साहब बोलते हैं मत दीजिए गिर जाएगा। और चीजें बड़ी जरूरी। गिरेगा कहाँ से? एक तो पिए बोलने वाला है ना। तो वही अच्छा बनता है। तो आपको तो ये कॉल करते हैं। हेलो। हेलो। स्पीकर और माइक्रोफोन सारा म्यूट हो। अच्छा इसको हटाना है।
ठीक है very much
हाँ हाँ बोला क्लियर हाँ है जी क्या है जी क्यों आ रहा है कुछ वॉइस की वजह से उस पर वॉइस ज्यादा है ना स्पीकर होगा मैक्स से जो वॉइस ज्यादा है ना शायद ही सही जा रहा है साथ वॉइस की पे मत डालिएगा की प्रेस होने लगे मैं की पता नहीं चलिए डालना ठीक दे रहा है सर ठीक जा रहा है मैं ठीक तो जा रहा है इसका, फिक्स हो गया। नहीं फिक्स हो गया, देखिए ना। इसको तो फिक्स है।
एक इसमें कनेक्ट किए हैं, कनेक्टेड किसमें है?
MS3 में ना
लिंक
ठीक है, अपना आईडी है सर का। गूगल में जाइए आप। माइक ऑफ कर लो।
मोबाइल में तो म्यूट ही जा रहा है।
लेकिन आपकी स्टे था, देखिए अभी ठीक है। फिर स्टे हो गया क्या? स्टे हो जा रहा है लेकिन। हम लोग बंद कर दिया जाए क्या वाईफाई इसका?
इसको चेंज नहीं कर सकते हैं,
हम्म,
चेंज नहीं कर सकते, पासवर्ड चाहिए।
पासवर्ड किसका?
सर वाला सेटिंग में डालेंगे तो होगा, लेकिन
रुक जा रहा है इनका वाला, मेरे देखा है।
पासवर्ड चाहिए।
कंप्यूटर का चाहिए।
हाँ,
ये ना सेट करके सेट इज लिमिट, जिसमें डाटा कंज्यूम कम खाता है।
उसमें
जैसे कि वाईफाई में एक सेटिंग होता है यहाँ पे, ठीक है, प्रॉपर्टीज में जाके एक लिमिट, जैसे कि डाटा कंज्यूम कम खाता है।
आगे छोटे छोटे यार शेयरिंग करेंगे।
शेयरिंग करेंगे तो वो तो मुश्किल है। सही है ये। क्या
चारों तरफ हो खुशियों की लहर, चारों तरफ हो खुशियों की लहर, हर तरफ चलता गुणगान रहे, बरसे असीम अनुकंपा ईश्वर की, आपके होठों पे सदा मुस्कान रहे। आदर, अभिनंदन, आभार। नमस्कार, आदाब, सत श्री अकाल, जोहार, hello and a very good morning ladies and gentlemen. A very warm welcome to this absolutely wonderful, beautiful, auspicious day that bring together too many special people like you. I am Suraj Kumar, Technical Officer of this institute, and today I have the pleasure of being your host with this stage. Ladies and gentlemen, आप सभी को बताना चाहूंगा कि मुख्य अतिथि महोदय का आगमन अब हमारे बीच हो चुका है। मैं अपने संस्थान के निदेशक महोदय प्रोफेसर अरविंद कुमार मिश्रा सर, डॉक्टर पीके बनर्जी सर, श्री जेके सिंह सर, डॉक्टर जेके पांडे सर से निवेदन करता हूं कि मुख्य अतिथि को मंच तक लेकर आएं तथा मंच पर आसन ग्रहण करें। Thank you very much, sir. Hearty welcome to all the dignitaries, guests present in the auditorium, especially today's chief guest, Dr. Kishore Srinivasan, Head CSIR Unit for Research and Development of Information Product, Pune, our Director, sir, scientists, officers, staff, and project assistant of this institute, students and professors from different colleges and universities from different parts of India, members of Simfer family connected with us via the web, friends from press and media, a warm welcome to all on National Intellectual Property Festival. दोस्तों, जैसा कि आप सभी को ज्ञात है, आज CSIR केंद्रीय खनन एवं ईंधन अनुसंधान संस्थान राष्ट्रीय बौद्धिक संपदा महोत्सव हेतु एक दिवसीय कार्यशाला जिसका शीर्षक इंटेलेक्चुअल प्रॉपर्टी मैनेजमेंट, जनरेशन, प्रोटेक्शन एंड कॉमर्शियलाइजेशन, बौद्धिक संपदा प्रबंधन, सृजन, संरक्षण एवं वाणिज्यीकरण का आयोजन कर रहा है। यह कार्यशाला नवाचार हेतु विचारों का पोषण करेगा, जिससे आत्मनिर्भर भारत और वैश्विक कल्याण के लिए भारतीय विज्ञान तथा प्रौद्योगिकी नवाचारों की भूमिका का एक झलक प्रस्तुत करेगा। नाउ I would request our director sir to please welcome the chief guest by presenting him with a bouquet. Sir, please. आप सभी से निवेदन है कि कृपया तालियों के साथ थैंक यू सर। देवियों और सज्जनों, इस कार्यशाला की शुरुआत भारतीय परंपरा के अनुसार हम दीप प्रज्वलन से करेंगे। मैं माननीय मुख्य अतिथि डॉक्टर किशोर श्रीनिवासन जी, हमारे निदेशक महोदय प्रोफेसर AK मिश्रा सर एवं अन्य मंचासीन विद्वजन से अनुरोध करता हूं कि दीप प्रज्वलन कर कार्यक्रम का शुभारंभ करें। दोस्तों, कहते हैं चलना है हमें अंधकार से प्रकाश की ओर, अज्ञान से ज्ञान की ओर, पृथ्वी से आकाश की ओर, पदार्थ से सूक्ष्म की ओर, प्राणी से परमात्मा की ओर। लैंप लाइटिंग के साथ एक शुभारंभ दीप प्रज्वलन हमारी संस्कृति का बहुत ही सुंदर हिस्सा है। नमन करते हैं परम पिता परमेश्वर को, उन्हें याद करते हैं, उन्हें मनाते हैं और शुरुआत करते हैं आज की खूबसूरत प्रभात के साथ। थैंक यू वेरी मच सर। आज के इस कार्यक्रम को आगे बढ़ाते हुए May I now request our director, Professor A.K. Misra sir, to welcome all the dignitaries and participants in this auspicious occasion. Sir, please.
थैंक यू सूरज। आप सभी को सुप्रभात एवं सप्रेम नमस्कार। मंचासीन हमारे मुख्य अतिथि डॉक्टर किशोर श्रीनिवासन, आउटस्टैंडिंग साइंटिस्ट एंड हेड CSIR यूनिट फॉर रिसर्च एंड डेवलपमेंट ऑफ इंफॉर्मेशन प्रोडक्ट्स उर्डीप, डॉक्टर JK सिंह, डॉक्टर PK बनर्जी, डॉक्टर JK पांडे, इस सभागार में उपस्थित हमारे अन्य अतिथिगण, डॉक्टर संजीव कुमार मजूमदार जी, सीनियर मैनेजर एंड हेड इंटेलेक्चुअल प्रॉपर्टी स्टार्टअप एंड इंक्यूबेशन डिवीजन, नेशनल रिसर्च डेवलपमेंट कॉर्पोरेशन, न्यू दिल्ली, डॉक्टर वीरेंद्र सिंह, सीनियर एग्जामिनर ऑफ ट्रेडमार्क्स एंड जियोग्राफिकल इंडिकेशंस, ट्रेडमार्क्स रजिस्ट्री, कोलकाता से आए हुए हैं, जो डॉक्टर शिवाकामी धुलप, पेटेंट एनालिस्ट साइंटिस्ट, CSIR यूनिट फॉर रिसर्च एंड डेवलपमेंट ऑफ इंफॉर्मेशन प्रोडक्ट्स उर्डिप से जो आई हुई हैं, डॉक्टर योगेश नाथजी ढोबले, IP स्पेशलिस्ट एंड क्वालिफाइड पेटेंट एजेंट, CSIR इनोवेशन प्रोटेक्शन यूनिट IPU न्यू दिल्ली से जो आए हुए हैं, और यहाँ पर उपस्थित सभी साइंटिस्ट, माय सीनियर्स, टेक्निकल ऑफिसर्स, टेक्निकल स्टाफ, स्टूडेंट्स, people from press and media, a very warm welcome and good morning to everyone. This indeed is one of the important day in the for CSIR and CSIR Simfer family. Reason being, we all are aware about Azadi Ka Amrit Mahotsav, which is going on, and we are passing through the Amrit Kal. And as part of the initiative of Azadi Ka Amrit Mahotsav, National Intellectual Property Festival, which is Rashtriya Baudhik Sampada Mahotsav, is being celebrated in the CSIR, entire CSIR family, under the aegis of Ministry of Culture, Government of India. And this started in the month of July, 1st of July, and is ending today on 31st of July. And we celebrated it across the nation. And this is the last function of this Rashtriya Baudhik Sampada Mahotsav, which we are celebrating here today. And this more so important, this workshop which has been organized on intellectual property management, generation, protection, and commercialization. This is very important. Reason being, I will give you one example. We were working on one of the technology. We developed the technology. This from my own personal experience. And then meanwhile, as you all are aware that we are, crazy about publications. So we had to go for the Q1 and Q2 publications. We did that. So not only one publication, we made 4 publications out of what we developed. And then by the end of work, we started filing IP. And for patent filing, when we went in, then we came to know that already it is in the public domain. It has been published. And so patent cannot be granted, neither it can be filed. So that was the reason, then later on, we realized that we did a big mistake. So probably at that point of time, we were not aware that if you go or if you have to go for patent filing, you need to be careful, you need to be cautious. So far as publications are concerned, and before getting on the publication, you need to go for the patent filing. So, you missed an opportunity. So that is how, with my own experience, I can tell you this is more so important, and it's sometimes a very important or very innovative project which you might have taken up, or a technology which you might have developed, but unfortunately it becomes difficult for you to go for patent filing because you are not aware of some of the prerequisites or pre-requirement. So that is the reason we need to understand what is the ecosystem which is existing in the country, what is the ecosystem existing in the global scenario. And so accordingly, we need to equip ourselves, we need to get educated, we need to have complete idea, complete picture, and then we should be accordingly moving on. As we all are aware, in the last, maybe 9-10 years, if you look up, our economy used to stand at $2 trillion in 2014. Right now, we are around $3.75 trillion economy, and which is poised to become $5 trillion by 27-28. And right now, we are the fifth largest economy, and we are poised to become third largest economy. And by 2075, it is expected the pace with which we are moving on probably will become the second largest economy in the country. And we all have seen from the past the developed economy, the first economy, second economy, third economy, which are existing right now, the kind of investment they have made in IP protection and the technological advancement. So the economy, if we look up to reach in at what we are expected, it becomes more so important for us to understand the ecosystem for IP or patent filing. So that is the background with which it is very, very important. And as CSIR family, it has been, the emphasis has been given to everyone to understand the ecosystem and then accordingly act on it. I, on behalf of the entire CSIR family, welcome here all the luminaries, including policymakers, technocrats, researchers, academicians, experts from the industry, scientists from various R&D organizations, distinguished guests, and dear students. Along with us, we have today Dr. Kishore Srinivasan, who is outstanding scientist and head CSIR, Unit for Research and Development of Information Products, URDIP, who on our request immediately agreed to come over here. And all the way he traveled in from Pune during monsoon season, traveling from Pune or Mumbai, really, I know how difficult it is. But we are very thankful to Dr. Kishore, who accepted our request and is with us right now. So we are very thankful to you, sir, for coming here, for the kind of support and love which you have shown to CSIR Simfer family. Thank you very much for visiting us and agreeing to be the chief guest of the function. Dr. Sanjeev Kumar Majumdar ji, who is Senior Manager and Head Intellectual Property, Startup and Incubation Division, NRDC. We are thankful to you as well. In spite of your busy schedule, you could, agree and you could come over here. In fact, we requested Mr. Amit Rastogi ji, CMD NRDC, but unfortunately, because of his preoccupation, he couldn't visit. But he has agreed that in the next program, he will be visiting us. Dr. Sanjeev ji has got vast expertise in managing the processing of patent application from filing to granting, liaison between inventors, institute, attorney, and patent office. We are very, very happy that Dr. Virendra Singh ji, who is Senior Examiner of Trademarks and GI Trademarks Registry, Kolkata, who agreed and who has visited us. from Kolkata. Very recently, he got transferred from Delhi to Kolkata and Kolkata to Dhanbad. I think it is his very first visit to Dhanbad, and he will be delivering on industrial properties like copyright and trademarks. So we welcome you and we are thankful to you. We have with us Dr. Sivakami Dulab, who is patent analyst scientist at CSIR Urdip, and who readily agreed to our request, and she has come all the way from far off distance, Pune. We are thankful to you, ma'am. Thanks for visiting us. And Dr. Yogesh Nathuji Doble, who is IP specialist and qualified patent agent, CSIR Innovation Production Unit, IPU, New Delhi, who came all the way from Delhi. We are thankful to you for visiting us, for agreeing to our request. And he will be delivering on patent filing and strategies, which will be an excellent addition to the event. Once again, on behalf of entire CSIR family, I extend my heartiest welcome to all our eminent speakers who have agreed and who are physically with us. I welcome all the people from present media who are covering this program, as well as our IT cell, who is, who has helped us in broadcasting it online. And I welcome all those participants who are connected online with us, all the scientists in charge of all regional centers, as well as the scientists and technical staff from the regional centers. Basically, this workshop, as I discussed previously, it aims to provide a platform to the industry, academia, and R&D organizations, scientists, researchers, and students to disseminate and deliberate on the various aspects of intellectual property, copyrights, trademarks, especially the generation, production, commercialization, and their management, which has become more so important in present context, in the domestic as well as international, because IP protection or the patent filing is one of the what we get in from after selling of our technology or technology transfer, whatever revenue we do get in, it is the first revenue which we can think of by getting the IP. So without IP, you are open and anybody can snatch away your hard work, your efforts. So it becomes more so important, which of late we have realized in the country, and there is an emphasis with which everybody, whatever idea, and small idea, even if very small idea, a creative idea, if you do have, immediately go for patenting of your idea so that nobody else can take it away from you, and then you try to come up with your product, process, or technology, whatever ultimately you come up. So with these words, I welcome you all, and I wish this one-day program, one-day workshop on intellectual property management, generation, production, and commercialization, a grand success. And I wish that all participants who are participating in the program will be participating it wholeheartedly, and the deliberations will be two-way, wherein if whatever doubts, whatever clarifications you do have, you can ask in to the speakers. They are the one who are the leaders in this field in the country. So getting them in Dhanbad was a difficult task, which we have accomplished. And with your interactions, with your dual interaction, two-way communication, it will become more so fruitful for every one of us. So with these words, I wish it a grand success. Thank you very much. Jai Hind.
Thank you very much, sir. राष्ट्रीय बौद्धिक संपदा महोत्सव पर मिनिस्ट्री ऑफ कल्चर गवर्नमेंट ऑफ इंडिया के द्वारा एक वीडियो प्रस्तुत किया गया है। मैं आईटी विभाग के कोऑर्डिनेटर से अनुरोध करूंगा कि वे हम सभी के बीच वीडियो प्रस्तुत करें। सर प्लीज।
भारत आदिकाल से ही जहां की धरा ज्ञान और तकनीक से समृद्ध रही है, इसीलिए तो भारत पूरे विश्व को सदियों से नया मार्ग दिखाता आया है। चाहे वो शून्य की खोज हो या चेहरे के पुनर्निर्माण के लिए प्रयोग में आ रही प्लास्टिक सर्जरी, वजन मापने की प्रणाली हो या कपास द्वारा प्राकृतिक रेशे की खेती, भारतीय ज्ञान का लोहा सभी मानते हैं। भारत हमेशा से अपने ज्ञान और टेक्नोलॉजी की विरासत की अमूल्य संपदा को आगे ले जाता रहा है। तभी तो मन और शरीर को जोड़ने वाला योग आज भारतीय संस्कृति की पहचान बन वसुधैव कुटुंबकम की भावना। जब पूरा विश्व कोविड जैसी महामारी का सामना कर रहा था, तब भारत ने वैक्सीन मैत्री से समाज और दुनिया को उम्मीद की किरण दिखाई। कई वैश्विक चुनौतियों का हल भारतीय नवाचार और अनुसंधान से मिला है। आइए 1 जुलाई से 31 जुलाई तक होने वाले आईपी महोत्सव में शामिल होकर अद्भुत पहचान द्वारा भारत को अमृतकाल में ज्ञान का विश्व गुरु बनाने का संकल्प लेते हैं। क्रिएटिव इंडिया और इनोवेटिव इंडिया द्वारा भारतीय कल्चर और साइंस को नई ऊंचाई पर ले जाने का दृढ़ निश्चय करते हैं और एक बार फिर से दुनिया को भारतीय टेक्नोलॉजी और इनोवेशन सॉल्यूशन से ग्लोबल चैलेंजेस का हल देते हैं। साथ ही आत्मनिर्भर होकर जो भारत का अपना है, उस पर भारतीयता का गर्व लेते हैं। आत्मनिर्भरता के लिए इंटेलेक्चुअल प्रॉपर्टी वो चाबी है जिससे टेक्नोलॉजी और नॉलेज आधारित अर्थव्यवस्था का निर्माण करने के लिए पिछले 9 वर्षों में प्रधानमंत्री श्री नरेंद्र मोदी जी के कुशल और दूरदर्शी नेतृत्व में भारत हर क्षेत्र में नए कीर्तिमान स्थापित करता हुआ अमृतकाल की यात्रा पर चल पड़ा है।
हमारी विरासत के प्रति, क्योंकि यही विरासत है जिसने कभी भारत को स्वर्णिम काल दिया, और यही विरासत है जो समय को बिल्कुल परिवर्तन करने की आदत रखी। यही विरासत है जो काल बाह्य छोड़ती रही है, नित्य नूतन स्वीकारती रही है। और इसलिए इस विरासत के प्रति हमें गर्व होना चाहिए।
ये महोत्सव अमृतकाल की इस गौरवशाली यात्रा में आपको इंटेलेक्चुअल प्रॉपर्टी की भारतीय पहचान को पुनः स्थापित करने का मौका दे रहा है। प्रधानमंत्री जी की ये हमेशा से सोच रही है कि टेक्नोलॉजी इंडिया ओरिएंटेड होनी चाहिए और हमारे सर्वोत्तम अनुसंधान और नवाचार का उपयोग आम नागरिक की समस्याओं के समाधान के लिए होना चाहिए। इंटेलेक्चुअल प्रॉपर्टी यानी बौद्धिक संपदा भारतीय विरासत है और इसी विरासत ने तो भारत को कभी स्वर्णिम काल दिया था और यही विरासत है जो समय के अनुकूल परिवर्तन करने की क्षमता रखती है। आत्मनिर्भरता को सक्षम करने में प्रधानमंत्री जी ने 5 प्राण का लक्ष्य दिया, पर इस लक्ष्य को हासिल करने के लिए भारत को वैश्विक व्यापार एवं विज्ञान के क्षेत्र में अपनी बौद्धिक संपदा का साथ लेकर नवाचार करना होगा। डिपार्टमेंट फॉर प्रमोशन ऑफ इंडस्ट्री एंड इंटरनल ट्रेड DPIIT और डिपार्टमेंट ऑफ साइंटिफिक एंड इंडस्ट्रियल रिसर्च DSIR द्वारा आयोजित 1 महीने तक चलने वाले आईपी महोत्सव में नए आइडियाज, इन्वेंशंस, ट्रेडिशंस और प्रैक्टिसेस का मूल्यांकन करते हुए नए आविष्कार के द्वारा बौद्धिक संपदा आधारित पेटेंट, GI, ट्रेडमार्क, डिजाइन, कॉपीराइट से आत्मनिर्भर होने के लिए ठोस नींव रखी जाएगी। भारत के वैज्ञानिकों, युवाओं और छात्रों की भागीदारी से 1 जुलाई से 31 जुलाई तक देश भर में कई स्थानों पर स्थानीय स्तर पर भी राष्ट्रीय बौद्धिक संपदा महोत्सव के आयोजन होंगे। इस महोत्सव के दौरान भारतीय अपनी बौद्धिक संपदा व्यवस्था को पहचाने और इससे सम्मान देने के लिए प्रेरित हों, ये सुनिश्चित किया जा रहा है। आइए भारतीय बौद्धिक संपदा की विरासत को आगे ले जाते हुए प्रधानमंत्री जी के दिए गए 5 प्राण के लक्ष्य को सिद्ध करें। अमृतकाल में एक नए विकसित भारत की ओर कदम बढ़ाते हुए अपनी बौद्धिक संपदा में हमारा अपना नाम जोड़ें और गर्व करें कि मेरी बौद्धिक संपदा मेरा अभिमान।
थैंक यू सर। अब मैं अपने संस्थान के उत्कृष्ट वैज्ञानिक डॉक्टर प्रदीप कुमार बनर्जी सर से अनुरोध करता हूं कि वो हम सभी को कार्यशाला के बारे में विस्तार से बताएं। सर प्लीज।
Dr. Kishore Srinivasan, chief guest of today's function, and also the outstanding scientist and head of Udip, Pune. Professor Arvind Kumar Misra, Director, CSR Simphar. Dr. J.K. Singh, Chief Scientist, Simphar. Dr. J.K. Pandey, Chief Scientist, Simphar. All our invited speakers, dignitaries, participants who are present in this auditorium and also present across India through online. Very good morning. On behalf of Simphar IP team and also on my personal behalf, I welcome you all to this one-day workshop on IP management, intellectual property management, generation protection, and commercializations. It's more like an awareness kind of program. In fact, it's worth mentioning at this point, one of our ex-director, you must have heard his name, he's also known as the patent man of India, Dr. R.A. Masilkar. Once he said that literacy drive is for illiterates, but patent literacy is for literates. Patent literacy drive for literates. Because IP, the name suggests IP, intellectual property. That means the property which you have generated through your intellectual capabilities, intellectual activities, from your innovative ideas, from your creative thinking. So you must also know how to manage it. And that's what the IP management is all about. It's not just generation, but after that, there are a lot of steps. In fact, the entire IP management has a very well-defined SOP, 10 steps. Before even generation of all these IPs, you have to start with background research, the opportunities, where you need to work. You identify those critical areas, start your working, research, development, innovations. Then you generate your intellectual property. It could be patents, it could be copyrights, could be a trademark or design. All this comes out from your intellectual activities. So once you generate this IP, you also need to know how to protect it, because it's a property, you have to protect it. It's an intangible property, you need to extra care to protect. If it is tangible, very easy. Intangible is very, very difficult to define, so the procedure is much more complex. So once you protect, you also need further to go ahead with its utilizations. You have to utilize the patent. You need to go for commercialization of patent. You have to earn revenue from it. There are multiple steps through which the entire process of patent is getting managed. So when we are designing this one-day program, we kept all those steps in mind. We wanted to take you through the entire journey from creation or generation to protection to commercializations. That's the way we designed our program today. We are really fortunate that we have Dr. Kishore Srinivasan with us. He will start the ball rolling with his keynote lecture, where he's going to talk on patents and IP value, the portfolio perspective. Very, very important topic to start with. Post this inaugurations, we have divided the whole day's program into two technical sessions. One is pre-lunch session and then another post-lunch. In the pre-lunch sessions, we have two lectures. We have Dr. Yogesh Doble, who is from CSIR IPU New Delhi. He is going to talk on patent filing and strategies. And then we have the next topic, which is patents and patent practices, the PAT informatics homework. This will be delivered by Dr. Sivakami Dhulab from CSIR Urdi Pune. And then post-lunch, we have two more lectures. We have Dr. Virender Singh, who is Senior Examiner of Trademarks and GI, Trademarks Registry, Kolkata. He is going to talk on industrial property IPR, its generation and protection. And then we have another interesting topic, very interesting topic, which is on the commercializations, that is NRDC in technology commercialization roles and strategies, which will be delivered by Dr. Sanjeeva Kumar Majumdar, who is from Senior Manager, NRDC, New Delhi. So you can see the whole design of this, starting from portfolio creations, background research, to filing, managing, protections, to commercializations. That's the way we designed. But we want to conclude in a meaningful way. Post the session in the evening, we want to come back again with all our speakers. We want to deliberate because there must be a clear deliverable at the end of the day. We must come out with a clear recommendations. What next? What we are going to do next? So we'll have a discussion with all of you. We'll capture your ideas during the whole day. It should be more interactive. Come up with ideas. We'll capture those ideas and we'll deliberate on that, and we'll find out what are the things we need to do next. How to capture more new ideas, how to generate more ideas, how to convert the ideas into patents or intellectual properties, and then, of course, how to manage it in terms of its protections and commercializations. The whole thing, we want a very clear kind of a roadmap or recommendation emerge from that panel discussion at the end of the day. So thank you once again for your participations. And once again, I welcome you. And I'm very confident. I'm very confident it will be very, very interesting learning experience for all of us. Thank you very much.
Thank you very much, sir. CSIR सूचना उत्पाद अनुसंधान एवं विकास यूनिट प्रमुख डॉक्टर किशोर श्रीनिवासन सर के मार्गदर्शन से बौद्धिक संपदा और तकनीकी वाणिज्यिक सूचना सेवा प्रदान करके अनुसंधान परियोजनाओं के पूर्व अनुसंधान और विकास को गति देने का मिसाल प्रस्तुत किया है। ऐसे तो हमारे मुख्य अतिथि विश्व भर में बौद्धिक संपदा में अपने काम के लिए परिचित हैं, फिर भी औपचारिकता हेतु अब मैं अपने संस्थान के मुख्य वैज्ञानिक श्री जेके सिंह सर से आग्रह करता हूं कि मुख्य अतिथि का संक्षिप्त परिचय हमारे बीच प्रस्तुत करें। सर।
Honorable Chief Guest of this function, respected Director CSIR SIMFER, Professor A.K. Mishra, outstanding scientist Dr. P.K. Banerjee, Dr. J.K. Pandey, Chief Scientist, participants in this program, and eminent invited speakers, colleagues of CSIR SIMFER, and friends. Good morning to all. I really feel privileged to provide brief biodata of the chief guest of this function. Dr. Kishore Srinivasan is presently head of CSIR Unit for Research and Development of Information Products, CSIR URDIP, Pune. After securing his doctoral degree in physics from Indian Institute of Technology, IIT Madras, and a brief stint as staff scientist at the Center for Materials for Electronics Technology, CMET, Dr. Srinivasan worked as a postdoctoral research associate at the Pennsylvania State University, the University of California, San Diego, and the University of Nebraska, Lincoln in the United States on diverse aspects of nanoscale materials, physics, and energy storage. Subsequent to his postdoctoral tenures, he joined General Electric Global Research Center, Bangalore, as lead intellectual property IP specialist, driving patent analytics and patent informatics programs across key advanced technology platforms in GE, wherein he acquired frontline training in diverse streams of patent analytics. Subsequently, he moved on to the Global Institute of Intellectual Property, GIIP, Bangalore, as program director, framing and driving both in-house IP training sessions for entry-level patent analysts and patent engineers, and customized external IP training programs for corporate and industry IP professionals and practitioners. Further, from 2013 to 18, he held office as Head Intellectual Property Thermax Limited, Pune, driving their intellectual property function and activities across technology and business verticals. Dr. Srinivasan took over as head CSIR URDIP in April 2018. Dr. Srinivasan holds a patent information specialist certification from WON, Netherlands, and has acquired training in United States patent practice from the Patent Resources Group, Virginia, USA. Further, he has to his credit a Master of Law, LLM, degree in Innovation, Technology and Law from the University of Edinburgh, UK, and a certificate in Intellectual Asset Management from the Chicago Kent College of Law, Illinois University of Technology, United States. He has peer-reviewed research publication to his credit and is a recipient of numerous awards, including the G Management Award for Outstanding IP Analytics, Landscaping, and Technology Road Mapping activities for various advanced technology programs across GE, the Inventor Incentives Award instituted by the Penn State Research Foundation for fundamental and applied research on nanoparticles, hydrogen storage materials, and the Voicecast National Research Fellowship awarded by the Department of Science and Technology, DST, Government of India, to young scientists. Thank you.
थैंक यू सर। महोदय, हमारे लिए यह परम सौभाग्य की बात है कि आप जैसे प्रख्यात संरचनात्मक और बहुमुखी प्रतिभा के धनी व्यक्तित्व का मार्गदर्शन आज हम सबको प्राप्त होगा। महोदय, आपसे आग्रहपूर्वक निवेदन है कि आप अपने आशीर्वचनों से हमें आलोकित करें। सर प्लीज।
Thank you very much for the kind introduction. Good morning to you all. The Director, CSIR Simfer, Professor Arvind Mishra, dignitaries, Sri Sanjeev Majumdar, NRDC, Delhi, Dr. Virendra Singh, TKDL, sorry, beg your pardon, Trademarks Registry, Kolkata, scientists, faculty, colleagues present in the audience, as well as connected online across CSIR, and dear friends. At the outset, it's my pleasure, privilege, and honor to be here, to be associated with this very important, momentous, and memorable occasion when Simfer Dhanbad seeks to celebrate the National Intellectual Property Festival, Bauddhik Sampada Mahotsav, under the aegis of Azadi Ka Amrit Mahotsav. There cannot be a more appropriate time for CSIR and the country to really undergo a very important learnings in the field of intellectual property when India, by and large, is positioned or strives to position itself as one of the growing and fast spiraling economies in the globe today. Intellectual property, as you are all aware, is one of the most potential currencies in a knowledge-driven economy. And the impact of IP is more felt, more as a driver of new technologies, new markets, and as a potential instrument that seeks to drive market power across the globe, as well as a potential maker of brands, as far as any organization is concerned. In my talk today, which is broadly along the following lines, I would like to first give you a session outline as what I plan to cover as part of my guest lecture for the next 1 hour. Understanding the attention span of the audience, as well as the varying levels of preparation across the board, I would go through a variety of topics. I would start off from a broad overview of certain specific fundamentals that are required. I would leave the detailed coverage of several aspects to the experts here. I would, after defining the various the various types of IP, I would now go for a contrast, or I would also seek to bring before you a contrast distinction between publications and patents. Then we take a sneak peek at history and see how patents have been then and what patents are now today. Who are and what are the potential sources of IP? Who are the potential stakeholders of new IP that's being created? And then we go over to what are the thoughts and reflections for India, which seeks to leverage the potential of IP to position itself as one of the fast-growing economies in a knowledge-driven economy among the Committee of Nations. Why are patents important? How do patents attain the pride of privilege and importance that they have in the present times? What is patent value? Why is patent value going to be a very critical entity that's going to be deliberated so widely across the globe? And what is the need for India to be positioned itself on the value map when it comes to intellectual property precepts, practices, and precedents? What are the ready reckoners at hand when it comes to understanding and appreciating or assimilating the diverse nuances of patent value? Then I take to the core forte of what CSIR URDIP does. As most of you are aware, CSIR URDIP is one of the specialized services units of CSIR located in Pune, and we cater to patent informatics activities, diverse streams of pre-research and pre-development activities. There are different streams of analysis and informatics services to laboratories, starting right from the pre-research stage all the way to the pre-development and the pre-filing stage, and even going forward to intellectual property commercialization and valorization. We look at what are patent landscapes, patent maps, that there is a core forte of CSIR URDIP. Then I try to tell you taking the patent informatics homework forward. How does CSIR already position itself as a due diligence agency, trying to articulate strategies for filing and creation of valuable IP for CSIR? To just kind of a broad overview, I upfront start off giving you the different types of IP. I would leave specialized coverages to the experts, as I already told you. I'm sure most of you are aware, faculty and students are aware about what is IP, what are the various types of IP protection. IP is a negative, exclusive, and exclusionary statutory right on any invention that is granted to an inventor or an applicant by the state or the government in return for disclosure of the invention. IP exists in almost everything that you do every day. What are the sources of IP that you are familiar with? The notes that you prepare, the drawings that you make, the experimental arrangements and designs that you make, the computer programs, software, and the codes that you write, the manuals that you prepare, the music that you hear, the mobile phones and caller tunes that you use, and the inventions that arise from your activities in your laboratories and classrooms. The list is endless. However, you should all remember that the various schemes of intellectual property protection shown here differ in their scopes of protection. You all should be aware what are trademarks, what are copyrights, what are designs, what are geographical indications. All of these schemes of IP protection, they protect expressions of ideas. Why is a patent and how is a patent different from the difference by virtue of the scheme of protection it offers? Patents protect not just the expression of ideas, they protect inventions that are based on the ideas themselves. In other words, they protect operative ideas that are broader, stronger, and more functional in their scope of protection. So what is the advantage? By virtue of functional protection embodied in the claims in a granted patent, the invention becomes very resistant to duplication, replication, copying, etc., etc. By virtue of this protection and the enforceability it offers, the patent gives you, or patents give you rather, a proprietariness in a competitive product market. They protect USPs or specific components that go into devices that are going to rule the market next several years down the road. That's the reason why we say that patents offer not isolated value, but they expound a value pipeline or a runway for you from an organizational perspective, from an enforcement perspective. And they also give you the potential to drive market power. They protect strategies and they unfold new business directions for organizations. So that tells you again, or rather that explains why patents are expensive to create and maintain. And they are even more costly to infringe. Within a few slides, we will see what are the different dimensions of IP value. Why is it that patents are expensive to create and maintain? What does patent infringement entail? What are the potential damages and liabilities that can accrue to you as an organization or an entity if you willfully or inadvertently strive to violate or infringe somebody else's patent? So no discussion of IP is complete without going through all of these nuances. Now let's get into other definitions and related statutory aspects concerning patents. As I told you, I'm just going through this in a very broad manner to give you an overall awareness as to what patents are. As I already told you, they're granted by a state, inventor, applicant, or entity. But what is contingent on that? There is whatever rights that you get are contingent on the disclosure of invention. They are in exchange for public disclosure of an invention. And what is an invention per se? An invention can be any new and useful process, a product, a machine, an article of manufacture, or a composition of matter, or any new and useful improvement thereof. All of these come under of these are what constitute claim elements, or elements that are protected by the metes and bounds of the claims in the specification of any patent application or a granted patent document. From the overall preamble, it's very clear upfront, as a title statement on the slide shows, patents constitute a negative, exclusive, exclusionary, and territorial as far as the rights are concerned, and they are time-bound rights. What do you mean by negative rights? Patents exclude others, give you the right to exclude others from making, using, or reproducing your claimed invention for which you have been granted the right, exclusive rights. These rights are exclusive to the extent that the rights specifically accrue to you. You means the inventors in the patent application or the applicants or the assignees who own the patent. Exclusionary, again, is tied into the definition of negative. When you say it's a negative right, you exclude. Exclusionary clearly tells you that you are excluding others from making and using the claimed invention. Another important dimension, important point is patents are territorial rights. You do not have a world patent. You have international applications, but they are prosecuted territorially and they entail patent grants in the respective countries or the jurisdictions. All the same, with a note of caution, you need to know that a patent per se doesn't bestow you with the right to practice or use the invention per se. What is the origin of the name? Patent stems from a Latin name, noun pater, means laying open for public inspection, disclosure. That again underscores that the very act of disclosing the details and the specification of an invention in the public domain is what is a very important and necessary prerequisite for the grant of a patent to an inventor or an applicant. Now let's go to more other statutory dimensions of patents. Patent rights are valuable and enforceable for 20 years from the earliest filing date of the priority date, the first ever date when an application for the invention or a related increment has been filed. Patents can be sold, licensed, mortgaged, they can be assigned, transferred, or even abandoned. They are territorial rights, as I already mentioned. The procedures for granting patents, the requirements and expectations from the patentee who has been granted the patent, the extent of exclusive rights that are accorded to an applicant or the inventors by virtue of grant of their patents. All of these vary from country to country, territory to territory, jurisdiction. And these are governed by the territorial patent laws, national patent laws, which are prevalent in the respective countries, as well as international agreements and covenants. So this is this is an ocean in itself, and I do not strive to go into these details much because this will be dwelt at length and in substantial detail by the experts who are going to be speaking to you throughout the day today. But the most important thing that you need to remember is whatever that you get your rights for, whatever that your invention is protected for, please remember that patent rights are granted only for patentable subject matter. Whatever inventions that you file, that you seek to protect through your patent should fall under the gamut, or they should fall under the domain of what you call patentable subject matter, or they should qualify the statutory substantive criteria for patentability of inventions that articulate specific laws, premises, rules, guidelines, which would judge your invention for the worthiness of the grant of a patent. That again tells you that we have got subject matter which falls under non-patentable subject matter. Not everything that you think is patentable can be patentable. You have got abstract entities, laws of nature, naturally occurring substances, phenomena, mental acts. They are not patentable under any law in any country. Some countries, including India, they offer restricted or selective patent eligibility for software and business methods. There are various statutory premises and disclaimers which are attached to what kinds, when does software deserve to be protected by a patent document, by a patent. Now let's go on to yet another very important topic that needs to be discussed, especially in the context of CSAR. When confusions and a lot of misplaced priorities are in place when it comes to judging publications and patent documents. I have often witnessed tendencies to substitute patents for research publications and vice versa. The National Intellectual Property Festival and a very momentous forum like this, opened up by CSAR SIMFER for awareness building in the field of IP, should primarily start off with understanding how patents are distinct from publications. This slide gives you a snapshot of the front page, snapshots of the front page of a research publication and a granted patent document. What are the differences? This table column or the next couple of slides, it summarizes the various specific points that occur to me when it comes to building awareness about what are publications versus what are patents. Publications are non-legal documents. They are technical in nature. They are academic. They have research and technical impact or implication. They have a technical value proposition by virtue of the results they disclose, the interpretations they offer, and the conclusions they draw, which are critical, which are quintessential to advancing the body of knowledge in a specific area of science and technology. But what are patents? They are legal documents. They are techno-legal in character, in purport, and impact. And they have a techno-commercial value proposition by virtue of their techno-legal enforceability. They are intangible assets. They have intangible asset value. That is something which doesn't accrue necessarily to publications. They are protected. They are bound by time-bound rights. Our specific products, devices, or even processes that are sought to be protected through the claim elements in the respective documents. Publications are written in academic or research parlance. They have research and they have ample wealth of research and experimental data. They talk about analysis, they talk about interpretations, they talk about conclusions with academic and technical purport. But they have no legal binding. They don't have proprietary rights attached to them or associated with them, and they don't have durations of validity. They just serve as prior art. They are prior art documents, and they are prior art by their own might and right. But patents are written in precise, structured, techno-legal language. Semantics are distinctly different in patents versus publications. They have precise technology and invention embodiment data, enabling and supporting structured, legally binding articulation of the proprietary rights which are embodied in the claims of a patent document. For research publications, we talk about authors, affiliations. But in granted patents, we talk about inventors and assignees. Publications are read for their scientific data, experimental data, phenomena, interpretations, insights. But patents are read for their techno-legal impact and purport. Reading patents is a totally different domain. It's a science and an art by itself, an art and science by itself. You need to train yourself to read a patent document. A subject matter expert in a specific area need not necessarily be competent to understand what a patent document claims and discloses. And it contains, it's actually a legal instrument by itself that defines precise bounds of proprietary rights for the inventions which are being disclosed in the patent document. Now, if you look at a few morphological aspects from the morphology perspective, as far as patents and publications are concerned, for publications, you have publication titles, abstract, introduction, experimental details, results, and discussions. You take them to conclusions. That's about that morphology. But when it comes to patents, you have a patent title, you have prior publication data, you have various dates, codes, and fields on a patent document. All of these are particularly important because they become part of the metadata that is associated with a patent document, as we would see very soon in a couple of slides. And the main written matter of the specification in a patent document concludes with what you call as the claims of the patent specification, which have techno-legal binding. The claims are the legally sensitive part of a patent document. And a patent becomes a techno-legal instrument by virtue of the claims which are positioned towards the end of the specification in a patent document. A patent document talks about multiple dates. You've got a priority date, you've got a filing date, you've got publication dates and grant dates. All of these dates are important because they decide the validity, the statutory validity, and the tenure of enforcement as far as a patent is concerned. There is nothing like enforcement for a research publication. The grant date denotes what? What does it denote? It denotes the date as of which the patent document becomes a legally enforceable asset and an instrument. Patents are prosecuted. They are granted, and the patent document contains metadata, codes, fields pointing to technical and IP data in the document. But none of these are there in a research publication. When you say metadata, what do you mean? The next slide shows you what is it that I have been trying to tell you. We are now taking, I'm just taking you back to a sneak peek into history when I'm trying to tell you what and how patent documents were 3 centuries ago and how they are today. The image on the left is that of the first ever United States patent that was granted exactly on this day, 31st of July, 1790. As we stand on 31st of July today, on 2023, the right-hand column shows you how a patent document appears today. A patent document that was granted, this is the first ever patent, US patent that was actually granted to Samuel Hopkins for his invention on a method to prepare potash, which is an essential ingredient of fertilizers. The patent was granted to him on 31st of July, 1790. And you see the front page of the patent document. It's plain running text. But it was signed by none other than George Washington, the first president of the United States. 3 centuries down the road, we stand on 2023, 31st of July today. You can see how a patent document appears on the right. We have a host of codes, fields, titles, dates, etc., all of them. You see the evolution in the morphology of a patent. This evolution in morphology is one of the factors which is tied to the realization of patent value, as you will soon understand. That gives you a host of metadata that you have, based on which you can pull up and bring up patent documents to contextualize your search and analysis efforts as part of unearthing and capturing patents that are going to be material with reference to a specific invention for which you strive to protect through the grant of a patent. Now, coming to certain other digressions on this, no discussion on intellectual property and patents would be complete if we don't say what are the sources of IP and who are the potential stakeholders of intellectual property. Inventions, research publications, thesis, dissertations, reports, presentations, classroom teaching materials, equipment, IC designs, confidential information, all of these are sources of IP. It's endless. Whatever you create is your IP. You have the copy. You automatically become the de facto copyright owner of the works that you create. However small it is, however trivial it is. And once a patent or any IP instrument is granted, we have a host of stakeholders here: students, researchers, staff, employees, scientists like you, faculty, collaborators, sponsors, funding agencies, universities, research laboratories, the government, industry, corporate sectors, patent offices. The list is endless because it's a granted techno-legal instrument. Why is this realization important to us? It's important because as much as the sources are diverse, the stakeholders are also diverse when it comes to every single granted patent. And that tells you who are all the stakeholders of patent value. Whatever patents that you create, if you have value attached to them, you benefit not yourself as an inventor or an applicant, but you benefit a host of stakeholders who are your stakeholders with you when it comes to realization of patent value. Now let's go to the present context. We are celebrating the National Intellectual Property Festival. There cannot be a more appropriate forum. Is intellectual property important to India now? What are the India-centric thoughts which have often reflected back and forth into my mind as I thought about the ambitious and competent efforts of India to position itself on the global IP ecosystem and also as one of the most potential, fast-growing, fast-spiraling economies in the world today, ambitiously leveraging the potentials of a knowledge-driven economy. Admittedly, as I told you earlier, IP is the currency of a knowledge-driven economy. The primary motivation and exhortation of this impetus on IP in India is to tap the innovative, energetic, and creative young minds of our country to drive positive, game-changing, and disruptive trends and paradigms in science, technology, and innovation to bring about sea changes, fundamental changes in the science, technology, and innovation ecosystem of our country. What for? That is to ensure a sustainable future for the generations to come. This will essentially entail creation of new technologies. Once there is a focus on creation of valuable IP in our march towards Atmanirbhar Bharat, they would entail creation of new technologies, new markets, new business models, new benchmarks, new industry standards, and new scorecards, bringing in new intangible intellectual assets to the country. Further, this context also envisions an opportunity for young scientists who are budding inventors, technologists of India to find out how IP rights can support their goals, help transform their ideas into reality, generate income, create jobs, and make a positive, sustainable impact on the world around them and its economy. In any knowledge-driving economy, science, technology, and innovation are the engines of economic growth and prosperity. Let us, as scientists, not forget this ultimate reality and truth. As a scorecard of technology and innovation, IP forms an intangible asset for any organization or company and has economic value, techno-economic value proposition attached to it. The value of IP, as I already mentioned, lies in its techno-legal instrumentality and the attendant techno-legal enforceability. That is again draws its strengths from its techno-commercial potential. So that quickly tells you that it is synergistic in approach. IP is not a domain by itself that needs to be practiced in isolation. It is a domain which receives transdisciplinary contributions from best practices in diverse domains. The need of the hour, while we are celebrating National IP Festival, is to instill and nurture in young minds of young scientists and technologists in this country, an awareness in IP, its fundamentals, its implications, its value proposition, and the means to realize, protect, and value IP, not as an isolated instrument, but through a series of stages. That's what we call, from any organizational perspective, the IP value life cycle. When you talk about IP value life cycle, it comes all the way, right from filing, IP capture, creation of IP, protection of IP, culminating in what you call as commercialization of IP or valorization of IP within the statutory frameworks, regulations, and laws prevailing in India. When we talk about India and its ambitious positioning on the IP map of the world, and also as one of the fast spiraling economies in the world, I just had a few reflections, India Reflections 2022. How has India done over the last 1 year as far as IP is concerned? It's indeed promising. This slide shows you a few quick statistics and numbers on the recent patent filings in India during the last quarter of the last financial year. The data for this financial year are yet to come. They are under preparation by the Indian Patent Office. The trends and information presented are adapted from multiple sources, of course, the Indian Patent Office, and also presented by PIB, Economic Times, Economic Survey, etc., etc. As evident from the data here, out of the total 19,796 Indian patent filings during January to March 2022, it's a very significant and promising development for India that Indian applicants have topped the number of filings. There have been more numbers of filings by Indian applicants, amounting to almost 10,706, which is 54% of the total filings. And they significantly exceed the number of filings in India by non-resident applicants who are staying outside India, which is only 9,090. And again, remember, this is a development for the first time in the past 11 years. Further, there has been a 50% increase in the number of patent grants. Patent filings from 42,763. If you talk about applications being filed, if you consider the 2014-15 figure, it comes to 42,763. And we have a whopping 66,440 during 2021-22. And there have been a five-fold increase in patent grants from almost 5,974 during 2014-15 to almost 30,074 during 2021-22. Further, what is even more promising is that the average patent examination timelines have come down in the Indian Patent Office. They seem to have decreased to almost 5 to 23 months, as against the earlier durations, long, winding durations of almost 72 months. What do all of these go to tell us? We just mentioned a short while ago that intellectual property is a currency of any knowledge-driven economy. These are the figures that would propel and catalyze the competent positioning of India as one of the most ambitious and fast-growing economies in the world for tomorrow. How do we know that? It is evident from the Global Innovation Index, where India's rank on the Global Innovation Index. India's ranking in the Global Innovation Index has ramped up, has ended from a figure of 81 in 2015-16 to 40 in 2023. Still a long way to go, but really the way to go. These indications are all tremendously, they are all significantly positive. And why? What are these due to primarily? They are primarily attributed to the very significant initiatives which have been taken by the government of India to popularize IP and enhance IP filings among scientists, young scientists, technologists, in academia, research, industries, and even more among startups and small entities. You're all aware that patent filing fees for educational institutions and small entities have been reduced by almost 80% by the government of India. And there have been a reduction of about 10% in trademark filing fees for online filing as against physical filing. In addition, the strong and concerted IP awareness programs which are launched by the government of India in schools, colleges, and universities across the country, as well as for MSMEs and small businessmen, traditional artisans and craftsmen through various channels, including the Atal Tinkering Labs across the country. There's imparted more awareness and insights to these sections of the population on IP creation, ownership, and protection, as well as the potential value proposition that all of these streams of IP protection offer, the potential to generate revenue through diverse streams of monetization. However, all of these numbers and figures being highly promising, one should remember a very important point in the present times. While numbers are important, it is as rightfully explained by our Honorable Prime Minister during the recent CSIR Society meeting, it is imminent for CSIR. It is imperative at this present point in time for CSIR and the IP creation of the academic and research ecosystems in the country to focus on high quality filings. Patent quality and patent value are the most important primary reckoners of any IP activity as far as India is concerned going forward, for the plain reason that IP value is the one that is going to give India the strength that it needs for its competent positioning over the times to come. When you talk about patent quality, what is required? It is required that you have to improve the quality of patents which stem from the quality of the inventions which are being created by you, the inventors, which are amenable to patent protection. More important, it is all about what is the quality of the claims that you draft and create when it comes to filing your patent, when it comes to writing up your specification in preparation for a patent filing. This slide primarily talks about what is the importance of patents. Okay, I mean, what is the criticality, or what are the important dimensions when it comes to the analysis and the reading and analysis of patents? Or in plain terms, why do we read patents? Why is it important for us to understand patents? Reading and analyzing patents gives us a host of information to sample from, gives us data, large, vast expanses of data to sample from when it comes to diverse streams of analysis. It helps us with legal and IP risk assessments. It helps us understand our competitors or people who are active in the same area as much as we are active in. It helps you with information and insights on what could be potential new technology directions, which could be protected by competent IP, valuable IP, which could in turn prove itself to be a technology driver going forward. And how do these translate into market or business drivers for any organization? My colleague, who is going to be talking today afternoon about patent informatics, would be dwelling at length and in depth about the various aspects of reading patents and in emphasizing and highlighting the criticality of reading and analyzing patents in the context of our efforts to create new and valuable IP. A few more data and figures to give you insights into why and how a patent is valuable. When we say that patent is a techno-legal document, why do we say that it is valuable? There is a value proposition attached to it. Going by estimates, as late as as last as in 2015, patents and IP and intangible assets have amounted to be global capital contributors, generating contributions to a tune of $5 trillion, which clearly tells you what IP is worth and what is the potential value proposition of patents, or for that matter, any intangible asset of any organization. If you think of any technologically active company, a frontline technology company, you can envision a company, the big names that you've heard of. 87 to 90% of the overall company value of any technology company is ascribed to the intangible value stemming from patents and other streams of intellectual property. 50 to 55% of global enterprise value is also one of the potential contributions of patents. And this is even more for technology-oriented companies and startups. Patents are a significant source of revenue. There is a separate stream of evaluation called IP evaluation that uses different approaches to value patents that protect inventions coming under different streams. You can have cost-based approaches, market-based approaches, and income approaches to value patents. And end of the day, if you talk about an invention or a technology that you strive to showcase, the value proposition stems from two important dimensions. One is the value of the invention per se, and the value that is ascribed by virtue of its being protected by a patent document. That is the overall value as far as a patent or an invention is concerned. In addition to these, you should also remember that patents give you several other significant advantages and mileages on various dimensions. It offers protections to technologies, and it is a big deterrent to competitors. Patents function as technology and innovation drivers. They are scorecards for technology and innovation. They are competent market and business drivers. They are a growth index, and they give companies and institutions and entities prime mover advantage. If you want to enter a new market, if you have potential patents that protect similar inventions, You as an inventor and your company as an entity will drive the market power in the specific technology domain. That's what you call as prime mover advantage. Patents are a big tool in giving you prime mover advantage. Then, last but never the least, patents confer global thought leadership on you, regardless of whether you're an individual, a company, an entity, small or big. It gives you means to benchmark your creations versus the creations of or even related or similar creations by the rest of the world. It gives you branding, it gives you reputation, it attracts licensing opportunities. But all the same, the last line still gives you a note of caution. I begin taking you back to a few slides back where I said patents are expensive to create, they are equally expensive to maintain, but they are very costly to infringe. No discussion on IP is complete without this slide. When you talk about IP value, you should also understand value in terms of liabilities. IP has the power to make and break companies. Why do we say this? For the past several years, intellectual property, the very word intellectual property, in several circles, has often been associated with high-profile patent wars and litigations that ran the mills for several years, hogging the limelight worldwide. Why have they attracted so much of media attention? These are on account of purported infringements or violations of the IP of one company by the other, entailing huge amounts as penalties, damages, and so on and so forth. And these have been due to companies and corporates by and large. Therefore, we should admittedly realize that intellectual property till the other day, a few years or maybe at the most a decade ago, has been the prime forte of companies and corporates. Very recently, the value proposition has sunk into different circles, academia, R&D, and so on and so forth. We have also various scenarios of patent and IP sales and acquisitions between companies involving huge amounts paid and received by them. Therefore, it is very important that we realize before we try to protect something, start a line of R&D activity, you try to file a patent application for a piece of invention, or you try to launch any of your products in the market, be aware that of the overlapping activities which have been done by your peers, by third party, by your competitors, and ensure that you steer clear of the potential danger zones or the erroneous zones. This slide gives you some snapshots of some leading companies in the world, big players in the world, who were either involved in protracted legal battles and litigation proceedings in courtrooms over IP infringements, or were involved in hefty financial transactions or payouts in lieu of their IP assets, attracting media attention all over the world. Most of you might be aware, at least some of you might be aware, of the very high-profile epic patent wars that rocked the IP horizon worldwide was a long-running 14.5-year battle between Eastman Kodak and Polaroid that started off in 1976 and was settled only in 1991, with Kodak eventually paying up a hefty amount of $925 million as damages to Polaroid, inclusive of interest. This is the largest settlement, penalties and damages settlement that has ever happened in the IP firmament today. What was the reason for this? Polaroid accused Eastman Kodak of having infringed into their digital photography patents. As a result, what did Kodak have to do? Eastman Kodak recalled the entire generation of instant photographic cameras sold to customers between 1976 and 1986. They had to recall from the market, handling out appropriate compensation and damages to the impacted customers. This is one of the worst scenarios that has ever happened, which is a very grim reminder of how costly it can be for someone to infringe somebody else's patent. In 2013, eventually, the saga was still not over. Kodak ended up selling off almost 1,100 of its digital photography patents to its licensees such as Apple, Microsoft, Google, etc., for almost $525 million US. Another recent blockbuster patent litigation, which most of you are aware, would be the 7 years of winding allegation and protracted patent war between Apple and Samsung that rocked the IP world. The litigation started off in 2011 with winding and allegations and counter allegations between Apple and Samsung on various aspects of infringements of Apple's seminal patents on the smartphone by Samsung. Ultimately, the litigations ended up in the apex court of the United States, and Apple was awarded damages from Samsung to the tune of $539 million US over its allegations of patent infringements against Samsung. Such cases have not been restricted to US and the other parts of the world alone. Most of you should be aware about one of the most potential cases that ran the mills in India. That was the major patent litigations that hit the headlines between Bajaj and TVS. The patent battle that started off in 2007 and ran till 2019. In September 2007, let's go into it in a little bit detail because it's important that you understand that India is also not immune to patent warfare. In 2007, September, Bajaj Auto accused TVS Motors of infringing its patent on the digital twin spark plug ignition technology when TVS Motors launched its 125cc motorcycle model Flame 125 that incorporated the controlled combustion variable timing intelligent technology. Bajaj Auto claimed that the TVS technology was a copy of its original technology, that is DTSI technology, which it uses in various products which it has launched out the past several years, and also particularly in the Pulsar series of bikes. TVS, however, to its fort, they will deny the allegation. They did deny the allegations, and TVS went the extra mile. They slapped a fine of 250 crore as a defamation suit against Bajaj Auto. The case finally landed up at the Supreme Court. In effect, this entailed Bajaj delaying the entire launch of the TVS Flame 125cc bikes in the Indian and other global markets. This is a classic case how companies, your opponents who have potential patents, can even delay launching of your products in the market if it comes to light that your products have indeed infringed the claims in their patents. Eventually, what happened? Bajaj and TVS arrived at a mutual settlement in October 2019 of their decade-long dispute. They agreed across the table to withdraw all their decade-long disputes, their proceedings, and absolve each other from all outstanding liabilities, claims, and demands and actions in all the courts, including India and also other countries in Asia. When one talks about IP sales, now let us go away from patent wars into IP sales, sale of patents. Google purchased the Motorola patents, a bunch of Motorola patents, about 17,000 patents of Motorola, way back in 2011. Why? Because Google wanted to protect its Android operating system. They purchased the patents of Motorola for $3.5 billion US. In turn, yet another case of patent sales was in 2012, when America Online, AOL, had 800 patents which were acquired by Microsoft for about $1.05 billion US, which was in turn turned around to Facebook for $550 million in cash. So what do all these figures tell you, basically? Why are we looking at these case studies? It's costly to create. It's costly to maintain, but extremely expensive to infringe. There are price tags attached to IP. It indicates the value. But we should also realize quickly that the value proposition, the intangible value proposition, is even higher than the actual prices which are attached or that tagged onto the respective patents or the assets of any company, organization, or entity. Now let's get on to the subject proper, where we say, what is meant by patent value in terms of patents that protect the devices, commonplace devices that we use in our everyday lives? we see that any product launched by any company in the market or device, it is rarely the case that it is protected only by one patent document. It has got multiple components, types of IP protection. A device that you talk about, be it a smartphone, be it a car, or be it an automobile part, whatever it is, we have got multiple IP instruments that protect any specific product. If you look at the latest brand of the smartphone, it has thousands of patents and other types of IP protecting the various aspects of the design, the brand name, and the functionality. As we would also see, all of these different types of IP protection would either be enforceable within the same duration of time, or these could also be filed eventually in a phased out manner over subsequent years, so that they protect the various improvisations, the enhancements that have been made by the company to the respective product lineups. This is actually the case in majority or in most of the products which are being marketed by companies, where there are invariably priority claims attached to every subsequent improvisation, which actually dates back to the original filing, which protects the core inventions as well as the given product is concerned. This is yet another classic example of how diverse streams of IP protection would go into a little bit of an older device, which is the Tata Nano car. We have got more than 37 patents and more than 31 designs that protect the diverse aspects of the Tata Nano vehicle. So any finished product thus is protected by multiple IP instruments, and these are what get packaged into what we call as a portfolio. So what does it tell you? It tells you that compared to an isolated patent for a specific aspect or a fragment of or a component of a multi-component device, a set or a family or a bunch of IP instruments is what attracts value. So now going with this, you have seen multiple instruments, multiple IP streams of protection being packaged towards protecting devices or articles. What do we understand as a portfolio? In simple terms, a portfolio is just a collection of related or unrelated IP instruments or types. They can be granted patents, they can be applications, they can be trademarks, they can be designs, copyrights, owned by any entity or an organization. Among the various possibilities here, one of the simplest and the rare possibilities would be the case of one company has only a singular novel and an inventive product, whose components are already in the public domain. That is a very rare case to happen, but still there are such cases around. But the most common case that we have would be an IP portfolio that packages various types protecting distinct features of the grant, or a company that is set to market a multi-component product, where there are different portfolios around the individual components of a specific multi-component product. In such a case, it is possible to have different patent portfolios. So what is the ultimate impact of this? The important feature of any patent portfolio is that the different IP types should address products or protect similar or related technical or industry problems. If you have a bunch of patents which protect specific aspects of a particular product, that means that there are several aspects or improvisations to the invention, and all of these need not necessarily happen at the same point in time. But eventually they pull to the same family, which means they address a lineup of problems which have been sought to be addressed by the industry over a significant period of time, so as to provide differentiated solutions or a runway of solutions that would hold the market for a substantially long period of time. In addition, it is equally important that they address problems and solutions have futuristic market value and envisage novel, inventive, and differentiated feature improvements as far as the product and its market potential are concerned. So thus we see a directionality. It is not that patents are just blocked up together or they are piled up together at random. There is a purpose when there are groups or families of patents or different types of IP protection accumulated together towards protecting or enforcing a specific device in the market. That is what you call as a directionality as far as building a portfolio is concerned. It is this directionality in the nature of problems being addressed by the innovative solutions and the character of the solutions that are being offered through the respective inventions in the patent document, that value gets realized, especially when it comes to the protection and enforceability offered for the specific device or the multi-component product in the market in any country or in any jurisdiction. So what does it tell you? The take-home message is no product can be protected by one patent. And at the same time, any organization that strives to create value is not doing a job only by creating few isolated patents. Patent value for self-reliance and self-sufficiency, for Atmanirbhar Bharat, it is important to have directionality in building patent portfolios. There needs to be a significant strategized approach when it comes to building ecosystems around specific products and technologies that are going to hold the market over the several decades to come. Let me now give you a very simple, naive, school level example, or even I would say a very preliminary and a primordial example to help you understand what are patents versus what are portfolios. The left column shows you bricks which have just been accumulated and piled at random. They don't give you a message. They just give you, yes, there are a few bricks which are just lying out there in the backyard. They don't carry any specific message for you. They are just bricks by their own right. They are there. Now look at the right column. Still, you don't have much that is worth a bill. You've got bricks which have been piled up one above the other. They just show you how orderly we could arrange bricks. But it still doesn't tell you why this should be valuable to any person, for that matter. They are just there because they have been piled up. They are being prevented from littering around the backyard. Littering the backyard, pretty much. But look at the central column. You have a beautiful building coming up, which is made up of bricks. The big question to ask is, do the bricks by themselves make up the building? The straight answer is no. The building is a portfolio. The intangible or the tangible value proposition. If you talk about a building, it is a property, it has got real-time value. But if you visualize a portfolio of patents, of intangible assets, if you equate them with they can only be equated to a building, an edifice in its own might and right, which gives you value not by virtue of the bricks accumulating themselves or being accumulated, but the fundamental confluence of multiple bricks with several other ingredients and different streams or different sets of materials and instruments that go in together to ensure that the value proposition is exuded in real time. This is how you understand a portfolio. So thinking a bit, we can quickly realize that these individual bricks are like patents in dark space. We just have few random filings here and there in any specific technical area. They are just like bricks on the backyard. The best that we have is that they are just piled up. But if you want intangible value proposition from your patents, you will have to strive to make it attractive. Building. The building or the monument or the edifice or the palace, whatever you call, is what you call as a patent portfolio. That is what gives you value. That is what makes companies. You name all the big companies worldwide, you name the big names in intellectual property, in patents, in technologies, you name any technology-savvy company. They all rest on the firm foundations and the firm edifices and buildings that have been built using their patents. Let's go for a simple example here that's about, I would want to showcase a company, Seoul Semiconductors. They are active in the LED lighting market. I'm just taking a random example. It's not important whether they are particular to what we do here. It is just for you to understand what our patent portfolios are. If you look at the the LED lighting market, if a company strives to put in place or launch an LED light bulb in the market, what are the various individual technology segments that go into building the finished product, which is an LED bulb? You have a host of segments which are given on the left column. The more the segments that a company plays into, the more pioneering would its place be in the IP value ecosystem, or the market value proposition that it upholds by virtue of its products being protected by patents in the various seminal technology domains or segments that contribute to the realization of the end product. Seoul Semiconductors, for instance, has got attractive seminal early time patent filings in the area of atomic groups, LEDs and applications, packages, encapsulations, component assembly, LED systems, driver circuits, lens, boards, heat, etc., etc. All of these are important segments which are material to the performance of an LED bulb and the USPs of the bulb in the market, which are sought to be marketed by Seoul Semiconductors for the success of its next generation bulbs that are ambitiously sought to be positioned in the market to hold the market for at least for the next 1 decade. You could see the columns there. They clearly show what the influence scores are as far as the individual products are concerned by virtue of the patents that Seoul Semiconductors has in the respective technology domains. It clearly tells you how much of importance that an early patent offer when it comes to any company making its mark in a specific product, which is a multi-component product. You also see what is the percentile of the earliest patents which the company has in that specific technology segment. And it tells you how much of the share, the potential market size of the total available market of that specific LED bulb is being owned by Seoul Semiconductors by virtue of its technical and IP power. Here is a clear case which clearly demonstrates how IP as a potential asset is competent to drive market power. But for these patents, Seoul Semiconductors would have been swept off its feet in the LED lighting market. If there's a value proposition accruing to Seoul Semiconductors in the LED lighting market, it's only because of the potential influence that the light bulbs, that the individual technology segments and the IP that is generated by Seoul Semiconductors and created, and the subsequent daughter filings and the priority filings which have stemmed throughout in time, which actually reinforce and back up the generations of products that Seoul Semiconductor has got in the global markets. So now that takes us to the real challenge question for IP and India. For new self-reliant India, as it is ambitiously poised to position itself among the fast-growing economies in the world, how is it that, what is the challenge question from an IP angle for this country? That's what I have sought to give as a top headline for my. How do we create value-returning IP assets for self-reliant and self-sufficient India, Atmanirbhar Bharat? Valuable IP stems from both big science and game-changing technologies that offer targeted and well-benchmarked novel solutions, which are inventive, useful, and concrete in their own might and right, solving real-time industry and societal problems, never offered by others so far. So what do you need to do as scientists and inventors who are tasked with the research and development process? We are all tasked as scientists to develop holistic, progressive, transdisciplinary or interdisciplinary solutions that would be valuable for industry in solving multiple connected problems, yielding rich diversity in applications that would be valuable to industry for tomorrow across segments. Whatever products that we have, whatever processes that we make, should be benchmarked against the state of the art for the technology and their market differentiators or their techno-commercial value proposition. They should ensure that these solutions are effectively protected through competent streams of IP protection, not one patent. Multiple types of IP protection have to go in to any of these differentiated solutions developed so that it's not an isolated value that accrues by virtue of these IP instruments, but it's a value runway over the several years to go. So towards this end, what is required? anything that's going to be of value to the country, anything that is aimed at creating a valuable asset should necessarily involve a strategic approach and a strategic thought process. Strategy first and strategy last. It is not one filing, but layered or tiered primary patent filings on core inventions, followed by secondary, ring-fenced subsequent daughter filings to protected market-oriented adhesions to products. In other words, what do we strive to create? We are essentially trying to create a portfolio around everything that we do to ensure that what is offered is a value runway. We are actually perpetuating and sustaining a problem solution ecosystem that would be fertile enough to generate value for the organization going forward. It is this understanding and realization that is critical to all of us at this juncture when we celebrate the National Intellectual Property Festival. I would just quickly take you through what are the ready reckoners of patent value. When you say that there are going to be, of course, valuable patent filings, the generation of valuable IP, there are a host of factors. I will not spend much time on these because all of these are organizational factors. We have got multiple factors. It's important to have first and foremost a self-appraisal of the competitive advantage that an entity or organization commands in respect of initiating R&D activities. When you start a line of R&D, how competent are you? What are your competencies? What are your capabilities? What are your strengths? What are your weaknesses? What are the opportunities available? What are the threats around? These are the important questions to be raised. Then, second, most important, as much as you know yourself, know your competitors. Who are the people with whom you're rubbing shoulders? Who are those people who can potentially block your directions of activity? What are their strengths? What are their weaknesses? What are their opportunities that they offer by virtue of their strengths and weaknesses? And what are the threats that we get? The competitive advantage would either be the background IP that you have, the granted patents in the organization, or the know-how that would be available to you to understand. So what does this involve? This necessarily involves you taking stock of what patents that you have and the IP of the organization with a view to understand the strength and shortfalls that you have and trying to rectify them from an IP perspective. The next important is understanding your competitive environment. We always pays to ask the question, know yourself. What is your competitive advantage when you think you're putting yourself into a direction of R&D activity? Do you have any background on this? What are the patents? What is the know-how? What is the literature that supports you? What are your envisaged lines of activity when it comes to generating something new? And what is the potential that it offers, that your solutions might offer when it comes to driving the markets in related areas going down the road? As I mentioned earlier, understanding strengths is critical, and that too from strength, weakness, opportunity, threats, and that too well ahead before you start a game. The entire slide tells you there are various other factors which I'm not getting into. There are markets. You need to understand your consumers. You need to understand what are the industry practices, what are the trends, what are the filing realities, what are the costs. But more importantly, you should understand what are the key competing environment that you have and what is it that you have as your strengths, and how would you leverage the weaknesses of someone who tries to block your way when it comes to your efforts into getting into a realm of activity and positioning your products to a company ambitiously in the market. And last but not the least, when you are at that level, when you offer really differentiated solutions, there comes a time when you ask yourself, am I, by virtue of my R&D and my wealth of learning, by virtue of my differentiated efforts, am I enough to outsmart the paradigms of AI and ML, artificial intelligence and machine learning, when it comes to creating really differentiated, novel and inventive solutions for tomorrow? The more you leverage AI and ML as a tool when it comes to creating valuable IP, the better off you are when it comes to sustaining your pride of place in the innovation ecosystem or the R&D and innovation and technology ecosystem in any context, in any domain. Now, the important questions. First, I'll go very briefly on this in the interest of time. How do we derive competitive advantage? Know yourself first. This is where an organization like CSIR ORDIP comes to your benefit. We are the people in the trade. We tell you what your strengths are. We help you understand and realize and introspect into what's the background that you bring into the organization. What is your background? What is the wealth of background knowledge, know-how that you bring to the fore to help yourself position your products, come up with new directions of activity, and create valuable IP for the organization. We help you understand what your background IP is, by virtue of patent informatics. This is what patent informatics helps you all about. It's a due diligence exercise which has got multiple dimensions, which flows through multiple streams. Before you start any R&D activity, we help you with state-of-the-art evaluation, trying to understand who the key players are in the market, who the key competitors are in any direction of activity or in any R&D area, and what are your deeply seated opportunities available for you to create or to venture out to make investments into new directions of R&D. Then we also help you understand what your inventions are. We also get you appraisal about your competitors. That's of course the next slide. Decide who your competitors are. Who are the companies, organizations who are active in similar or related technology domains? Who are the people or who are the players, who are the entities who are in similar lines of activity that you want to pursue? What is the IP that they own? What are their ownership rights? How do you evaluate the third-party IP? Once you evaluate yourself, you would be in a better position to help us support yourself and say, how would third-party IP help you or show you opportunities? This benchmarking process is being done on a strength, weakness, opportunity, threat perspective, as I already told you. The opportunities that unfold before you help you create or help you understand and identify the opportunities that are available for you on new R&D activities as well as for new IP filings. In addition, we also support you with competitor roadmaps. We use predictive analytics. We try to gauge the directions of activity of competing entities. With all of these efforts, what is the ultimate takeaway? We help you strategize your IP position. To create something of value, it takes a significant regiment of homework from your end to ensure that the patents that you create survive the risks and encumbrances in the open market. So what's the key objective of all of this analysis? Whatever homework that we do for you? CSIR ORDIP is specialized in diverse streams of patent analytics and informatics services that seeks to position, that helps you understand, identify, and appreciate the opportunities that you have for R&D, for new IP filings, as well as for new potential product launches. What is the ultimate objective? The objective is to maximize your competitive advantage by virtue of differentiated IP assets that you have or which you can create, and at the same time by minimizing the risks that you have. A very important question that again needs to be asked in the context of IP value. As I said earlier, when you talk about valuable patents or even IP value accruing from patents, there are a host of reckoners to this. It's not only about what you do, the kind of activities that you are involved in, it's also about how you benchmark yourself. When you strive to create new IP, you should always be understood what are the substantive elements and what are the laws, the statutory guidelines that you need to comply with when it comes to creating new IP. That is where the real reckoning happens, when you understand that whatever that you have been doing till now does not qualify for patent protection. And what essentially qualifies is something in a very narrow niche area, which is an intersection. When you attempt to file a patent application, you are governed or controlled or restricted by your activity, the precise metes and bounds of whatever you have done, and the limitations of whatever you have not been able to do or whatever you have not done. When you have got the entire macrocosm of the rest of the world that has done several things, that have accomplished, that have to their credit, numerous inventions and innovations and new technologies that complement or supplement whatever you have tried to offer. There may or may not have overlaps with what you have strived to do. Over and above all of this, you have got a blue book sitting above you, which is nothing but the substantive criteria of patentability, the laws of patentability, the statute, which ordains what deserves to be protected and what does not. So the intersection here actually gives you what is it that you deserve protection for, and what are the metes and bounds of the patent rights that you can rightfully command and enforce. This is the ORODIP landscape. This is what ORODIP does for you. CSR ORODIP, my organization, is positioned on is one of the premier organizations in our country primarily to support CSR scientists when it comes to your inventions, understanding the worth of your inventions, opportunities that are available for you to protect your inventions through patents, and also giving you the opportunity space, technically feasible opportunity space that is important for you to understand, realize, and assimilate. Before such time, you start your R&D activities, or you attempt to file a patent application, or you strive to launch a product in the market. Broadly, if you envision any technical activity to progress through this value chain, ideation, design, development, and deployment, we help you ask the right questions. We help you find answers to these questions, starting off right from the idea piece, going all the way up to your finished product with different sets of questions that need to be brought up at different points in time, so that these are always flagged up as ready reckoners for you going forward as we commiserate with you throughout the life cycle of your R&D activities. That's the reason why we say IP is not something to be addressed at the end of the pipeline. The journey of IP starts with the journey of R&D and then the journey of technology development. The journey of intellectual property protection, creation, capture, and enforcement, it commiserates and accompanies the journey of R&D. Starting off with ideation, you see the various questions that are being asked. Is your idea novel? Is it non-obvious? Is it useful? If at all you reduce your idea to practice through an invention, is that invention going to be worth a patent? Next comes the design. Is your design going to be non-obvious? Are there not related designs in the marketplace which try to mimic or at least overlap in fragments with what you have attempted to do? What is it that you have attempted to develop? Whatever that you have developed, is going to be useful? What are the dimensions of utility as far as your product is concerned? Is it inventive? Have you developed the product in isolation, or have you held hands with people who are the stakeholders in your product development? Last but not the least, if you think a company that you have partnered with is competent to launch a product, what are the low-risk opportunities available for you, for the company and you, to position your product in the market? What is the marketability of your invention? All this rigorous regiment of due diligence they all form necessary and sufficient prerequisites when it comes to understanding, when it comes to positioning yourself on the IP map, and also when it comes to positioning yourself in the R&D map in any geography or in any jurisdiction. This is again the process flow of ORODIP. What CSR ORODIP does for you when you get across an invention disclosure to us, or you get across a request to understand the state of the art, or you send us a request to understand the possibilities for market positioning of your product. Broadly, there are 4 blocks, process blocks here: search, screen, analyze, report out. At the end of the overall process flow, we get you presentations. We also cross multiple iterations with you. We have extensive discussions, technical, techno-legal discussions with you. And end of the day, what you get would be a presentation or a report that clearly delineates what are your opportunities versus what are the blocked areas. If there are blocked areas and you are left with no option, what are the low-risk opportunities available for you to design around what is already out in the market, so that you understand what is that you can safely protect through a patent filing, or you can safely launch in the market in any specific jurisdiction. So what do we give? What are the outputs of all of these? What is the outcome as far as you are concerned? Whatever activities that CSR ORODIP strives to do, For those of you who are not aware of these terminologies, state-of-the-art landscapes provide information on blocked versus available areas for new R&D activities. Patentability assessment reports provide information on patentable filing opportunities for novel, inventive, product-oriented and market-oriented inventions. And freedom to operate assessment provides evaluation, benchmarking of differentiated market features and specifications or marketable features, differentiated marketable features or USPs of your products or technologies in the market. And also, we also get you the IP due diligence, which is required for a critical and objective assessment of IP risks that you do have when you attempt to position a product in the market. Further, it should also be noted that patentability assessments are only a necessary and sufficient requisite to patent filing. It is not a sufficient condition. You need to understand that any regular complete specification filing presently, as far as CSIR is concerned, needs to go in for a techno-legal or a techno-commercial evaluation of the value proposition of the invention in a patent. Before such time, it qualifies for a complete specification filing in the Indian Patent Office or any patent office. This slide shows you what is the canvas of information that we get from whatever we do for you. A patent landscape effort that we do gets you, and the first work product that we get out to you would be a spreadsheet. But always understand that a spreadsheet, just a harmless and innocent work product that it comes there, offers you information that is packaged in different levels of magnification. We get you the population of players out there who have been the players in a specific area, who are all the key competitors, what are the geography-specific trends, what are the specific countries where your competitors have been active, what are the technology domain-specific and prior art-specific aspects. We also get you distributions of patenting activity. We get you time-specific locations. What are the various technology domains where specific companies have been active? What are the various assignee segments and the market segments that they have command? All of these come within the scope of what you call as patent landscapes. In other words, they are just relationship matrices. Whatever work products we get out, as far as our efforts for you or support services for you, clearly tell you where are the opportunities, where are the blocked areas, where are the real threats, and what is it that you need to circumvent and design around when it comes to be risk-free or low risk when it comes to any of your IP activities. So essentially, you need a blueprint of an interpretation matrix or a relationship matrix. That's what a landscape offers when it comes to deciding what are the opportunities that are available for you when it comes to new filings. We also bring you different analysis scales. The data that is available through patent searches and analysis gives you the opportunity to look at competitor data, the data of your adversaries, of third parties at different levels of magnification, and map out risks which are going to be very important for you when it comes to understanding your precise filing opportunities and also your market launch opportunities or space. In other words, the technically feasible opportunity space is what you call as white space. That is where ODIP helps you. That is the primary and the ultimate offering that we could ever bring in that would support CSIR and CSIR scientists across their entire journey when it comes to R&D activities and new technology development. This slide is just a visualization of what a landscape is all about. If you visualize yourself coming down from a very high altitude, imagine that you're just flying yourself in a helicopter. You're just coming down close to the earth, to the ground. You see different magnifications of the landscape. So that's what I meant by magnification scales, different scales at which you look at prior art activity. What is the level of refinement that you give to your exposition of the risks, the opportunities, the threats, and the blocked areas in a landscape? To what level of refinement can you carry yourself when it comes to the analysis? That is what differentiates the different streams of analysis that we offer. Different levels of activity, different streams of R&D activity. There are different occasions where you need information and updates about prior art activity at different levels or different magnification scales, time scales. That is what is going to be important when it comes to scoping out the IP risk and understanding opportunities at a very fine level. This is one of the outputs of patent analysis. It just gives you dots and dashes in space It just gives you what is the geographical jurisdiction against a dark background. A pattern landscape visualization is a typical pattern map. It gives you how gasification, coal gasification, or any stream of biomass gasification, if you look at it as a technology domain, what are the different types of activities or how distributed across the world are the inventors or assignees when it comes to specific patents or patents in the area of gasification. This is what this map appears to give. That is a very high level of magnification. This is one of the, very small scales at which we can give an overview about what is the distribution of your competitors or distribution of various players across the globe when it comes to different dimensions of activity. This is a more precise or absolutely comprehensive method of visualizing what are the different fragments of information that we offer. CSIR ORDIP offers through its patent landscapes and through the canvas of its patent analytics activities. We help you dig out IP information that's going to be material to you when it comes to starting your R&D activities or even when it comes to positioning your patent filings. We look at a host of IP data here, which are just mentioned in all the blocks individually, and we help correlate them. We bring out different cross-sections or correlations of these, which would give you different projections of competitor activity and help you understand opportunities from different perspectives, through different length scales and through different intersections. Then you have the different fragments of technology information that you bring in. You got subject matter, technology domains, industry areas, etc., etc. Then most important, as technologists, it's also important that you have insights on structure, property correlations, application correlations. That gives you more potential opportunities to position your IP filings and also tailor and refine the end specifications of products that you envision your R&D or your invention should cater to tomorrow in the open market in the specific countries that are going to be material to you. This slide quickly gives you what are the important value drivers. Whatever informatics services that we give you, the pre-filing homework, what are the takeaways from this? We help you understand and appreciate what's the technically feasible opportunity space for you. What are your IP value drivers? That's a big question. If you want to create valuable IP assets, it's very important that we realize what are the IP value drivers that are going to be material to you when it comes to positioning your IP instruments for tomorrow. How do you strive to position your product? What are the well-defined metes and bounds of the claims? How do you file a strong, broad patent application? What are your chances? How do you position your product in the market? What are the differentiators or the USPs that you need to reckon with when it comes to positioning your product or when it comes to helping your industry partner position the product in the market based on the fruits of your invention or your R&D? So all of these takeaways would decide the impact of your work. What is the strategy that you need to have? What are the R&D directions to invest in? What is the core competence that you need to build if you need to have filings in this domain? What are the products and the technologies that you need to in-license to ensure that you have substantial competitive advantage before you venture into specific directions of activity and mark your positions in the R&D and IP roadmap of the world? This is just an illustration of how companies position their IP strategies. When we think strategies, why are strategies important? They're important because that is the only one that helps you create assets of value. If you need to create patents, if you need to create intangible wealth for the organization that needs to be value returning tomorrow, it should necessarily be accompanied by a strategic thought process and a roadmap. And that is again what you mean by building a portfolio of valuable patents. First, understand what your core strengths are. What are the core technology domains and grounds where you're playing in? What is the scope for advancement that you have? What are the other peripherals? The improvisations, the adaptations of your invention, all of these form the core inventions and your technology imprints. Then you take it forward to the functions and the applications. These are the ones that help your industry partner. If you hold hands with the industry and if an industry shakes hands with you to carry your inventions forward to the market, what are the precise USPs of your potential product for tomorrow, which your inventions would cater to or support? Based on the foregoing discussions, you could clearly see what are the ready reckoners, what is it that you need to focus on, and what is it that you need to steer clear of. This clearly shows a well thought out strategic approach. Then you have got an entire microcosm of your competitors and your collaborators. You have got vendors and suppliers. Their IP is distinct from yours. What is it that you need to leverage? What is it that you need to ignore and stay away from? That is the most important strategic reckoning, the thinking that needs to go in when it comes to generating IP. There should be efforts to define, refine, and position your invention precisely, completely, with emphasis on the problems addressed. Whatever that you do should strive to address the industry problems for tomorrow. And what are the solutions that are truly differentiated that you offer so that industries can count on them when it comes to generating a value runway for tomorrow. The core inventions need to be scoped, focusing on products, processes, technologies, as the figure rightly shows you. They will form the primary filings. I will show you these in subsequent detail as we take the slides forward. And this approach is what essentially gives you a pipeline of filings as opposed to individual dots in space. Such a pipeline of filings is what constitutes a portfolio. And such a pipeline of filings, a host of filings, is what attracts IP value. This is an overall process flow as to how R&D and IP need to travel together. Your effort to take forward any direction of R&D starts off with your background, your recognition of your background IP, and how far is your initial competitive advantage that enables or actually facilitates you leverage IP as an R&D enabler. What is it that gives a threshold for you to take off? Then comes the benchmarking process, where you understand yourself first, and you also understand your competitors from a strength, weakness, and opportunity threat perspective. That is what we have often referred to as the regiment of due diligence or competitive intelligence. Then comes the attributes of your foreground IP. Based on whatever you have done, how potential, what is it that you need to create as IP assets? What is the realization? Then comes the whole world of IDFs, invention disclosures, IP creation, product-oriented IP, etc., etc. Then you understand on how to position your foreground IP into something that protects the products for tomorrow. Then comes the IP filing process. I would not spend much time on it. There are experts talk about it in greater detail. Then last comes IP enforcement. So we see an entire chain here. It's just a value chain. And it shows how R&D starts, the IP exercise also starts along with it and travels together at various stages. There are inputs, IP inputs that need to get in so as to enable you understand where you're heading to and what is it that becomes a good and valuable imprint of whatever that you strive to do. Now comes the key reckoning. How do you file valuable IP? What could be a strategic process when it comes to creating valuable IP assets for CSIR and for India to realize the realm of Atmanirbhar Bharat as we continue our journey through Amrit Kal? First, understand what you do. Recognize your core strengths. Develop core technologies and inventions which are going to be value adding. They are your transformative inventions. They carry the day for you. In the IP map, as well as in the market outside. Core technologies, but immediately we should follow them up with products. The core technologies give room for products. What systems and devices would draw strength from your core technologies? What are the processes which are delimited by competent differentiated products that are amenable to patent protection? What are the new compositions that you have developed using your core inventions? All of these form the next layer of patent filings that you need to do as an organization. Then this is how you start building your IP portfolio or a patent portfolio. Now you see a strategic thought process here as we go on to develop new adaptations and improvements. As far as your lineup of products is concerned, your systems and devices are concerned. You have got enhancements, you have adaptations and improvements, you have optimizations. End of the day, these are all enhancements to whatever core inventions which carry the transformative imprint of your R&D activities. They form the next tier or layer of filings as you accumulate the portfolio. And again, understand, these do not come at the same point in time. They're all phased out. If you file one, you utilize or leverage the priority mechanism of the patent system to your advantage. All of these are priority or even daughter filings, but they add value. They give you a runway of value with time to whatever you have strived to protect at a core level and whatever you have strived to enhance on an incremental level and leverage as far as your market advantage is concerned. Then comes the next level, which talks about structured property correlations, performance. Why are we focused on these filings? This particular layer of filings are the ones which contain claims which specifically protect the USPs of whatever products are envisioned to come out of whatever R&D that you do. These they protect the features, specific features, or even components that give specific features to your inventions. And then comes the last big layer. What are the market-oriented USPs? Generate market-oriented IP. Market-oriented IP, product-oriented IP. That is how a portfolio culminates. That is what gives you strength. So what does this tell you? This shows you an entire pipeline of how filings happen. This is what is often called the ring fence model of patent filings, which helps you generate value through a constructive building or creation of portfolios of patents around specific components of your product or even specific attributes of multi-component products, devices, etc. Most important part of all these filings is enablement. Whatever differentiated things that you do have to be documented properly. And this is what supports your claims, which essentially protect and add value to every single layer here. This is the kind of approach that gives you resistance to litigation, which becomes a real deterrent to competitors. And your third-party peers and competitors would really think 10 times or even 1,000 times before they strive to attack your portfolio. Your portfolio would be the most resistant to all sorts of liabilities. And this is what, end of the day, offers you a sustainable market position. That is what carries your day for you in the markets, not for today, but for tomorrow. This is what you call as an IP value runway. Now you see the correlation between how you start off with individual building bricks, which are patents, build families of patents, and eventually understand what is the value proposition of IP through a portfolio construction, which essentially follows a ring-fenced approach. This is the most robust approach towards building portfolios, which is something that would hold value for any organization. And this is what institutions should internalize at the present times when there is an increasing call for self-sufficiency and self-reliance. I would just skip off these slides. These are all passive strategies. It talks about protection, avoidance of disputes, how you defend yourself against your competitors. All of these are important. Okay, when it comes to understanding your position in the market and also avoiding disputes and liability to the level as possible so that you maximize your competitive advantage while you minimize adversities and risks from your peers who hold the market. Always remember that IP is a collaborative activity. Do not be under the impression at any point in time that you are the only doers or you are the only players in the game. There are people to outsmart you. Do not have a proverbial head in the clouds approach. There are people who can hold cards against you. It is your responsibility to be wary about your competitors and understand how best you can outsmart your competitors through differentiated lines of activity that would put your signature, the signature of CSIR, on the IP roadmap of the world. This is what I told you initially about an IP value life cycle. Companies and institutions and entities go multiple passes through the entire life cycle. You start off with an IP business model. What is the big question that you ask? We all spend crores of rupees or even say lakhs of rupees for filing patents and maintaining them. The paradigm for Atmanirbhar Bharat has to be different. IP shall cease to be a cost object, but IP shall be a business function. When IP becomes a business function, IP pays for your businesses. It has got profit and loss centers. To develop IP of that caliber, you need to have a structured, well thought out approach, which I explained all the last more than an hour. The big question is, how do you generate valuable revenue returning IP? What is the background IP asset that you have? What are the strategies that you need to reckon when it comes to filing valuable IP? How do you reinforce what you have? What are the approaches towards building things which companies would find valuable for tomorrow? What are those potential differentiated solutions that industry is hungry for tomorrow, which you don't have today? And how is it that your R&D can provide differentiated, novel, inventive, connected solutions to them? How far are you sensitive to the big problems of industry for tomorrow? That decides on what is the value of the IP that you create and what is the value that the industry sees in what are the assets that you create for Atmanirbhar Bharat. Multiple passes through this entire value life cycle tells you what you are. You go multiple passes. Organizations that have gone multiple passes through this entire value life cycle eventually realize how to make money out of IP and how IP becomes a value returning and revenue returning techno legal instrument. That is where you realize the techno commercial value proposition of IP. It's a massive exercise, a pan organizational exercise that is massive in impact and even more overbearing and overwhelming in impact and purport. Let me now sum up. What have you seen of the last 1 hour? Commiserate with industry. Involve industry in your R&D activities. IP is not an end of the pipeline entity, please. I start with your R&D journey. Before investing money, resources, manpower, build industry stakeholdership in projects. Go for collaborative approaches which are cross-disciplinary. Don't look for conventional solutions. New IP hardly comes from solutions that you already know. You need to imbibe transdisciplinary approaches when it comes to scoping out or finding out solutions to your differentiated problems. Complementarity in problem solved and solutions that you offer. They have to be industry ready. What are the levels of refinement that you need when you go back to your labs, when you're at your workbenches as scientists working on ambitious R&D projects? Have an eye for these questions. Attempt to answer these questions to whatever levels of granularity that you can. That is the way CSIR shall be benefited when it comes to creating and generating and leveraging valuable IP. Competitive intelligence, benchmarking, risk mitigation, circumvention, all of these CSIR ORDIP is for you. We offer you seamless support around the clock. When it comes to your activities in R&D, when it comes to allaying your doubts, your concerns on IP protection, and pointing you to specific low-risk opportunities where you can file good, valuable patent applications for your inventions. And also come up with ready reckoners and due diligence questions when it comes to you supporting an industry or working closely with an industry to launch an ambitious product in any territorial market. Understand and have a sensitivity for the value chain of R&D and IP. Understand how IP works hand in hand with every single stage of R&D. Understand what is valuable IP, the overall technology and the IP value proposition. That is what offers you licensing opportunities. Focus on core inventions. Help us support you when it comes to building valuable assets in a ring-fenced model. Understand what are the different stages of your R&D activity and what is the nature of filings that you need to have at every single point in time as you take your IP exercise forward. That is what I showed you by way of the ring-fenced approach. That is what build portfolios which are value multipliers for any organization to help them sustain a value runway for tomorrow or the years to come for Atmanirbhar Bharat. Thank you all for your attention. Jai Hind.
Yes. Thank you very much, sir, for such a detailed and informative lecture. महोदय, आपने अपनी अत्यधिक व्यस्तता के बावजूद राष्ट्रीय बौद्धिक संपदा महोत्सव समारोह के एक दिवसीय कार्यशाला में उपस्थित होकर कार्यक्रम की गरिमा बढ़ाई। महोदय, हम आपका हृदय की गहराइयों से आभार प्रकट करते हैं। आपका बहुत बहुत धन्यवाद। अब मैं निदेशक महोदय से अनुरोध करूंगा कि वो मुख्य अतिथि को शॉल और मोमेंटो देकर सम्मानित करें। थैंक यू सर। मैं अपने संस्थान के मुख्य वैज्ञानिक डॉक्टर जेके पांडे सर से आग्रह करता हूं कि कृपया धन्यवाद ज्ञापन प्रस्तुत करें।
Thank you very much, Suraj. Respected chief guest of the today's function, Dr. Kishore Srinivasan ji, Dr. Professor A.K. Mishra, our director, Dr. P.K. Banerjee, Sri J.K. Singh, host of guest speakers from today's function, Dr. Majumdar, Dr. Viren Singh ji, Dr. Delup ji, and Dr. Doble ji. Our colleague scientists, my dear students, I am honored to be here for delivering this, proposing this vote of thanks. सर्वप्रथम मैं अपने अपने CSIR के उन लीडर्स जिनसे हमारे निदेशक भी हैं उनका नमन करना चाहूँगा, जिनके कारण ये बहुत ही टॉपिकल विषय पर ये एक दिवसीय संगोष्ठी का फिजिकल रूप में आज आयोजन हुआ है, जिसमें भी है गैलेक्सी ऑफ guest speakers in specialized in all aspects of the intellectual property for the first time probably in the history in Dhanbad. I don't know, but at least for 34 years, 33 years since then when I am serving here. On this very topical subject, the subject is utmost important, and to highlight that, let me tell you one brief statement about that. हमारे जैसे हमने वीडियो में शुरू में CSIR के वीडियो में देखा कि हम विश्वगुरु थे, इसमें कोई हमारे आसपास भी नहीं था in our ancient India, but slowly and slowly the value system changes. Why? Because हमारे नॉलेज सिस्टम में, हमारे भारतीय ज्ञान परंपरा में कहीं ही ज्ञान के कॉमर्शियलाइजेशन की बात ही नहीं थी। हम तो बस एक चरण स्पर्श पर पूरा ज्ञान न्यौछावर कर देते थे, खाली पात्र ढूंढते थे, बस उपयुक्त पात्र मिले और ज्ञान दे देते थे। वैल्यू सिस्टम चेंज हुआ और उस ज्ञान को अब मोनेटाइजेशन हो गया, कमर्शियलाइजेशन हो गया, और हिस्ट्री इज फुल ऑफ एविडेंसेस व्हेन आवर नॉलेज सिस्टम वाज पेटेंटेड बाय मेनी अदर्स एंड दे वर सोल्ड टू अस। सो उस ज्ञान जिसके कारण हम उस विश्वगुरु थे उससे धीरे धीरे स्लाइड डाउन हुए, एंड वी आर अगेन गेनिंग बैक, gearing up for this विश्वगुरु इन दिस आज़ादी का अमृत काल जो हम लोग 25 साल का कर रहे हैं, 20 अप टू फॉर दिस 75 to 20 years ऑफ द फ्रीडम, विश्वता का अमृत महोत्सव जिसको हम मना रहे हैं। तो इस जो ये अमृत काल में हम लोग फिर गियर अप कर रहे हैं, उसका मेन बिंदु यही है कि हम कमर्शियलाइजेशन को अपने नॉलेज सिस्टम को प्रोटेक्ट करना, एंड प्रॉब्ली दैट इज द की फॉर दिस इवेंट टुडे। एंड इसको हम और लाइटर सेंस में कहें तो बस विश्वगुरु बनने की जो क्या कहेंगे यहीं पर अटकी हुई है। इसी तरह के सेमिनार और इसी नॉलेज सिस्टम के चेंज वैल्यू सिस्टम पर हमारी रुकी हुई है, कृपा जिसको कहें, कृपा यहीं रुकी हुई है। Now coming to the formal note of thanks, I am on behalf of the institute, on behalf of this organizing committee, we are really grateful to our chief guest of the today's function, Dr. Srinivasan ji, who made all the way from Pune and delivered such a value-loaded talk. It's really a value-loaded. Even अगर हम 20-30% भी इसको grasp कर लिए होंगे तो we can definitely justify our staying in this time. It was a very valuable talk, and he has made all the way from here and spare his time and come to this place. We are really express our hearty vote of thanks to him. Now coming to our guest speakers for today's function, Dr. Sanjeev Kumar Majumdar ji from IP Startup NRDC New Delhi, Dr. Viren Singh ji from Trademark Registry Office Calcutta, Dr. Mrs. Shivakami Dhalup ji from our CSIR UDP URDIP, then Dr. Yogesh Nathuji Dhoble from IP Specialty and Patent Office. I'm not able to read it. Thank you. These experts have also come. They are all specializing in one in very specialized field in all the dimensions. So making together, they are specializing in. They are giving talk in all the directions, all the dimensions of covering all the dimensions of this IP related seminar for this whole day. We are thankful to all of them for making this event a meaningful, successful, and very useful to all our speakers, to all our participants who have come here and who are present here. Thank you very much, sir. Now to our colleagues, junior and senior both, Dr. Banerjee, Sri J.K. Singh ji, all the scientists who are in the hall listening to these talks. Then we have a galaxy of the students. A lot of students are here who have from Dhanbad, who have come here all the way listening here. They are representing from the PK Rai College, SSLNT College, BKMU University, BIT Sindri, and all. Maybe I don't know. So these are the students, places from where the students have also come. They have made this event meaningful because this type of events does not occur very often. So it's definitely very useful that these people have come. The students have come also to take the advantage of this event. Then special thanks are also due to BIT Sindri, their training and placement cell. Then Binod Bihari Mahato Kolanchar University, School of Mines and Metallurgy of Kaji Nazrul Hasan University, Asansol, West Bengal, for giving the opportunity to conduct this awareness program in their campuses, as a result of which a number of them have registered, and maybe since the program it's not possible for all of them to come here because of the distance, so many of them have registered and they have joined online. So we are thankful to them also. So, and further special thanks to Dr. PK Rai College, SSLNT College, BB, KMK University, and PIT Sindri for sending their students to their program. My heartiest thanks to all students and these from the respective colleges. And now thanks are also due to our press media fellows who have the greater responsibility of spreading this event, this knowledge system event that is being conducted in this Simfer to spread all around the at least in Jharkhand, so that people take advantage of it. At least the event will be available on YouTube, and so even those who cannot attend this program physically, they can take the advantage of it through YouTube. Finally, finally, I would like to thank Dr. Sujan Saha and at the end, because he has done everything. We came in the scene and the very last moment. He has done from the last 15-20 days, all around, day in and day out. He was working hard. So all thanks are for this success goes to him. Yeah, if there is any failure, obviously the burden lies on us. So with this, thank you very much to everyone.
थैंक यू सर। अब आप सभी से निवेदन है कि कृपया राष्ट्रगान के सम्मान में अपने स्थान पर खड़े
Actually, guests and all dignitaries are requested to wait here. We will serve tea here, and all the students, research scholars, and all our colleagues are requested to have tea just adjacent to the hall, please. And we'll take a short break. We'll come back just after 10 minutes. अच्छा, इसका चेंज करके
ना ना ठीक मुझे ड्राफ्ट किया है प्रभु। हाँ वाईफाई वहाँ वाईफाई है हाँ छोड़ दीजिए डाल देंगे ना 10 मिनट डाल देंगे अगर कर देता है हाँ हाँ डालिए काफी फीचर से क्या
देख लो एक बार चलनी भी चाहिए ना वो से रहने तो जो भी लगाए
छोड़ देते हैं सर
ऐसे ऊपर कर लो ना इसको
इसको कॉपी करके रख लेते हैं सर डेस्कटॉप
आ गया
देख लीजिए ना
नहीं है ओपन कर दूं
मिनिमाइज कर दीजिए
ये हटा दूं या
हाँ हटा दीजिए केबल वाला कर दीजिए ना 10 मिनट दूसरे ले लीजिए पेन तुम कॉपी कर दीजिए सब पेन ड्राइव कर दीजिए तो इसमें कॉपी कर दीजिए लैपटॉप पर डाल दीजिए इसमें कौन सा लगता है इसमें हाँ दिलीप है देख ले रहा हूँ दिलीप है दिलीप डाल दीजिए दिलीप सर का लगेगा इसमें तो लिखा हुआ है हमारे भी
Isso tá aqui. Yes.
Standard.
ओके जी केवल खराब है कौन सा हाँ स्टीम है वो वाला ये देखिए प्रेजेंटेशन दो का है एक यही है उनका मैडम का और ये उस सर का ठीक है अभी पहले कौन होगा ये सर का होगा शायद ठीक है चलिए आप नाश्ता करते हैं
For me, it's going to be very easy, sir. Because you have covered in detail. That's what I was telling them. So so I'll take the case study. Other things I can Skip some slides also. Taken a lot of so I can focus on the case study. It can become easy actually.
Good afternoon, all of you, and welcome back to this workshop. Now we are going to start the first technical session of today's workshop. This technical session actually having two lectures, patent filing and strategies, that will be delivered by Dr. Yogesh Dhoble. He is coming from CSR IPU, Innovation Protection Unit, New Delhi. And second one will be delivered on patents and patent practices, the PAT informatics homework. That will be delivered by Sivakami Dhulab. So we are going to start this technical session. First, I would like to request Dr. P.K. Banerjee sir to chair this session, and our respected two invited speakers, Dr. Yogesh Dhoble and Dr. Shivakami Dhulab, are requested to come on the dais. Please. Thank you, sir. Now I would like to request Chairman Dr. P.K. Banerjee sir to welcome our speakers. First, to welcome Dr. Yogesh Dhoble. Now, Madam Sivakami Dhulab. Now I hand over the dais to Chairman, sir. Please, sir, to conduct the session. Now I would like to request Dr. Orkojyoti Das, Senior Scientist, to introduce our first speaker, Dr. Yogesh Dhoble. Orko, please.
Hello. Hello. I am Dr. Orkojyoti Das, Senior Scientist of CSIR Simper Dhanbad. Today, we are fortunate to have with us Dr. Yogesh Nathuji Dhoble as a distinguished speaker for today's workshop. I welcome you, sir, in CSIR Simper. It is my distinct honor and privilege to introduce Dr. Dhoble. Dr. Dhoble is a senior principal scientist working in Innovation Protection Unit of CSIR headquarters. He did PhD in civil engineering and is a qualified patent agent. He is also the fellow of Institute of Engineers India. He is having 23 years of experience in the area of intellectual property rights. He had written several research articles, patents in his knowledge domain. He had delivered several lectures in faculty development program in the area of intellectual property right. As we gather to delve into the crucial topic of intellectual property rights, our esteemed speaker will guide us through the best practices and the strategies for patent filing. So without further ado, I would like to invite Dr. Dhoble to enlighten us with his lecture. Sir, please.
Very good afternoon to all. Honorable Professor Mishra, Director Simfer, Honorable Chief Guest Dr. Srinivasan, Chairperson of this session, Dr. P.K. Banerjee, Scientist and students. Good afternoon to all. So, patent filing and strategies, I will try to make it at a level 1 presentation because we have a lot many students here who are just starting beginning their career in science or engineering. So I will make it a very at a level one so that everybody understands it properly. So if we see a process for a grant of a patent, what does it mean and what you can to which terminologies you will come across is that one is the filing in the sense what patent are you going to file, is it a product, is it a process, or is it a use? Because in use of a product is not patentable in India particularly, but in US, Europe, or in Japan you can get a patent on utility aspect. So it depends on in which territory you would like to file a patent. So filing will depend up according to that. So in India, we can file a patent, and that patent also can be filed abroad. As our chief guest has already told that these are the territorial rights. Therefore, its protection is also of that uh, kind. So as the as the filing is of a territorial nature, the examination will also be of a territorial nature, means it will have some kind of effects of that country particular laws. So then there will be some kind of pre-grant opposition, means after the examination is done by the experts in that area. They are called the examiners. They are sitting in the patent offices in particularly in India. If you see, we have four patent offices: Calcutta, Delhi, then we have Chennai, and also Mumbai. So we have these four patent offices where the examiners sit and they examine your patent document, and then they will try to whatever the loss is, whatever our loss is, accordingly they will try to see whether they are compliant to it or not, and then they will go. Then it will proceed for the grant. So basically, while processing for the grant, there may be the instances like pre-grant opposition or a third-party representation. The pre-grant opposition means before the grant, the patent is liable to be opposed by someone, or there can be a third-party representation. This is particularly in case of United States, where there is a third-party representation, and thereafter, you can see the grant of a patent, and even if the patent is granted, it is liable for the post grant opposition, and there can be a revocation steps also. Means this also comes after the grant stage. That means there is a liability that that means there is always the possibility that the patent can be revoked at any stage. It is not that once it is granted by the patent office, that means you have a monopoly always. It is liable for the revocation at any point of time. And then for every patent, you need to pay some kind of renewal fee. So that renewal fee uh, that is in the incremental nature. Meaning is that for the rights are there with you for 20 years, but for first 5 years the fees will be a little smaller amount. Then the fees will go on increasing because the patent office thinks that uh, you are going to renew that patent uh, because you are gaining something out of this monopoly. That is why you want to renew. So the patent office also thinks that I also should get some kind of enhanced fees from you. That is why, because the government always tries that it should be used largely by the public. So they discourage you to have the monopolistic right for a longer period of time to keep the balance between the public interest and the individual company's interest. they try to have some kind of fee structure. So what is the normal procedure for a grant of a patent? So normal procedure in is that if you are started working on some kind of idea and you are near near close or close to some kind of, I mean, you had done some kind of experimentation and you had reached to some solution, and you want that this patent to and you know that it will take some more time to materialize the things, but as you know that the pace of working by the other people is faster, so you want to protect it as early as possible. So there is a provision that you can file a provisional patent application. So this provisional patent application gives you the priority date. So what is priority date is that whosoever files the first will get the benefit, and that is respected by all the patent offices. So provisional filing one should not miss out. If they know that the experimental processes would take some more time and to have the constructive results, because provisional patent never gets published. It will only get published after you file a complete application. So your data, whatever it is secured till you feel that you are ready with the complete application. Then only you can file. Uh, meaning is that provisional, if you pay the fees at the provisional level, then within the limits of the claim, whatever the free claims that are 10 claims in India, so that 10 claims with 30 pages is free at the complete stage also. So you don't have to pay again for that fees. So provisional filing or a complete filing, it depends on what kind of maturity in your patent application it is. So after completing this stage, uh, filing from provisional to the complete application, you have 12 months of time, means from the provisional filing date to convert it to the complete application. You have 12 months of time, and that 12 months of time is also available for going into international application, that is called the PCT application. So when you file a PC, you should file on the PCT application only when you know that you have to go into 2 or more countries. Then only it is beneficial, and the rates are different for different kind of uh, applicants. Like if you are a natural person, means a individual student is filing, or or any person, natural person, it is said in a legal language. So if a natural person is filing a patent, there is a heavy discount in filing of a patent. So yeah, if I tell you the filing fees, it is very nominal fees that the Indian Patent Office ask from the applicant. That is only 1600 rupees you have to pay to the patent office to file a patent application. So it is a very insignificant amount if we see in totality, if you want to protect your IP. For the organizations, if we see, it is 8,000 rupees, but the amount of expenditure that the organization does is in lakhs and crores. And if you file a provisional application with 8,000 rupees plus, if you say the legal associate charges including, so it is not a very big amount, but investing that amount with the start, because all the game of this patent is who files first. So uh, so that is very one should keep in mind very clearly that first to file is the principle of this patent business. So when you file a PCT application, that has to be done within 12 months. If you miss this timeline, then you cannot file the application later on, because that's it. Many of the time it happens that the people, the inventor feels that I had filed the patent, but nobody has come up. And suddenly, after 4 or 5 years, there is a business request from abroad, and then they feel that they want to file the patent abroad. It is not possible, and you can lose upon the business. So then what happens after that PCT application file? Once you had filed the PCT application, then you get an international search, and the examination. What I had said is a written opinion. In other words, that you get, you need not have to respond. It means it is not compulsory to respond to those written opinions. It is voluntary, but it gives you the benchmark where your application, where your patent stands. You very well know what are the prior arts that are hindering for the grant of your application, and how much it will stand patent offices. So PCT application gives you the real test of your invention. So even if you don't want to file a PCT application, or if you want to go only for one or two application, one or two countries, that also you can do through a non-PCT application. Later on, this 30 to 31 months, as I had indicated here, it is from the date of first filings. That is from the date of first provision. So the inventor or the applicant or any organization has the time of 30 months to decide upon where actually they want to protect their invention. So this time is a very fruitful time wherein they can look for the prospective business partners. Thereafter, the if you cross these 30-31 months, again there is no means uh, there are some kind of means after 30-31 months, when you cross this line, then you cannot file the application in individual countries, and later on those patent applications which are lying in the patent offices, they will be soon published, and then you will get a search report and an examination report, and you can have the interview with the examiner, and there will be the settlement of the arguments, and you can have the grant of a patent, and you have to pay the maintenance fee in respective countries. So every where you will see there is a timeline which is involved when you are in the process of patent filing. So now, if we say which how many countries does the PCT application uh, covers? So it covers 157 countries, and you can go into individual countries, or you can select the group of countries wherein the group of countries will grant the patent, and then thereafter also you have to file the patent in individual countries. You have to select in those countries. So PCT is not the granting authority, and you should not say that it. I had filed a PCT, and PCT I will get, and you are expecting a grant of a PCT. So it is a wrong nomenclature used by the people. So PCT is the mechanism wherein you file and you get some kind of addition on time. You gain some time to file the application abroad. So what sort of justifications you can look for when you go for a filing of a patent? So you should have some kind of market leads, or you have some business interest, or market survey. You had done some kind of market survey, or countries where the similar IPs are protected. This is also means when you try to see who all are working in your area of research, or where you want to, in the area where you want to patent your product process. You come across many patents there. That time you can see in which jurisdiction those patents are falling. So jurisdiction means in which countries they are protected. So that could be one lead wherein you can see the prospects of the business. So any techno-commercial report, as Dr. Srinivasan's group is working on techno-commercial reports that are available with CSIR. So whether they are the part of any portfolio or of a strategic interest, that can also be considered when you file the patent. When you want to go for a filing of a patent, then what is the specification and what is a claim? So any patent document has this, we say it is a specification. Patent specification, it is a completely a techno legal document. We will say that techno legal in the sense uh, means there are legal clauses. No, there are no legal clauses within which you can say that act says this and act says that, and you don't know how to write it. It is not like that. It is the specification technical document only, but written in the sense that when it is interpreted in the court, it should be very clear what you are going to protect. So it should be very clear, concise, and the claims are should be means either broad or narrow. It should be it should be definable. That is the sense of the techno legal document. So it should have the full disclosure. Whatever the invention you are having, you should completely describe it. You should, how can you describe it completely? You can take the benefit of what the others had filed, how the other people had filed the patent in your domain. So that will give you a very good lead on how you can draft your patent application, what kind of examples you have to write it. So that will become a kind of basis for you to write your full specification. So another is that you should very well exemplify uh, in that. And what I said is that you should have clear and precise claims. So the claims qualifying to patentability according to the respective jurisdiction. So as I said, the every patent office means every country is having their own patent law, because as you know, some countries are developing, some countries are developed countries. So they are, each country is having a different kind of immunity in themselves, as the because they also want that their country's interest should be protected. So every country is having some kind of restrictions or openness in granting the patent. So the patentability criteria, there are only three criteria. If you see, they are novelty, non-obviousness, and the utility. But in that also, if you see, as far as the CSS example is considered, that you can get a patent in US, Europe, but you may find difficulty in getting a grant in India. So it depends on country in which your application is, and more specifically, it depends on how the examiner is looking into the citations. Citations means what? The uh, citation means the documents which the examiner is referring to as a relevant documents when he is examining your patent. So examination report, I had included here Urdi patentability report because this is more relevant to the CS here. So I had said it is a kind of examination report also, because if you are getting some adverse remarks in Urdi patentability report, it doesn't mean that it is final. You need to introspect within it, and you have to see how you can get a patent. And you, as he rightly mentioned, that you need the URDIP and the inventor have a lot of iterations while they are doing this. So it is means arriving to what is actually the inventive part of your invention. You might have written a whole of your invention, means trying to claim whole of your device like a projector. You are trying to have the invention on the whole projector, but in particular, where is your invention? You have to come out with that. Where in it is that part where the audit looks into. So PCT written, then there is a PCT written opinion. This is also a very good report. Then the examination reports. It is not always that a grant of a patent is required, we have to always check it whether you actually need the grant of a patent. Because when the examiner looks into your claims and when you are trying to get a broader claim which is of your interest, but when the examiner is showing you some documents and when you feel that you will be getting a very narrow type of claims, then it is not worth to continue. Means always the examiners will try to have you a grant. It is not that they will always reject your patent, but the patent offices are very helpful in giving you a grant. But what kind of grant you are getting, you need to introspect within yourself. Nobody will tell you what is the worth of your patent. You yourself have to find out what kind of claims you are having. Then further, if we see the draft reply, then what should be your strategies around those report is that you should draft the proper reply and response to the citations, because this will save on the cost. The cost is the important factor in while you are in the filing process, patent process. It is means apart from the students I'm talking about, there are the organizations also which are listening to it. So this is in particular to the organizations where they incur lot of cost on this filing, prosecution and maintenance. So in order to reduce the cost of filing, cost of prosecution, you should draft your reply in complete, means complete in all senses, so that the examiner don't have to come again to you and ask for the novelty or inventive step again and again on the same point. So thereafter, I had put in this patent filing cost. This is for the organizations. The for the individuals, it is a different one. So for individuals or the natural person, it is 1600 rupees. But for organizations like CSIR, it is 8000 plus. What I had said is that because in CSIR, the CSIR IPO is the organization where in all the activities related to the filing are done by the uh, in-house only. That means we don't take the services of any attorney. So we directly file, so the price is less here. Otherwise, the if you go through the attorney, it will reach to something 25,000 rupees. So this is the country's name are also mentioned here. The Japan is the higher. Japan filing amount is more because we have to file the translation also, translation of the whole document into Japanese language. That is why the cost is so much. Then coming to the examination request cost, uh, means filing the request for examination is uh, what we say is not compulsory in India. In some countries, you have to file the examination request at the time of the filing of the application, but it is in India, you can file it within 48 months. So 48 months is the time you have to again decide whether you want to really want a grant of a patent or not. So this also cost can be saved if you do a proper due diligence on your all steps you are in when you're filing a patent. Means after filing a patent also there are the cost, where I will come to that slide wherein I will show you how the cost escalates on. And if you take the proper steps, then you can actually reduce the significant amount. So the EP attorneys are a costly one, because filing a patent abroad means that you have to engage the foreign attorneys in that process. So foreign attorney charges are higher, and the foreign attorney charges are, many times it happens that the official fee is very low and the attorney charges are high. So prosecution cost of a patent in India, for particularly CSIR, it is no charges because CSIR deals it in-house. Otherwise, the charges would be on the hourly basis or depends on what kind of agreement you are having. Then there is a grant fee for patent. Means India, there is no grant fee when it is go at the grant stage, but at other patent offices, the grant fee is there. And also here you can see the EP. EP is you can see a very big bar because there is a validation cost and a grant fee, and you have to file the translation or in the German and French. That is why this bar for EP is bigger one, because at this stage also you and because the EP represents the group of countries, that is 15 30 countries. So within that countries, if you want to enter and you are expecting that you want to file, because this EP also nowadays is giving a grant very faster, otherwise it was delayed one. Means it depends actually when you want a grant. If some commercial party is there and they want the grant to be seen before they go into enter into agreement, then only you should have the grant. Otherwise delaying process is the very cost. Means not delay on your part, but initiating a examination process, you should delay as much as possible so that you can reduce on cost. Then there is a annuity charges for the patent, which is for India. This is, as at Sonia, this is in US dollars. As I said, it's that for organizations it is different, and for natural person it is different. So one has to see these figures. What I am presenting is as organizations, means other than natural persons figure. So these are the estimated annuity cost. This also includes the charges of the attorney. Then this slide shows the cost at of for each stage expressed as percentage of the total cost. And in this you can see very clearly. This is what I had taken from one research paper, and this research paper was very well written, so I had taken from that. And it clearly shows, and this is true also, that annuity cost means the maintenance cost of the patent cost is around 60% of your total budget for the patent. So one has to see whether you would like to maintain it or not. And why you are maintaining, you should actually maintain the diary, that why you are maintaining it, what was the purpose when you renewed it last time, and whether that purpose has been served when you are taking the decision this time. So maintaining a diary is very important aspect. Then this is the example, because most of the organizations would like to go in European countries. So validation means you can say it as a filing cost in Germany, France, Switzerland, Netherlands. And this again you can see the increasing graph, because all you may say that these are all European countries, then why these bars are more higher for other countries. So again there is a translation cost is involved. Some countries require only the claim translation and some require the full specification translation. Then coming to this validation is renewal annuity fees. This is also one kind of trend you can consider. Then I had taken one example of a patent case, which is which is which was we filed it in 2012, and when it reached 2023, what happened to it in terms of cost? We are not looking in terms of what has happened in terms of the commercialization or whatever technology transfer. What has happened to it, we leave it for this time, for this moment. But we will just focus on what happens when you do these activities. Suppose if you file the application in 2012, the cost of for filing was 4,000, now it is 8,000. The fees was less that at that point of time, 2012, it was 4,000 for natural other than natural person, means for CSR you can say. This is just an example, and the patent specification was having 22 pages, somewhere around 18 claims, and was having 8 drawings. So when it was filed in 2012, it incurred only 4,000 rupees. Now, when you go for PCT application, as I said, in 2000, means after 12 months, you can file the PCT application. So you had incurred a significant amount, that is 2.5 lakhs. And then you file again the demand, and that took around to another 2 lakh rupees. And then the 31 months time, the 30 months time has come up. So you take a decision to file the application in US, Australia. AP means ARIPO country. So ARIPO is African regional countries. So you decide to go into ARIPO. Then in Canada, CA means Canada, EP means Europe. So you decide to go into national phase where you incur another significant amount. Is you see the escalation of the cost of the patent. It is not one time that you incur the cost, but it is as the time passes on, the cost of that patent goes on increasing. So every time you have to take a decision whether you would like to proceed or not. What is happening? What is there? Is it a part of your portfolio, or are you working on that in the same line? And what are your future plans on that? It is very important. So this is only for one patent I am talking about. There are number of patents that the organizations file, like the means patent savvy companies file, and they are doing these activities. So let then there is a EP validation stage that comes in. So and as I showed you in the at the bottom line, if you see here, the US, Europe, and PCT India and ARIPO, the cost was by the 2023 is written down. So you can very well see what happens to the cost factor. So how can you reduce? You can uh, reduce means by some way or the other. You can try to reduce the cost. That can be by the length of your specification, by giving the complete disclosure, and try to see whether the examination wherein you are going go smoothly by complete disclosure, giving the examples not in paragraphs and paragraphs repetitively, but writing it in a tabulation form, then trying to make the figures reproducible clearly in a black and white images. Wherever the technical information which is required in color means uh, color is essential part of the explaining the figures, then only put that figures in color form. That figure should be very clear, otherwise again you will incur cost in particularly in US. If your font size of the labels are not clear, they will raise the objection and the attorney will make money out of it. So everywhere you have to see how you can reduce upon the cost. Then there is a claim section. Earlier, claims are to be very precise and clear. Then write only the citations which are very important and very closely related. It is not a research paper. Research paper should have, you can refer to as many publications as you want. But when you are writing a patent specification, you should put in only those relevant, means directly relevant uh, publications or patents, not more than that. So this is very important because whatever the citations you disclose in your patent specification, US Patent Office will ask the PDF of all the citations. So it is it also incurs the cost. Then timely filing of formal requirement. Uh, this also means if inventor is not, if inventor has transferred or inventor has gone abroad, what will happen is that the formal requirements literally takes time. Sometimes the inventor expires, then you have to find the legal hair. So it takes lot of means time, and that time cost money. Then this is the filing cost in different countries. This is tabulated one, and you can see this means 5 lakhs is this means it is just the filing cost I had shown, not other cost. So you can make out of it. But again, I am telling you, this is the cost of the organization, and the inventor's cost is very less. When even if when you are filing a PCT application, it is having a discounted rate. The 90% discount is given by the PCT authority when you are filing a PCT application. So one should keep it in mind that the rates of the natural person and the non-natural person are different. Then some more avoidable cost would be that the 3 months extension of time, which may be in lakhs, and the continued examination. If the examiner is not satisfied and you are struggling to get a grant of a patent, then there is a process which is never ending. Is that you can file the continued examination again and again and again. So it is a never ending process. Like and other cost also I had shown you. So a renewal review, one can do a renewal review annually, see the state of art every time when you are trying to renew it. What are the new patents in your domain, and whether that new patent has scaled your invention means it is now become non-relevant, or means is outdated one. You have to see it. Then strategic or commercial interest, one has to say. Then performance, cost and benefit analysis. I think every lab of CSI does it. Then market study, and if there are government restrictions on the product you want to launch, if there are, then you have to check out. Particularly for the drug cases we may be talking about. Then in general, we can see here that what is the average age of a patent in force at selected patent offices. This was a data published by the WIPO, and this data shows that not many applicants are interested in more than 10 years. 10 years means government gives you the right for 20 years, but not many people are interested in even for keeping it for 10 years. For in the particularly sector of the electronics or IT, it is changing at a very fast pace. So they are not even interested in keeping the patent for 5 years. But in case of a pharma companies, the pharma companies keep the patent for means 20 plus years. Also means some kind of documentation you have to show that it has taken a long time to get the process, means market penetration approvals, like clinical trial 1, clinical trial 2, then US FDA approvals. That takes lot of time. So the patent offices for those kind of uh, patents which has the drugs, means pharma products API, gives 20 plus protection. Then this is the another slide for this percentage patent renewal trend at patent offices. So this is also showing that not more than 10 years people are interested to keep the patent, because one of the factor is that there is a huge escalation of the patent renewal fee. Then this is the official renewal fee trend, which is also showing the increase in that trend. You can see it, it is a phenomenal increase that happens after the 10 years. So this is the total official fee for renewal, which is paid to the patent offices across world. Then specific strategies, coming down to specific strategies, is that organizations can go for defensive and offensive. As you might have seen the boxing, sometimes the boxer goes defensive, sometimes the boxer goes offensive. In the same manner, the patenting activities also go sometimes the patent are filed to defend your organization goals, and sometimes you have to be offensive, means you have to see for how you can generate the revenue through the licensing fee or initiate some kind of litigations or some kind. And many times the patents are filed just for recognition or to increase the valuation of their organization. Means if you can see, if there is a news that comes in that any the organization had filed a patent, you can see the jump in the in their uh, in the stock market for their company. So it happens on valuation aspect also. And it is the same case when if there is a patent litigation filed by some company to the other company, the stocks will get downwards. So it has a lot of implications beyond direct licensing of a patent or the direct what we can say, the direct benefits of that patent. You have lot many indirect benefits out of it. So early evaluation of patentability is like you have to do it at the research funding stage, the continued monitoring you have to do, and the best role can be played by the for the continued monitoring is that by the principal investigator, that is the scientist, who is very well equipped with the knowledge. He is having the knowledge of the his domain, who is working, which particular research group in which organization are working. They are very well aware of, and their help is required by the organization to decide on how to proceed further. In fact, there are these statistical tools that are available. They means very paid tools are there, but the scientist role cannot be ignored. Then the conduct a thorough prior search and a patentability assessment. Identify any existing patent or the published material that may impact the novelty and the non-obviousness of the invention, and keep track of your competitors, other active researchers. Means some many times it happens that the CSIR scientist tells us that my patent is getting infringed, and you just do something that how we can protect our knowledge domain. So we had filed opposition to the patents coming in by the competitors, and we were successful in defending our territory. So inventors role or the investigators are very important. Then file provisional patent application. A provisional patent application provides low cost initial filing option. Very important. Then it established early filing date and allows you to use patent pending in your invention while you gather additional data or funding for the full patent application. And you can file the NDA, means non-disclosure agreement, with the negotiator or the business partner. So what I feel is that we should not miss the opportunity of filing the application. And that is true that whether you may say that I am not filing in US, the US patent, I know that there is a US patent, and you are thinking in your mind that yeah, there is a US patent, but I want to file it in India, and India will grant you the patent. It is not like that. It is the novelty is seen universally. Even if you are filing in India, the US patent document, whatever is there, will come in. So identify commercial viable inventions, like if you are having limited resources, not every in if you are having limited resources and not every invention may be worth patenting. Focus on innovations with significant commercial potential, as the patenting process can be time consuming and costly. Conduct market research to gauge the demand and potential applications for the invention. So it is best that you can identify some market business partner to fund your patenting process. So this will save on many things, and you will also gain confidence, and you can have some kind of agreements with them. Mutual collaborative agreements also can be done. in that will boost your R&D also. So patents can be expensive, especially when considering filing fee, attorney cost, and maintenance fees. Use all timelines very judiciously. Time clock starts from the date of filing of a patent. Use PCT system. So what can be another things that can help you is that hire the seasoned attorney and delay grant or the early grant, you whatever you want, you should think it means very judiciously on how you want to proceed. If the patent offices are very active, then you cannot delay the grant. But when there is no expedited examination happening, you should not think that why your patent is not getting granted. But if you should think about how you can commercialize, what steps you are taken for commercialization, rather than thinking that why your patent is not getting granted. If you want the patent to be granted, there are the processes in place which can take care of it. But think of the as at the inventor level, you should think that how to commercialize your patent. Granting will come automatically. Then there is a mechanism of refund of examination fee. If let us say that in 48 months, within 48 months, you had filed the examination request, but the patent office is still sleeping on your application and they are not granted it. Now you are thinking that it is of no use that you should have the patent. Then there is a provision that you can get the refund of your examination fee also. But that should be done before the examination touches your application. So deferment of a grant process and no extension fee and no petition should be taken. No late fees should be done. So what are the monitoring and enforcement? So after obtaining a patent, actively monitor the potential infringing activities that are around your application. Review the patent portfolio judiciously. Enforcing your patents is essential to protect your organization's IP right and generate potential revenue for licensing or litigation. So with that, I thank every participant to patiently listening me. Thank you.
Thank you. Thank you, Dr. Jogesh Thoble. So nicely you explained the entire process, process of filing patent till actually it goes for application, commercial applications. So it was very nice. Maybe quickly we can take a few questions. If you have any doubt, we can have little interactive. Anybody having any doubt or want to clarify? Open to you. Yeah, anybody? सब clear है? Students? Understood everything or it's going tangentially?
I tried to keep it simple as possible. I tried to keep it simple as
No, I think it was very simple way. I have a small observation. In the filing process में काफी number आप देखें ना, cost पैसा बहुत लगता है, lot of money. So it is scaring ना sometimes. Why I should spend so much of money? कहाँ से इतना पैसा मिलेगा? Why I should spend so much money? So this kind of, your figures are even, I got little scared, after seeing those numbers. But I think there is other side also. थोड़ा सा एक comment मैं add कर रहा हूँ. Particularly, धोबले साहब has shown that एक defensive strategy भी दिखा है ना, एक defensive है, एक offensive है. Now, offensive जब होता है, पैसा का बात बहुत इंपॉर्टेंट है, आपको रेवेन्यू लाना है, लिटिगेशन से कमाना है, आई स्पेंड मनी आई अर्न, ठीक है, उसमें कॉस्ट बेनिफिट तो बहुत इंपॉर्टेंट है, बट मेनी टाइम्स यू डोंट सी द बेनिफिट व्हेन यू आर इन ए डिफेंसिव मोड. मान लीजिए आपका एक फैक्ट्री है, यू हैव डेवलप सम इनोवेशन देयर, आपके पास एक लेट्स से कुछ मशीन है और रिएक्टर है, कुछ आप उसमें चेंज ला दिए, यू ब्रॉट सम इनोवेशन, आप कुछ नया चीज कर दिए हैं. उस टाइप में आई एम इट्स बेटर आई स्पेंड सम मनी protect that IP, because if I don't do it and somebody copy and do it, वो आके हमारा ऊपर में litigation डाल देगा, then I have to spend money. अपना idea है, मेरा invention है, it's better to spend few lakhs because benefits are in crores. इन बड़ा factory में तो benefit crores में होता है. So it's better to spend few lakhs and protect. When I'm defensive, I don't want to go to business, outside, and I just want to save myself, so that nobody can come and say that आप हमारा patent को copy कर दिए, चोरी कर लिए. मैं उसके लिए defense. So there is a value, na? There is a lot of value in that. It is worth, and I'm mentioning that because in India most of the industries or organizations working in defensive mode. We whatever innovation we are doing, trying to do, at least protect myself. Fast step. Okay, so that is. But if you are in the offensive, you want to litigate others or stop others and all. Of course, you have to earn money and all. So that was, I thought that my one comment I wanted to add, because I was seeing the numbers very scary. But don't get scared.
Yes.
There is also that kind of strategy where you need to go for patenting. Save yourself before you can earn from others. And of course, another thing is that if your intention is image building, or many time image banana bhi bahut badhiya hai na? I have done doing innovations, a lot of things. Organizations go for image building by patenting and all. Because bahar se you students, when you see an organization, you see kitna innovative company hai, kitna flexibility hai, kitna learning hai, all this, you go their portfolio and see, here is an organization having 100 patents. So immediately आपको respect बढ़ जाता है ना. You have a lot of respect for the company, and there is a value to it. जो brand name होता है, उसमें भी value return आता है. So I think those are other side. Why you should go for patent? Don't get scared about only the money part. Okay. Any other observations or anything? You have a microphone. I'll come to you. I'll come to you.
No, I will ask in valedictory session, sir. It will be clarified in valedictory session. That will be okay.
Okay. Yeah. There. First, she is going to ask a question. Wait, I'll come to you.
Good afternoon, everybody. I wanted to ask, while we are in a product development stage, at what stage we are going to file for a patent? After the complete product has been developed, or at the ending stages?
So what I said is that you should file at the conceptual level itself, the provisional application, because your pace of working and the other's pace of working may be different. So as soon as you are near to the reality, you should file the provisional application, and then you can put in a data within 12 months of time, so that the complete application can be filed, because date of filing is very important. The first priority will be awarded to the applicant, those who file the first application.
Also, sir, where is the repository for all the patents that have been filed in the country?
See, it is a national patent office, and it is it dockets it in the time, means time stamp is there. Whatever the application you file, there is a time stamp. So they maintain it, and every national patent office, whenever they publish it on their by the 18 months, means whenever you file a patent, it will be published after 18 months only. So whenever they come into the public domain, there is a time stamp on it. So it declares that this invention was disclosed at this time.
And the repository is available where?
Repository is online.
Online only.
Yes. There are databases.
Okay.
Thank you.
You can take this.
Patent. Most of these patent documents are indexed in patent databases, and they are available online. So you can access those databases and do the search. And apart from that, you have the national patent offices who index and save all these patent documents.
Sir, one more question I want to ask.
how to find out our product worth and which type of grant to be taken?
Product worth.
Yes.
See, worthiness of your patent should be, worthiness of your invention should be seen by yourself. You are the only person who can see the worth of your product. And if somebody market identifies your product to be of the interest, they will come to you. Means say if there is a sweet, the ants will come automatically. So that is the answer we can say.
Thank you, sir.
Sir, my question is that if I filed a patent and someone has occupied it, what is the legal rights for me for defending my patent?
When you had filed a patent, it is already protected. You know, if you are the first filer, then you are already protected. And somebody, if he is trying to work on your invention, means patent, means he is trying to infringe your application, then you can file an infringement suit on it.
Yes, sir. Okay, sir.
So whoever has filed first, he has the right.
Yes.
So you have the legal hand. Means the government has given you the legal.
Sir, some advocates will also given by the government, like public prosecutors. Which
Public prosecutors, there are patent special attorneys that handles you and that can take care of it.
Okay, sir. Thank you, sir.
आफ्टरनून सर। सर मेरा सवाल ये है कि जैसा कि अभी सर हमने देखा कि मैक्सिमम या मिनिममली 20 सालों के लिए पेटेंट होता है सर, और सर आपने अभी भी बताया कि रिन्यूएबल प्रोसेस भी है। तो सर क्या मान लीजिए सर कि जो मैं 20 साल के बाद एज अ पर्सन जो भी इन्वेंटर हो, डिस्कवरर हो, वो 20 साल बाद ना रहे तो उसका पेटेंट का क्या होगा सर?
20 साल, देखिए जो राइट्स होते हैं ना, वो राइट्स होते हैं वो असाइनी के पास होते हैं, है ना, कि जो भी उसका राइट होल्डर होता है, अगर वो मर भी जाता है तो उसके जो लीगल हायर्स होते हैं ना, उसके पास ट्रांसफर होते हैं और वो रिन्यू हो सकते हैं। ठीक है
सर, तो रिन्यू कौन करवा सकता है?
रिन्यू तो उसका लीगल हायर करेगा ना फिर।
सर अगर उसका लीगल हायर कोई ना हो, जैसे माइकल फैराडे का
नहीं, देखिए अगर रिन्यू नहीं करेंगे तो लैप्स हो जाएगा, पेटेंट खत्म हो जाएगा। फिर उसके बाद जो बचता है वो ये बचता है कि वो पब्लिक डोमेन में चला जाए, देन एनीबॉडी कैन प्रैक्टिस दैट इन्वेंशन। देयर आर लॉट ऑफ इन्वेंशंस दैट यू कैन प्रैक्टिस व्हिच आर ऑलरेडी इन पब्लिक डोमेन।
ओके सर, थैंक यू सर।
ठीक है।
Yeah. Any more question? Or feeling very hungry? Okay. Okay. So what we'll do, we'll continue this discussion because we have to go for lunch. We'll take a break right now, and we'll come back after lunch and continue this session with Madam. Okay. It's okay. Fine. You want to make some? Yeah, one
submission. Those who are scared about the funding, the 60 lakh rupees cost for filing in different countries and filing in India, need not to worry about that. Have your food, enjoy. There are sufficient funding agencies to bear the cost of filing of your patent in India and abroad also. So not to worry about before your meal. So be relaxed. There are funding opportunities there. I will brief that later in my presentation. In fact, for Indian filing, we are here for you. And this 60 lakh is cost for our CSIR scientist here, not for you. For you, it is free, completely free.
Thank you. I think feeling very relaxed now.
So I stressed upon everything.
Okay, great. So let's have the break now. So lunch is here. All of you are invited for the lunch. Yeah.
Yes, sir. दिगवाड़ी से आए हुए सारे HOS HORG सभी का लंच, और यहाँ भी जो HOS HORG हैं सभी का लंच गेस्ट हाउस में है, और रेस्ट सभी का हमारे ऑडिटोरियम के बाहर में।
Thank you.
And guest also.
প্রেজেন্টেশন একটা হয়েছে, হ্যাঁ ও আসুন, পেন ড্রাইভ দেবে তো
না না আছে এখানে।
ম্যাডামে ম্যাডামে হ্যাঁ ঠিক আছে, कल बस इसको है ना, इस वाले दूसरे होने दीजिए।
हेलो हेलो, नहीं आ रहा है। हेलो हेलो, हेलो।
Hello.
Hello.
After the break, once again, welcome to all. Uh, I would request Dr. PK Banerjee sir to and Dr. Yogesh Dhoble, sir. Dr. Shivkami Dhula, please come up on the stage. Now I would request Dr. Pallav, senior scientist of this institute, to introduce the next speaker.
Namaskar. Good afternoon, everyone. I feel extremely privileged to introduce our next eminent speaker, Dr. Shivakami Dulab, Senior Principal Scientist from CSIR Unit for Research and Development of Information Products. Dr. Shivakami Dulab has over 20 years of experience in providing patent analytics and techno-commercial information services, especially in the field of pharmaceuticals, chemicals, and process industries. Dr. Dulab has completed her PhD in information sciences with a focus on non-obviousness criteria required for patentability. She is the holder of double PG diploma in patents law and chem informatics. She is also a master's degree in chemistry from Pune University and has cleared patent agent examination. She has received multiple accolades and awards, such as the SIS Young Information Scientist Award in 2009, and is also the recipient of Innovation Challenge Awards from London twice. She has to accredit a large number of publications related to patent analytics and chem informatics. Some of her other notable contributions include building subject-specific databases. We are really lucky to have you with us, ma'am, and I welcome you once again, and kindly enlighten us with your lecture. Thank you.
Each down है ना? एक ही व्यू चाहिए, एक ही व्यू चाहिए.
Thank you, ma'am, for introducing me. And a very good afternoon to our chief guest and our head UDIP, and to all the invited speakers, scientists from SIMFA and students. So I understand the whole session is going to be a bit difficult, but I'll try my best to keep it a bit interactive and try to be brief and explain you for whatever I have come here. So in the morning session, we have seen that our head CSR UDIP has already made the job a little bit easier. And how we have supported them right from when they have conceptualized the invention to reduced it to practice, and we have helped them in filing the patent document. So I'll take you through this case study, and I hope it should be useful for the scientist from Dhanbad, and for the students who are from the science and engineering background. I hope that it will also be helpful for you to understand that what is the job of a patent analyst like us, and so that you can pursue your career in IP. So I think you can also have some takeaways like what we have for some of the scientists. So as I've already told, our head has very nicely explained the details of making a homework or the patent informatics work. So I'll try to be brief and tell you what we have actually done at the ground level to help the scientists. So I'll go into the definition of what is patent informatics, what are the different types of searches, why we have to do these different types of searches at what stages, and how we do it at CSR unit. Then I'm going to illustrate the applications of these analysis to a case study, which we have done for our own CSR lab, and how we have, helped them to protect the invention, also to transfer their technology to a company. And apart from the patent analysis, now under the leadership of our new head, post 2018, we have also initiated the work of techno-commercial evaluation. We have learned it through the guidance of our head, and we'll try to explain you how we do it and what is its importance. So as we have already seen in the morning session and from our IPO scientists, that in any setting up any R&D or a business unit, it involves a lot of cost. Okay, so most of these decisions of whether you have to invest in a research or not, or whether you have to invest in a business unit or not, most of these decisions are based on analyzing a lot of information. And this information is not only huge in volume, but it also includes different types of information. For example, scientific literature, it involves patents, it involves import-export data, and also some predictions from computational analysis. So all this kind of data is usually used to gain an insight or take an informed decision whether you have to invest in your research or not, or into a business unit. So all this kind of, and in using all this kind of analysis, there are different stages. In the first stage, you have to use this patent analysis mainly to find an opportunity, an opportunity which you can actually start your research and development. And once you start your research and development, it should yield some products or technologies which can be protected by valid and enforceable patents. Once you start your research work and you come up with some process or technologies, you also have to ensure that you have to benchmark your products or process against some processes or products which are already existing in the market. So using this patent analytics or using this kind of analysis, you can also benchmark your invention with what is already existing. So once you develop it, you protect it, the game is not over. You also have to ensure that your product or process is not infringing anyone else's intellectual property right, because we have seen, like our head has already told, that the damages are quite big. So that is why you have to, conduct these kind of analysis. Sir has also explained this, but let me tell you, at a research level, scientists as well as academics, you read scientific literature documents and review articles. But let me tell you that 80% of the technical information, they are disclosed in patents. And we have already seen in the morning that the patent documents are very structured documents. They are indexed in searchable databases. So you don't have to worry about the searching part. We are here to help you to how to search these documents, how to retrieve them, and how to give you the relevant information. So that is our part. You don't have to worry about that. So using this patent information, it is not only used to find out whether your invention is patentable or not, but you can also find out that who are your competitors, where are they filing the patent documents, what are the trends, what are the emerging applications. And many a times you can also find out that if you already have your products, you have your materials like catalysis, polymers, you can also find out that what are the new applications of using this patent analysis. You can also find out what are the new applications for your materials or polymers or product or process. So that will help you in getting newer market segments. So as Sir has already explained, that patent informatics, analyzing patents is an art, it's a science. So I'll just read the definition for you. Patent informatics is the science of analyzing patent information to discover relationship and trends that would be difficult to see when working with a document on a one-to-one basis. So we are here to do it. Basically, you have to do a patent analysis or do this kind of study, not at the end, but you have to do it very much when you are in the initial stages of your R&D, or what we call as you are even planning your R&D, you have to do it at that time. And you also have to continuously monitor the patent information
not only patent information, the new scientific literature, the products which are there, the market data. You also have to continuously monitor while you are doing your R&D from the concept to reducing it to practice, and then when you are targeting a market. These are the different scheme of analysis which sir has already explained in the morning. So what I will do is, so state of art, patentability assessment, freedom to operate analysis are the different analysis. While going ahead, what I will do is try to explain you what is a detail about each type of analysis, when you have to do it, and what are its applications. And as I've already told you that under the initiative of our new head UDIP in 2018, and very recently, we have also started working on techno-commercial analysis. So going forward, I will just give you a brief on that and how it has benefited some of our labs. So state-of-art analysis, as it says, that we do a complete survey of all the patents, literature, and products in a particular area. And we try to give you all the information when we do the search analysis and try to give you an information so that scientists should not invest a lot of their time in reading so much of patents. For example, because we are here in this lab, you will understand the technology of fly ash processes. So fly ash is something, the particulate matter which comes from the coal combustion. So one of our lab had asked us to, they wanted to see that what are the existing prior art in this area. So when we just did a simple search, we saw that there are around 2,500 plus patent documents in this area. So we analyzed all the patent documents just to give them an overview that how these fly ash particles are used to convert them into useful products, different types of products, and what are their applications. So that becomes a very broad technology landscape. But if you have to go a little bit in deeper, you have to find out and tell us that out of that, so many applications, what are you looking at, so that we can drill down the data, refine the analysis, and give you a better picture. So one can be technology focused, or it can also be a company focused analysis. For example, in the fly ash technologies, process technologies, there are many companies who are already filing patents, and they are there. For example, you have Halliburton from USA. Then our own Indian companies, you have Birla, you have Reliance, who have patents protected in this area. So if you feel that they are the competitors, or you want to find out what are the technical areas they are focusing on, you can also ask us to analyze a company-specific portfolio where we do the analysis and we can share it with you. So we do the search using our own search strategies, which can include keywords. Like if it is chemistry, we use the chemical names, we use the CAS numbers, we use structure search. So we incorporate different types of data, which is defining these materials or compounds, and try to build on the search strategies. As sir has explained, that we give a broad overview on a broad picture for you of what is the existing technologies or what is the existing technical area in this part. And then we try to refine and give you a specific trends. So most of these analyses are presented by graphical analysis, so that again, it becomes useful for the scientists to get an overall picture without wasting or without investing much of their time in reading these documents, because that is our work, which we do it and we give it to you. So a state-of-art analysis is important when to identify opportunities so that you can plan your R&D and initiate your work in that. It also gives you a general trend and how the technology is moving over the past few years and how they are emerging. Then you have the most important part, the patentability assessment. Sir has already told that it involves a lot of cost. The prosecution involves a lot of cost. Not only in India, of course, it is less for the academics, but if you consider organizations like CSR and industry, it involves a lot of money. So it is important for us to do the pre-filing homework so that we give you an information of whether your invention will be patentable or not, and it can also reduce the prosecution time, that the number of interactions that you have, office actions you have with the patent office. So there also you can reduce your money. So our objective is to help you to file your patent with minimum time and less of cost.
So when we get a patentability request, we try to understand the invention. We try to give you not many patents like in a state-of-art analysis, but we try to refine the search and give you only those relevant documents, maybe 4 or 5 to some extent, so that we also identify what are the differences between your invention and the prior art, so that when we give you the differences, it becomes easy for you also to identify or interact with us to tell that in addition to this, there are more differences, and together then we can assess it for the patentability. So that is what we do for the patentability assessment. Then we have a freedom to operate analysis. So after you file a patent, in case if you want to transfer your technology or license your technology in cases of CSR, or you want to manufacture your thing, you have to ensure that you have to conduct a freedom to operate analysis. You might have come across, for the students, you might have come across this picture very frequently, which says that you cannot enter into somebody else's property. If you enter into somebody else's property intentionally, then you are liable for punishment. So in a similar way, intellectual property also has a similar meaning. You cannot use somebody else's intellectual property. You cannot use, manufacture, sell, or export a product or a process that is already patent protected by somebody else. You are liable for infringement, and that third party or whoever's the owner of that patent can sue you. So it's important to conduct a freedom to operate analysis. Usually it is conducted before a company tries to launch their product in the market. And for organizations like CSR, we usually transfer our technology or license our technology. So it becomes important for us to conduct an FTO analysis before you transfer your technology. Many a times it's not only for that. When we do an FTO analysis, we also tell you that these are the potential patents which are blocking you. So that 1 or 2 patents you can read. You can also try to design around your invention and try to come out of that invention and still have a freedom to operate. So based on these are the different types of analysis which we do at URDIP for all the CSR laboratories, and even for academics, we can help them, of course. So basically, the outcomes of these searches is, as I've already told, for state-of-art analysis, it's not the big white space, but what we have learned in the past few years is we try to give you the low-risk opportunities where you can actually plan your R&D. Then we also try to give you that what are the patents which are already protected, what is the space where you can try to have a freedom to operate. And of course, we also give in the market information to say that where your inventions can have a market segment. So what I will do now is, after going through a brief of what are the different types of searches and how we do it, I'm going to take up a case study where I will illustrate how we have used these different types of analysis for our client and help them not only to file patents, but also to have a demonstration of a pilot plant like they had an FTO also. So just for all of us to be on the same page, I'll just say that DME, dimethyl ether, this is an alternative fuel which is usually used in internal combustion engines, and it has some properties which are better than our traditional fossil fuel. So just for understanding for this session, I'll not go into the deeper analysis, but we just have to know that DME, the dimethyl ether, it can be synthesized from three different sources. You can synthesize it from natural gas, you can synthesize it from synthesis gas, and you can also produce it from methanol. So one of our lab who wanted, it was a mission project, so we had to handhold them right from the beginning to a stage where they can, whatever they have envisaged to the mission project, because a lot of money is being invested in the mission project. So we try to assist them throughout the project. So first time is they just wanted to know, let us see that what are the existing patents literature in this area. So when we just did a search using our own methodology of keywords and patent classification codes,
we got to know there are 2,000 plus patent documents only for the production of dimethyl ether. So you can imagine that how crowded the space is. And now you have to find an opportunity from this crowded space. So what we do in a state-of-art analysis is we knew that the team who was working in this area, they were focusing on the catalyst technology. They wanted to know what their work was on catalysis. So when we analyze our patents, we try to find out what are the different catalyst systems which has been used for producing this DME, what are the different sources which has been disclosed in the patent documents or scientific literature. We try to classify the technology based on the chemistry. We also enlisted that who are the competitors in this area and what are their focus. So this is a broad picture. If you remember in the morning session, sir had showed you all a helicopter picture, which shows you a broad landscape. So this 2000, categorizing it, reading the documents and categorizing it, this is a broad overview, which we have given to the scientists at a first level. So many of the patents are focusing on catalyst, of course. There are many patents which are focusing only on the processes. There are some companies who are focusing on how to come up or produce DME and also to get another byproduct which is industrially useful. Some of them are focusing only on reactors or the reaction equipments. So you can see that these are the different focus of the patent documents. We try to search them, analyze them, and give them this kind of category. So when a scientist looks at it in this area, he gets an overview that this is how the patent documents are there. It's the focus. So now if you come and tell me, I just want to have a detailed analysis on what are the catalysts in this area. So I will go into the catalyst thing, and then as a next step, I'll give you a second level of analysis. So here in this case also, the scientists wanted to know what are the different catalyst systems. So we try to analyze the catalyst much more in detail so that we can tell them what are the catalysts which are there. So if you can see, I'll not go into the details of the chemistry part, but overall, I think the students can also understand if they have studied chemistry a little bit in their academics. So you have the metal oxide based catalysts, you have zeolites, you have composites. So these are the different catalyst systems which has been claimed and documented in the patent document. So now when the scientist has a look at this graph, they can now tell me, okay, we are interested in metal oxide based catalysts. So can you give me as a deeper analysis into that so that we can see that what are the different metals, what are the combination of metal oxides disclosed in the patent documents so that they can plan their R&D activity. So in the next level, we also told now, in case if you're looking at a larger picture of you're not only making the catalyst, but you also have to give the best operating procedure, the process, because your catalyst together with the process and the reactor, if you package it like this for your technology transfer, that would be a better strategy. So apart from the catalyst, we also gave them the overview on what are the different reactor systems which have been documented. So if you see, there are fixed bed reactor, tubular reactor, what was the design of this reactor? So we have tried to map them, what is the catalyst and what is the combination of the reactors that have been disclosed in the patent documents. Then we also gave them that who are your competitors in this area and what are the type of catalyst systems they have patent protected. Then as we have seen that this fuel DME can be prepared from different sources. So even the patent documents who are disclosing the catalyst, the process, they are specific to the starting materials. So when we try to map that, we have seen there are a couple of patent documents focusing on the process technologies for the conversion of methanol to DME. There are some only focusing on syngas to DME, and of course there are other mixtures of compounds. So here the scientist was now interested in, because they wanted to convert DME from methanol. So now if you see the matrix, we have only 50 plus documents from methanol to using mixed metal oxide catalyst. So now from a larger data of 2000 records, we have drilled down to around 50 plus documents, which is sufficient enough for us to do an in-depth analysis and give a detailed overview on what are the catalysts, what are the metals, metal oxide, what are the combinations that have been disclosed, that have been claimed, so that you can orient your research accordingly. So that is what we have given, and based on the state-of-art analysis and based on the information that was given to us from the scientists, it was useful for us to tell that if you are working in the area of mixed metal oxide catalyst, specifically from methanol, yes, the area is little bit less crowded, but there are still some patents which we have to look into detail before you plan your activity. And suppose if you are focusing not only in DME, but if you are focusing on achieving one more industrially useful byproduct, then you literally have a space in that. So at the next step now, when they know that there are 50 plus documents which we have to go in detail, you as a scientist will have to give us the information of what are the metals that you are working in, because unless and until you give that, we cannot refine our search to come. And that is why, when sir has also mentioned in the morning session, the discussions with the scientists help us to give you the relevant information. Otherwise, giving a broad information is not our job actually. Okay, so in the next step, the inventor had done little bit of experiments, and at least they knew that in mixed metal oxides, what are the possible metals they are going to incorporate, so that they can start with their process. So they had given us the specific metals, metal oxide, and if you see, they had given 20 different compositions. So we had to do a search for 20 different compositions, which is a combination of different metals, transition metals, alkaline earth metals. So when we get this kind of composition, for us to search, we don't focus on just molybdenum or aluminum. We try to reorient it and try to classify that, okay, molybdenum, it falls into a transition metal. So instead of seeing what is protected in only on molybdenum, we also go a little bit away to see what are the other transition metals that are already protected for this area. So this is nothing for you to worry, but just to set the flow, we use different keywords which is relevant to the topic of interest. We use the chemical abstract registry numbers. Then we use the patent classification codes, which is specific to every technological area. So we use a combination of these keywords and patent classification codes to retrieve the relevant document and to analyze them further. You don't have to worry on that, because we will do this for you. So now when I'm looking at only the catalyst compositions having these kind of metals, so I'm not looking only at molybdenum, but what are the other transition metals that have been protected by patents and for producing DME from methanol. So we try to see that what are the patent documents that are disclosing all the relevant concepts, and try to give you a picture on these are the elements which are already covered into a mixed metal oxide composition. So naturally, when the scope is this, okay, the scope of what is available for you to protect naturally becomes a little bit narrower. So from this, now we have to identify what would be the scope of your protection to for the protection. So now, because they have given ranges and all the metals, so what we have learned in the last few years, and specifically under the guidance of our new head URDIP, we have learned is you have to ask specific questions. If you have seen, sir has multiple times, he has told you have to focus on the questions to be asked to the scientists. So when we get a broad information like, just what are the metal oxides, we try to ask more questions to the scientists, like what are the exact proportions, whether there will be some specific surface area, the particle size of your catalyst, which is contributing to the final quality or the separation of DME. What are you working? Are you using the same reactor, which is usually known in the art, or are you making some modifications to the reactor also? So these are the questions which we try to ask the scientists. Many a times it is there with them, but it is not shared with us. That is what we have realized. But in some cases, the scientists are so proactive, and even when we ask the questions, they also understand, yes, this also could be a other dimension which could be useful to be evaluated. So in some cases, they tell us, we will give us some time, we will go back to our experiments and we will do it and we'll come back to you. So we also give them some time to give us the data to us so that we can give them a better opinion. So when we ask them, so with all the details, when it is shared with us, then we try to refine our search and analyze only that set of patents which are very critical. And this is the matrix which was shown to you in the morning session by our head also. So this is the level of analysis which we do for each patent document. We read the full text and try to map each of the features with respect to the prior art. So here, after we told them that there are some patents on the reactors also, literally they felt, yes, they also have some modifications they have done to the reactor. So apart from the compositions, they also requested us, can you please have a look at the reactor systems involved in this? So they just gave us a design on a plain paper, which was difficult for us, when we get information like that, to do the search. But because we have our own way of doing the search, building the search query, based on that diagram also, we try to give them the relevant information. So they were just thinking of some conical shaped reactors for this particular process. So even before investing into fabricating the reactor, they said, let us look into the details, because by the time we did the analysis for them in the catalyst area, they also came to know how we can support them, or what kind of analysis they have to get done from us. So in the second step, before us, before we told them, they came to us to tell, can you look at what are the reactors in this, so that we can work on the reactors also. So after we do the invention, if you remember, like sir had also shown in the morning session, our main important work is to identify the extent to which your invention overlaps with the prior art. That is the first point. And the second point is, the main point is, we tell you what are the differences of your process, of your composition, of your invention with respect to the prior art. So when we give the differences like this, so now if you can see, earlier when they gave us the information at the first level, we just had the broad catalyst composition with broad ranges. But now we have a specific composition with the specific ranges defined, the properties of the catalyst which are having a final effect on the production of DME. Then they also have the byproducts defined. They told us along with DME what is the byproduct. So that also becomes an important part of your invention. And of course, the role of the different components, or the role of each metal oxide which is going into the catalyst. So to this level, if you give the information, we also try to search and try to point out the differences as much as possible. And in the last, I'm into this field for almost last 20 years. But let me tell you very frankly that when we have, under the guidance of our new head, Yurdip, because we were made to ask this much of questions to the scientists. So that is when we have gained this new set of analysis, where we keep on asking the scientists. And when we identify the differences, we share it with them so that they are also on the same page with us. And many a times we have observed that scientists give us some more information, which naturally adds to the invention. So all these things, then with all this much of information, we try to do and just do a recheck of whether all these elements which are important perspective of the invention, whether they are claimed or not. And if and then we try to, so for this case, we have identified the composition is new, the applications of getting DME along with a byproduct is new, the process conditions is new, and of course the reactor design which they have fabricated based on the information what we had given to them, they also had some novelty in that. So based on all these things, then we apply the patentability compliance, the patentability requirement, to say whether your invention is patentable or not. That is, in this case, it was new, it was non-obvious, or it had the inventive step, and of course, industrial applicability was there. So we could straight away tell that your invention is patentable, and then you can file. So this is the full procedure what we do just to do a patentability assessment. And our head, we are fortunate enough to get a protocol like this. And now we usually did not have it earlier, but now we have a specific protocol with a specific set of steps to be followed from our end. And this is what we follow so that we do not leave any space and we are able to comment whether your invention is new or not in a very straightforward way. So for the same case, they, based on our analysis, they filed for a patent. Simultaneously, because it was a mission-oriented project, they also wanted to do a freedom to operate analysis. So just because during the patentability stage itself, we interacted so much, we had all the data with us, little bit more data which we wanted to do a freedom to operate analysis, that also we took from them. And let me tell you, freedom to operate is a very, we cannot do it for all the countries. You have to tell us that what countries you are interested in. For in this case, they wanted to do the operations in India, USA, Malaysia, Iran, and Iraq because it's a fuel. So we restricted our freedom to analysis only to these countries. You cannot do a global FTO because it becomes very difficult. So usually in FTO, we ask you what countries you want to do a freedom to operate because we have to go to that specific countries and see whether the patent is protected or not to give you an opinion on whether you have a freedom to operate or not. So because during the patentability analysis itself, we had lot of information. We needed some more information which actually goes into the process. So this is the kind of information which we collated for a typical freedom to operate analysis. We considered everything. What is the distillation column, the reactors, where, at what place, at what is the position of the your catalyst bed, and all the parameters, dimensions of the reactor, everything we considered to do a freedom to operate analysis. So when we did that, we did not find all these parameters were not disclosed in any granted and enforceable patents. So for a freedom to operate analysis, we have to find whether your invention, whether your process or your catalyst composition is protected in any granted or enforceable patent. If it is not, then you will have a freedom to operate. So in this case, there was no granted patents, enforceable patents, so they could have a freedom to operate. So we did this homework with the scientists for almost one, and I'm showing it to you in a presentation like this, but we have continuously worked with the scientists for almost 1.5 years in this project at least, and sir had given us a lot of inputs. Sometimes our being head of the organization, he also has met with these scientists and asked the relevant questions. So that has helped us, to take this invention at this level and get the information from the scientists. So the patent, it was filed with all the elements which we could tell them that these are the new features of your invention. And it was published and it was granted also in 2020. So you can see that it took a very short time. The prosecution was very smooth. It took a very short time because we did so much of analysis. Because we did the FTO, they also could demonstrate the pilot plant for this, which was inaugurated by our minister at NCL Pune. So it's like sir has always emphasized that your earlier inventions should lead to new inventions. In this case, because there were some PhD students or research scholars who were interacting with us. So because they were interacting with us so much, they also, apart from the scientists, even the research scholars or research associates, they also came to know how to use the patent information. So by the time we finished the first process, they came to us for a new invention, which is related, but for a new invention. So we did the same process, and they could file a follow-on application for the same catalyst area. So they could get a different patent also. So this is what we do in the routine analysis, which we have done all these years. And as I've already told you, now many of the industries and organizations like CSR, they have mandated the techno-commercial evaluation report for your invention before you file your application. So under the guidance of our head UDIP, we add learnings from, sir has given us a protocol on what are the different aspects on which you have to do a techno-commercial analysis. So we have a toll-gated approach, which I'll not go much into detail, but we try to understand the different encumbrances, like, for example, what are the techno-legal liabilities of your invention? What is the transformative impact? If you have a market for this, we try to look into the market data and then try to do the technology value proposition. Actually, it has a lot of parameters which we look into details, but I'll not go into the how we do it for this. I'll not take it right now. But yes, I can share some of the benefits for where we have done the commercial analysis for some of the labs in the last 1.5 years. So in some of the cases, we could tell them that a similar invention like yours has undergone a lot of prosecutions and it was not very smooth. So we could tell them that even you are going to face these kind of encumbrances. So you have to be cautioned, or we try to give them that kind of analysis so that they can, reply to the office actions. Then for the transformative impact, we try to tell them that at what level you are, your invention is a very basic invention, and you have to develop or try to invent around and go to the next stage if you have to launch a product in the market. And then, of course, for the market fit, we have a lot of paid databases, which gives information regarding the market data, export-import data for different technological areas. So we try to give them who are the potential companies who could, for whom you can approach to license your technology, who are the manufacturing companies. So all this kind of information we try to give in a techno-legal analysis. So based on the this is a usual protocol which is recently followed across CSIR. So you come to us for a patentability search. If we say that your invention is patentable, you can file a provisional application. Once you file the provisional application, then again you have to come to us for doing a commercial evaluation report. So after your filing and when you try to give your claims in detail, before filing your complete application, you should come to us at least 3 to 4 months before in order to do a complete techno-commercial analysis for you, because we also need a little bit of time. So the key summaries and takeaways for today is, like I've told you, we have been in the last 20 years, 10 years we have spent in teaching or, telling the scientists to start using the patent information. But in the last few years, under the leadership of our new head, we have tried to incorporate a systematic analysis, a protocol which is given to us by our head URDIP. We are going to the next stage where we try to implement this type of systematic analysis, going into the detail and give you inputs. So for a state-of-art analysis, we try to give you not a big white space, but a definite opportunity for you to plan your R&D. Then patentability assessment, you have seen how detailed we go so that we can identify the differences for you. And finally, it will lead into a filing for a patent application. And we also do a freedom to operate analysis. So all this kinds of analysis is the necessary homework which you have to do right from the time when you conceptualize your invention and up to the filing stage. But in case if you have not come to us, if you have not done the homework, we have the techno-commercial evaluation protocol to be followed. In many of these cases, we try to do all this analysis before filing the patent document by doing the techno-commercial analysis. So this is what I have. And I take this up before going into the questions. I take this opportunity and this kind of forum to thank our head URDIP, who has given us not only URDIP, but he has given the whole of CSR a definite protocol to be followed for patentability as well as a techno-commercial analysis. So I really thank our head to give a systematic way of analyzing this document so that it can, so that we can support you in the right way to file, not only file your patents, but also to say whether it has a freedom to operate. And in the TCE reports, we also tell you whether it has a market or not. And I also thank SIMFA director and the organizers, specifically Sujan sir, to give an opportunity to invite me and give this lecture. Thank you so much.
Thank you. Thank you, ma'am. It's a excellent presentation. Only I have noted that homework is tough. So you may be thinking, I do something and just go and file a patent. But there are a lot of, homework to be done before that. A lot of analytics to be done. Pat informatics, what you refer. But again, like previous talk, also don't be scared. There are people to help you. Yes, so ma'am is there to help you. Okay, so any question, quick question, one or two? Yes.
As the ma'am has suggested, and we have enjoyed all the sessions of patents. But sir, in our country, India, we are talking about science. Whenever we have studied the science from class 1 to 12, we have CSI or not Central Institute is doing great job, sir, for nurturing young scientists. But sir, what the CSIR net and SIMFER will go to the state university, which are lack of resources from anything, sir, because the research is not doing in our country, sir, in state government university. Central institutes is well done. They are doing research. But sir, our state university, what the SIMFER will done for the future? For nurturing our young talent, because the talent is if go sir, I also study the human resource in economics, because sir, human resource is the most valuable resource in the world. As a student of geology, if I have not knowledge how to extract the coal and how to make it a profitable for the economy, how will the sir new institutes will encourage the young students from the state university, so the sir new patents will more and more come, sir.
You want to respond to that? Yeah.
Tell you that even at the student age, if there are, because we are situated in Pune, we also give an opportunity for the students to share their project work. They come to us while doing their summer project.
Yes,
so we sometimes we try to do it for you all, or even you all can come to UDIP to get a hands-on training on this kind of analysis. And if you share the inventions, we do it for a lot of academics and college and professors who are guiding you all. So we also help them to file the patents, do this kind of analysis.
Yes, ma'am.
Talent.
Thanks, ma'am. Thanks, ma'am. Okay, ma'am.
So without knowing the details, I cannot tell you right away, but of course you can just drop in a mail to us in whatever way.
Or the new patents which are coming in our country, government is also providing the economic support if the person have no any financial resource and they have the sense of doing any invention for the country. So what the government will provide them when you discount in the price of the patent, or the talent will go waste. Yes, ma'am. Yes, ma'am. Yes, ma'am. Yes, ma'am. Thanks, ma'am.
Yeah, I think we are going to cover some of this. Only I'll just add, this CSIR has a program called Jigyasha. There's a program called Jigyasha, where CSIR laboratories are reaching out to the local institutes, state institutes, colleges, and schools to promote this research, the basic research, how that can be promoted, how to generate innovative new ideas, how to help them nurturing those ideas into a product. So those are the kind of initiative across CSR labs you will find. And those were around Simpa Dhanbad in this belt. If you have this kind of help, any ideas you feel like needs a help, you can approach to Simpa. This institute, you come straight to the director or our HRD head. Definitely, you are going to get a lot of help. Simple side. Okay. Any other questions?
Good evening, madam. I'm Dr. Sudarshan Singh Rathod.
Actually, I am working in pharmaceutical and various products formulations and all, and basically targeting these microbes to extract various valuable products or active biocompounds from the microbes. So many times what we are getting that if any compound what we are getting that is already published or that is already done by the any chemist which is published. Now in that case we can't patent that molecule, but is this possible we can patent that mechanism or a mode of action of that molecule in the patent form? Is it possible or not?
Mode of action per se cannot be patentable, but through that mode of action, are you looking at a pharmaceutical use?
Yeah.
Yeah. So mode of actions cannot be claimed, but if you have the final pharmaceutical use, like for which therapeutic area those compounds are useful, you can protect the new use of that compounds, or the better option would be that you make a formulation comprising that active molecule, and the formulation can be patentable for that therapeutic use.
Okay. Only formulation is possible.
Formulation can be patentable because the molecule is already known.
Yeah.
But if the molecule is not known for that use which you are claiming,
yes,
then you can have a new use only in US and Europe. In India, you cannot file a patent on new use of known substances.
Okay.
But alternatively, if you have, because that's an active ingredient, right?
Yes.
You cannot just consume an active ingredient.
Yeah.
You have to formulate it in such a way. It could be a tablet format. It could be an IV injection with suitable excipients. So that will contribute to a formulation, and you can always have a formulation.
Okay. Yeah. Thank you.
Thank you. Come this side.
सर मेरा दो सवाल है सर। पहला सवाल ये है सर कि सर माय नेम इज आकाश कुमार मिश्रा एंड आई एम फ्रॉम BBMK यूनिवर्सिटी डिपार्टमेंट ऑफ जियोलॉजी सर। सर हिंदी में सवाल पूछ सकते हैं सर? सर सवाल पहला ये है कि सर मान लीजिए मैम, अगर मैं अपने दोस्तों के साथ ग्रुप ऑफ फ्रेंड्स के साथ सर मैं कोई एक इन्वेंशन के लिए कुछ भी या डिस्कवरीज के लिए सर पेटेंट करवाता हूँ, और सर कुछ सालों के बाद हम दोनों में या फिर हम लोगों में विवाद हो जाता है, तो ये सर पेटेंट के रिगार्डिंग अगर कुछ करवाना चाहें कि अगर मान लीजिए मैं बोलूं कि ये पेटेंट मेरे नाम पर है, वो बोले कि नहीं मेरा है उसमें, तो सर इसमें फुल्ली मतलब कि किस आधा शेयर होगा या फिर जितने लोग हैं उस पर शेयर होंगे? यही सर पहला सवाल है सर।
बिल्कुल, दोस्ती अच्छी है, मित्र साथ में काम करते हैं, बाद में पार्टनरशिप टूट जाती है, सिप ही है, टूटती ही है। तो इसमें क्या होता है, जब आप पेटेंट फाइल कर रहे होते हैं तो कानून में जब आप फाइल कर रहे होते हैं तो आप सब इक्वली पार्टिसिपेंट्स हैं। जैसे आपने साथ में मिलकर काम किया, आप 5 लोग हैं तो डिवाइडेड बाई 5, आप 2 लोग हैं डिवाइडेड बाई 2, इसलिए हम उसमें कहते हैं इक्वल पार्टिसिपेंट्स होते हैं। जब आप उसमें आप इन्वेंटर्स एंड एप्लीकेंट आप फाइल कर रहे होते हैं 5 दोस्त। लेकिन एक दूसरी बात आपने बताई, आपके दिमाग की उपज से कोई नई चीज आपने बनाई तो उसका जो स्वामित्व होता है, ओनरशिप, वो उस इंस्टीट्यूट की होती है। तो अब आपकी जो फ्रेंड्स की पार्टनरशिप थी, टीम थी, ओनरशिप तो इंस्टीट्यूट के पास है, तो सारे डिसीजन अभी इंस्टीट्यूट के पास ही है। तो आप उस केस में अगर आपकी ओनरशिप इंस्टीट्यूट के पास है, आप पूरी तरह से सुरक्षित हैं। लेकिन जब आप ये इंडिविजुअल कैपेसिटी में फाइल करते हैं, 5 दोस्तों ने मिलकर फाइल किया, फिर उसके बाद एक इन्वेंटर उसमें से अलग हो गया और वो कहता है कि मेरा था, मुझे भी इक्वल मिलना चाहिए, तो वो पहले जैसे आपने पार्टनरशिप करी थी उस हिसाब से आपको अपने फायदे और नुकसान में बराबर ही देना पड़ेगा। आपके अगर डैमेजेस भी क्लेम हो गए दूसरे किसी इन्फ्रिंजमेंट के, तो डैमेजेस भी उस दोस्त को उतना ही देना पड़ेगा जितना कि आप देंगे। तो इक्वल पार्टिसिपेंट्स आप हमेशा रहते हैं, लेकिन इंस्टीट्यूशनल एप्लीकेशंस में आपको थोड़ी सी सेफ्टी मिल जाती है। इसलिए मैं सभी से कहता हूं, आपकी एप्लीकेशंस, आपकी क्रिएटिविटी, ऑलवेज कोई भी क्रिएटिविटी आएगी वो ह्यूमन माइंड से ही आएगी, लेकिन आपका जिनके साथ जहां पे आप एम्प्लॉयड हैं उस इंस्टीट्यूशन के नाम से, उस संस्था के नाम से, उस यूनिवर्सिटी के नाम से फाइल किया कीजिए, तो जिम्मेदारी ज्यादा से ज्यादा उस तरफ रहेगी बजाय आपके। हाँ, ओनरशिप बाद में ट्रांसफर होती है, लेकिन हम इंडिया में एज ए प्रैक्टिस जो है कि असाइनमेंट बाद में ट्रांसफर नहीं करते, इन्वेंटर्स वही रहते हैं, इंस्टीट्यूशनल ओनरशिप बराबर मेंटेन रहती है 20 साल के लिए। दूसरे देशों में कानून है कि वहां पे एक्सक्लूसिव ओनरशिप ट्रांसफर होती है, तो जिनको ट्रांसफर किया उन्हीं की रहती है। इंडिया में एक्सक्लूसिव ट्रांसफर हम ओनरशिप नहीं करते। काइंड ऑफ ऐसा मैकेनिज्म है। देखिए ट्रांसफर राइट्स, आप हमारा जो फॉर्म है पेटेंट का, जो पेटेंट फॉर्म 1 है, उसमें जब आप फॉर्म में 1 में साइन कर रहे होते हैं एज इन्वेंटर्स, वो लास्ट पैरा में एज ए एप्लीकेंट CSIR के डायरेक्टर साइन करते हैं, आप लैब के डायरेक्टर, बट इंस्टीट्यूशनली ये CSIR हेडक्वार्टर के नाम से सारी एप्लीकेशंस फाइल होती हैं। तो जहां पे आप अपने सिग्नेचर्स कर रहे होते हैं, वो आप अपने ट्रांसफर राइट्स ट्रांसफर कर देते हैं। इसलिए सिर्फ हमारे देश में ही मतलब कि बेस्ट लॉ मैकेनिज्म है कि इंस्टीट्यूशनल फाइलिंग होती है। यूएस में ऐसा नहीं होता, वहां पे इंडिविजुअल फाइलिंग होती है, देन आप असाइनमेंट फाइल करते हैं और पेटेंट ऑफिस में आप असाइनमेंट सबमिट करते हैं एंड एक्सक्लूसिवली वो असाइनमेंट फिर चल रही होती है। आप फिर यूएस में किसी को ट्रांसफर कर रहे होते हैं तो फिर वो असाइनमेंट वो फाइल करते हैं वहां पे। लेकिन इंडिया में असाइनमेंट फाइल करके रिकॉर्डल चेंज नहीं किया जाता, बट हाँ जब आप अपना स्टार्टअप बनाएंगे तब आपको वो चेंज करना पड़ेगा। स्टार्टअप्स के लिए बहुत जरूरी है, आपकी इक्विटी इन्वेस्टमेंट लेनी होती है, आपको काफी सारी जगह पे पिच करना होता है, तो वो सभी पूछते हैं कि आपका पेटेंट आपके स्टार्टअप के नाम से है, तभी आपको इन्वेस्टमेंट देते हैं। तो उस समय में जो है कि पेटेंट ऑफिस की एक मैकेनिज्म होती है फॉर्म 6 एंड फॉर्म 16। फॉर्म 6 जब तक पेटेंट अंडर प्रोसिक्यूशन है, आप असाइनमेंट फाइल करके उसको कंपनी के नाम से ट्रांसफर करते हैं। तो एज ए इंडिविजुअल ग्रुप आप काम कीजिए, बनाइए जितने पेटेंट्स आप बना सकते हैं। आपके कॉलेज के नाम से है, कॉलेज से जब अब जिसके आपकी जो भी यूनिवर्सिटीज है वहां पे अगर IIC आ चुकी होगी तो ये सारी चीजें आपको बताई जा रही होगी। इस समय जो अभी क्वेश्चन उन्होंने पूछा था स्टेट गवर्नमेंट में नहीं है, लेकिन स्टेट गवर्नमेंट की इंस्टीट्यूशन में भी इंस्टीट्यूशनल इनोवेशन काउंसिल बनाई जा चुकी है मिनिस्ट्री ऑफ एजुकेशन का एफर्ट से, एंड ये पूरी तरह से अवेयरनेस अभी लाई जा चुकी है। आप क्रिएटिव काम करते रहिए, आपको रुकना नहीं है, बाकी सब टेकन केयर बाय योर यूनिवर्सिटी, आपका इंस्टीट्यूशन ख्याल रखेगा। और जब आप यहाँ पे आ जाएंगे एज ए रिसर्चर, आप यहाँ पे जब ट्रेनिंग करने आते हैं एज ए JRF SRF, तो फिर सिम्फर आपका ख्याल रखेगा, उसकी आपको चिंता करने की जरूरत नहीं है।
Thank you. Thank you, sir. I think that was a very nice explanation. And what I'll do, we'll move forward because there are two more lectures, but we'll come back during the last session. I think we can have a little more time when this kind of discussion can continue, because that's the time we'll talk on the board. So with that, thank you for very, very excellent and very nice lucid presentation, I should say. We are very clear about the homework now. So I hand over to organizer.
Thank you, sir. And now it's time to facilitate the speaker of first technical session. Now I would request Dr. PK Banerjee, sir, to facilitate. Dr. Yogesh Dhoble. Thank you, sir. Now Dr. Shivkami Dulap. Thank you, sir. Now it's time for second session, second technical session. I would request Dr. SK Kashyap, sir, to please. And I would also request Dr. Virendra and Dr. Sanjeev Kumar Majumdar to please come up on the stage.
Minimize static. Files minimize complete.
Thank you, sir. Now, I would request Dr. Ramakrishna Vallu, Senior Scientist, to introduce our first speaker, Dr. Virendra Singh.
Thank you. Thank you very much. Good evening, ladies and gentlemen. Now this lecture will be delivered by Dr. Virendra Singh. Before delivering his lecture, I would like to introduce him. He is a well-qualified legal professional working as a senior examiner of trademarks and GI, Controller General of Patents, Designs and Trademarks, Ministry of Commerce, Industries and Government of India. Currently is posted at Trademarks Registry, Kolkata. Now I would like to read his biodata. Dr. Virendra Singh ji completed his LLB from Maharishi Dayanand University, Rohtak. After that, LLM completed from Kurukshetra University, Kurukshetra. Later, he awarded JRF from UGC, New Delhi. And he completed PhD from Kurukshetra University, Kurukshetra. Later, he moved to Trademarks Registry, Kolkata, as an examiner of trademarks and GI from December 2014 to June 2018. Currently, he is working as a senior examiner of trademarks and GI, Controller General of Patents, Designs and Trademarks. With this, I welcome him to deliver a lecture about industry property, IPR, its generation and protection. Please welcome, sir.
फाइल भी ना शॉर्टकट है. में डाल ले.
I would request Dr. S.K. Kashyap sir, please welcome our speaker with a bouquet.
Good afternoon to all of you. Respected Srinivasan sir, Chief Guest, Director sir, Kashyap sir, all the respected speakers and students. As since the morning we are discussing about the patent, what are the technicalities in filing the patents. Being a legal person, legal background, I would like to discuss about the what are the intellectual properties, what are the industrial properties, and how we can protect our intellectual properties, including copyrights, trademark. So, being a legal person, I would like to say that we should know about our rights, which rights we have. So, before starting, there is one technicality in that the PPT and the material which I have used in this PPT is only for your understanding, to explain you what is the copyright, what is the trademark, how we protect, and no part of this PPT will be used without my permission, since I have copyright in my presentation. This is what is the copyright, what we have rights in our intellectual properties. We are talking about the patent. You have right in your patent which you applied. Another type of this intellectual property, this is the copyright and the trademark. Though Srinivasan sir has given some brief about the intellectual properties, there's when a product comes in the market, a single product has multiple intellectual properties. For example, if any phone comes in the market, the brand name by which that product is being sold, that is his trademark. The software, the technology which are being used in that particular phone, that is patent. And user manual, how to use that is the copyright. So a single product has a multiple intellectual properties. So first of all, I would like to introduce about the property. Though property is not a new concept for us. Property is as much as old as the human race came into existence. When human race started to evolve for himself, at that time property was, I think, first thing which was acknowledged by the person for which they were fighting for their evaluation. And property is for the somewhere for the enhancement of the social status or for monetary benefits. So what is the property? Property generally means which a person thinks on. कोई भी आप प्रॉपर्टी ओन करते हो over which you have exclusive right. So when any person holds anything, that is his property. The word property is derived from the Latin word proprietary and equally the French equivalent properties, which means a thing owned. The concept of property and ownership are very similar to each other. See, in 1970, Supreme Court recognized this concept of the property, that property does not include only corporeal things, such as your movable and immovable property, but also include the incorporeal things, such as copyright and patent. See the essence of this property. That was way back in 1970, 50 years back, that the Supreme Court recognized that apart from your corporeal things, you have also incorporeal properties. So that was the essence of the incorporeal property, which was recognized by the Supreme Court in 1970. So according to Supreme Court, we can say that property can be divided into two types: corporeal things and incorporeal properties, tangible and intangible. Tangible property, which you can measure, either it can be movable property or it can be immovable property. And apart from tangible things, there is intangible property, which is intellectual property. Intellectual property includes patent, trademark, GI, copyright. So you being scientist, you being the technical background, you have known about what is the patent. You know what is the utility of the patent, what is the utility of filing of the patent for you. But along with the patent, you have trademark and copyright also. How it come into existence in your life? Suppose you have invented your product. You have invented your product and want to sell that technology in market. Then definitely you go to the market, some person or some company which give your more value to your inventions. Why you have invented your product? To gain monetary benefit. So when you go into the market for your product, the company which give more monetary benefit to you, you sell your product to that company. अभी आपको छोटा सा एग्जांपल देता हूँ. टार्जन मूवी थी जिसमें अजय देवगन ने टार्जन कार बनाई. उसमें 3 दोस्तों की कंपनी थी. They approached the Ajay Devgan to purchase that technology. So in the same sense, when you invent any product, when you invented any product, you may approach to the market, or someone from the market may approach to you for purchasing your technology. So when you approach the company that is doing the business in the market, that is trademark. When any person or any entity doing the business in the market, he is using the trademark, and trademark is actually, it may be any sign, any word, any device by which he is doing the business in the market. That is the trademark. Similarly, when you have invented your product and you write the literary content of that product, how you invented that product, when you written about that product, how it will work, how it will function. Then copyright into existence. So for you scientists, not only the patent, but also copyright and trademark is equally important for you. And in the before lunch session, sir was asking that there is a lot of cost for filing the patent, for protecting the patent. This is not in the case of the copyright. For protecting your copyright, you need not invest your money. You have to file only single application for the registration of the copyright. And only nominal fees is there for the registration of the copyright, only 500 rupees for the registration of copyright. हम किसी रेस्टोरेंट में खाना खाने में जाते हैं, वहां भी 1000 रुपया बिल आ जाता है. आप देखिए कि एक सिर्फ कॉपीराइट को प्रोटेक्ट करना आपके लिए कितना आसान है. If you have something which you have written or which you have painted, you can apply for the registration of the copyright. I will discuss in later stage about the copyright. So intellectual property is what is arising from your mind. When any person applies his mind, invented something which is new, which is original, and he expresses in some form, then it is the intellectual property of the person who has created that property. So intellectual property generally can be divided into two types: industrial property and copyright. Copyright is not industrial property. Industrial properties are only patent, trademark, GIs, design. So these are the industrial property. Why these are the industrial property? Why we say that patent is the industrial property? Why we say that copyright is, you say trademark is the industrial property? When you have invented your product, you go to the market for selling your product. I just told you that you go to the market to sell your product and to sell your technology. And person or entities which are doing the business in that field using that trademark, or when a group of the society from a particular society to protect their product, either that may be due to the geographical conditions or due to some other factors which are attributable by that society, that is GI. So all these invention, patent, trademark and GI, these are the industrial property. But when we come on to the copyright, when you have expressed your thoughts, idea itself are not copyrightable matter. But when you express your ideas into some form, that is protected under the copyright. So before moving forward, that industrial property, I have also told you that industrial property includes only the trademark, patent, GI. It excludes the copyright. The purpose of the industrial property law is to regulate the right to certain inventions and industrial or commercial creations. The object of industrial property consists of science conveying information, in particular to consumers, regarding product and services offered on the market. Protection is directed against the unauthorized use of such science that could mislead consumers and against misleading practices in general. First convention regarding the industrial property, which was adopted internationally, was a Paris Convention, which was adopted in 1883. which applies to industrial property in the widest sense, including patent, trademark, industrial design, utility model, service mark. I will explain about the trademark in next slides. Geographical indication and the repression of unfair competition. This international agreement was the first major step which was taken to help creators to ensure that their intellectual work are protected in the whole world. So Paris Convention was the first international convention which was related to the industrial property. As I have said that when a person applies his mind, when a person uses some resources, when a person uses, we can say that spend some time, when this property is created, this is the intellectual property. And every person who has created the intellectual property, he has the right to protect his property like his tangible properties. One main characteristics of the property is that you can dispose of your property according to will. This is the main purpose of the protect your property, that like any other physical property, you can also protect, you can also use according to will the intellectual property which you have created. When you have created your intellectual property, you are vigilant about your rights that yes, I have created my intellectual property. I will protect my property from the unfair use. No one should infringe my copyright. No one should infringe my trademark. Then you can protect your property as you are the registered proprietor of the trademark. You are the registered proprietor of your copyright. So when any person infringes your property, infringes your intellectual property rights, when you are the registered proprietor, then you can avail all the legal remedies available to the registered proprietor as per the Trademark Act and as per Copyright Act. Similarly, when you use your property as a registered trademark or copyright, you can utilize your industrial property for commercial purposes. When you are registered proprietor of a trademark, there are other competitors in the market which are providing the same product or same goods in the market. But when you are vigilant, you are registered proprietor of the trademark, then definitely you have cutting edge over the persons who have not registered proprietor of a registered trademark. Since registered trademark gives a information to the consumers that this product is originated from this particular person, this particular entity. And this gives the brand value to him that yes, this product has the particular characteristics, this product has the particular features. So when you are the registered proprietor, definitely you get the upper hand in the market that yes, you have the special characteristics in your product, in your services. And if any person tries to infringe your copyright, infringe your trademark, we can say as industrial property is the trademark. So when any person tries to infringe your trademark, you may take the legal action against that person as per the Trademark Act. So this is the value, this is the importance, this is the significance of the your registered intellectual property. As I have said that this is the main characteristics of the property, that you can use the property according to your will. If you are the registered proprietor of a registered trademark, you are the proprietor of that trademark, you can use according to your will, you can license, You can give franchisee of your brand name to other persons. So these are the benefit of the registration of the intellectual properties. For a common person, it has matter of the pride. As we know in the society, any person who has the more property, it enhances the social status of the person in the society. If any person has more number of houses, cars, anything else, property is the for the enhancement of the status. So for a common man, when a person is the proprietor of intellectual property, when he is the registered proprietor of intellectual property, it is a matter of pride for him. And like you students, it gives you some advancement in your academician. When you have copyright, you have more copyright, then definitely it enhances your status in the your institution, and you get the cutting edge when you go for an interview that how many copyright you have, how many patent you have in your name. Then it gives the you proud for your intellectual property. For a business person, he can commercialize his proper intellectual properties. He has a brand value in the market. He can earn from his intellectual property like trademark. So these are the benefit of the registered proprietor of the intellectual property rights. So as I told you that in this lecture, I will cover the copyright and trademark. First of all, I would like to cover copyright. As I have earlier told that Paris Convention was regarding the trademark, GI, patent. First international convention regarding the copyright was Berne Convention, which was adopted in 1886, which deals with the protection of works and the rights of their authors. It provides creators such as authors, musicians, poets, painters, etc., with the means to control how their works are used, by whom, and on what terms. As I have told you that you are the registered proprietor of your copyright, you can use your copyright according to you will. So Berne Convention was the first convention in the copyright whereby the rights of the authors were protected. After that, TRIPS came into existence in 1995, which incorporates appropriate provision of previous treaties and convention. जब भी हम कोई भी नई चीज बनाते हैं, कोई भी नई इन्वेंशन, कोई भी नई ट्रीटी साइन करते हैं, तो we adopt the provisions of the previous treaties to honor that treaty which have already existence. So after the Berne Convention, there was TRIPS came to existence, whereby it requires the members of the WTO to comply with certain specific provision of the Berne Convention. Apart from the Berne Convention and TRIPS, there are the Universal Copyright Convention, which was adopted in 1952. So what is the copyright? Copyright is the exclusive right to do or to refrain from doing certain acts by any third persons. It is a bundle of right. If you have copyright in any your literature work, you have certain rights. You can sell your products, you can sell your literature, you can reproduce your literature, you can convert your literature work into some form other types of the copyright. So it is the bundle of rights which a person, which a holder of the copyright have with him. And one more thing, that copyright is automatic right. As soon as you create some work, you some original invented work, which is not copied from anywhere, you get the copyright automatic in that work. But when you are the registered proprietor of a copyright, you have certain provision, you have certain rights that any person when infringes your copyright, you can move for the appropriate remedies. And one thing I would like to say that it at this stage, that copyright is a very violation of the copyright. Infringement of the copyright is a very serious offense. If any person infringes the copyright, that is the cognizable and non-bailable offense. And a person may get punishment up to 3 years and a fine which may extend to 1 lakh rupees. So this is the copyright. जब भी infringement की बात आती है, as I have told you that copyright is the infringement of the copyright is non-bailable offense. Person may give compensation easily. Every person has money with his hand. If anyone finds 5 lakh rupees, he will pay definitely 5 lakh rupees. But when it comes that yes, you have violated you have infringed the copyright, and you will be go in the jail, that impact the person who are violating the copyright of the registered proprietor. क्योंकि हमारे देश में यही है कि पैसे से कोई नहीं डरता, पैसा सबके पास है, लेकिन जब जेल जाने की बात आती है तब सब पीछे हट जाते हैं उस चीज से. Punishment has the deterrent effect to protect the infringement of the copyright. So I have told that copyright is a bundle of right which you can have when you create any copyright in any form. It prevents unauthorized or copying or reproduction of your work without your permission. Copyright is the author's legal right which they have in their literary, artistic, and scientific work. So, in which copyright subsists as per Copyright Act. Copyright generally exists in 6 type of work. It exists in the literary work. It exists in the artistic work, dramatic work, musical work, sound recording, and cinematographic films. When you write something in literary contents, your work is definitely protected under the literary category as per the Copyright Act. When you draw a picture, when you draw a painting, then definitely that will cover under the your artistic category. आर्टिस्टिक कैटेगरी में आपकी पेंटिंग आती है, आपके फोटोग्राफर आते हैं. When we take the photograph, then the person who is taking the photograph, he is the author of that photograph. Similarly, when any person composes the music, जब भी कोई आपने गाना लिखा, when you have written some song, and you have the person who has written that literary song, he has the copyright in literary work. Persons who is going to sing that song, he has the copyright as a singer. And the person who makes the music of that song, that is the music work. Person generally confuse that the music work will cover under the sound recording. No, when musical notations are written in are graphically represented, that are the musical work. Person who has composed the musical work has a separate copyright in music work. जिस तरह सलीम मर्चेंट का बैंड बाजा मूवी, उसने म्यूजिक कंपोज किया वहां पे, he has the separate copyright as a musical composer in that work. Person who is acting or dancing on that song in a film, who is the actor, that is the separate right of the person who is acting that movie or who is acting on that song. So in single work, you may see that there are number of persons who have separate copyright in each type of the work. Either it may be in literary category, either it may be in musical category, it may be sound recording, it may be in the form of cinematographic films. जब भी आप देखिए कि जब भी कोई मूवी बनती है, producer is the person who has created the movie. Actor who is acting in that movie, he takes the money from the producer. You listen that some particular actor has obtained 4 crore rupees, 5 crore rupees for his acting in the particular movie. That is the copyright of that person who is acting in that movie. He has a separate copyright, and the person who has produced that film, he has the separate copyright as he has created the film. So the person who has created the film, he has the separate copyright in that work. Next question comes about who is the author while creating the work which is being copyrighted. So when any person writes anything, the person who is writing, who is the author, that person who is writing some story, he is the author of that literary work. The person who is making the musical notations, musical composer, he is the author of that musical work. The person who is painting, who is drawing a painting, that artist is the author of the work. Person who is taking the photograph, एक ही फोटोग्राफ कोई भी पर्सन जब एक फोटोग्राफ डिफरेंट एंगल से लेते हैं, आपने किसी एक एंगल से ली, दूसरे बंदे ने किसी दूसरे एंगल से उस फोटोग्राफ को लिया, that both the persons have the copyright since that is their original work. So when a person takes the photograph, he is the author of that work. Similarly, as I have told you that in cinematography, film or sound recording, the producer who is investing his money, he is the author of that work. And when the literary, dramatical, musical or artistic work which is computer generated, the person who causes the work to be created, that person is the author of that work. So for different work, different persons can be author. And one thing I would like to say is that in all the categories, except cinematography, film or sound recording, only natural person can be author of that work. Only natural person can be the author. But there are exceptions that in cinema, sound recording and CF, and in films, company can be the author of a work. Apart from these two types of the category, only natural person can be the author of the work. As we have discussed that the person who has created the work, he is the author of the work. And definitely copyright is granted to the owner. Who is the owner of the work? General rule is that the person who has created the work, he is the author. and he is the first owner of that work. But apart from this general rule, there are certain exceptions which are mentioned in the copyright, that if any work is created during the employment of a proprietor of newspaper, magazine, or periodicals under a contract of service, then the proprietor of that newspaper, magazine is the first owner of the work. So far as the publication of that work which is created by the author is concerned, the owner of the periodical or owner of the magazines is the first owner of that work. And similarly, if work is created for valuable consideration, then the person who has paid the valuable consideration, he is the owner of that work. अगर आपने एक फोटो उतरवाया, आपने आपका फोटो लिया, आपने फोटोग्राफर को पैसा दे दिया है, then in that case you are the first owner of that work. Apart from these, if a work is created during the contract of services, then the institution, then the you can say owner of the institution is the owner of that work. Though you have created, you are the employee of a particular institution, you have created during the employment with that institution, you have created some work, then institution is the first owner of that work. If any work is created on behalf of the government, if there is government organization, as Shah sir was asking, that we give no objection, we transfer to all our rights to the CSIR. Definitely, we are the employee of the CSIR, and when we create some work for the government, we are using the resources of the government, we are under the service contract, then all the rights goes to the CSIR. Same type, if some lecture is delivered by anywhere on behalf of some person, the person who is giving that lecture or whose behalf that lecture is given, that person is the first owner of that copyright. So this is all about the copyright. For copyright registration, there are the 3 requisites for the protection when you can claim for copyright in a work. There are 3 conditions: that it should be original, it should be creative work, and your work should be fixed in some form. As I have told you, that original work is that you have not copied your work from anywhere. If you have copied your work, this is not the original work. And copyright exists only in original work. Originality and creativity both are the cognate. If you have written something in your own words, you have used your brain, you have used your skill, and you have expressed your thoughts in some material form, then you are eligible for the copyright protection. As far as the right of the author is concerned, copyright generally recognize 2 types of the author. These rights may be either economic rights, or these may be either moral rights. Economic rights are those rights which you can assign to other persons, which you can assign for your valuable consideration. You can earn money from your work. That are your economic rights. And moral rights are those rights which, though you have assigned your work, but still moral rights, the author who has created the work exist in favor of the author who has created the work. Moral right can never be transferred. For example, if you have transferred your right when any person uses your work, there will be always, he will mention that so and so person is the author of the work. Authors का नाम हमेशा वहां पे रहेगा वर्क की, that this particular person has created the work. So this is the right of paternity, gives creator the right to be named or credited if their work is used or played in public. This is the moral rights of the author. As far as the protection of the copyright is concerned, generally patent is granted for the 20 years, trademark is granted for the 10 years, but copyright is such a type of right which is gives you maximum period rights. It is the 60 years from the death of the person who has created the work. So if you have created any work in which your copyright subsists, that your copyright will subsist in your work or your name after your death plus 60 years. जिस साल आपकी डेथ हुई उसके भी 60 अगले साल से 60 साल तक, that your child will use that copyright which is existed in your favor. So after the death of the author, person has copyright for 60 years. Same thing in cinematography, film and sound recording. It is also 60 years from the date of the publications. In case of broadcasting rights, it is the 25 years from the year following year in which the broadcast is made. And performance right is also for the 50 years, the following years in which the performance is made. As I have told you that copyright is very simple to get its protection, unlike the patent where you have to spend a lot of money for your protection of patent. But in copyright, there is only simple form which you have to fill and submit it before the Register of Copyright, and you can get the registration of the copyright which you are going to apply. And the fees, as far as fees is concerned, you can make the payment by online mode or by DD. All these activities for the grant of the copyright, for the protection of the copyright, you may file either online or offline. If you file online application for the protection of the copyright, you have to submit only as Form 14 for the registration of the copyright. And when you satisfy all the conditions for the copyright, then you get the registration in the copyright. So Form 14 actually consists of three parts. Application form, first part. This is the second part, statement of particulars and statement of further particulars. These are the three parts of the Form 14 which you have to fill before applying for the copyright registration. And this Form 14 is very essential for the registration of the copyright. Most of the persons who apply for the copyright, they don't know how to fill this Form 14. Generally, confusion occurs where who is the person, who is the author, who is the owner in the work. As I have told you, the person who has created the work, he is the author, he is the first owner. But in some situations, as I have told you that section 17 prescribes that these are the certain situations where the person other than the author can be the owner of that work. So this is the Form 14 which while we are applying for the copyright registration, we have to fill up this Form 14. It consists of the 17 columns. First column regarding the registration number, which is given by the copyright registry. Second column is about the name, address, and nationality of the applicant. Who is applicant in the work? Either author can be the applicant in the work, owner can be the applicant in the work, or publisher of the work can be the applicant in the work. So in column number second, we have to mention who is going to apply for the copyright. Third column talks about the nature of the applicant interest in the copyright of the work. How is the person applying for the copyright is interested in the work? Either he is a author, either he is owner, or he is publisher. We have to mention his interest in column number 3. Column number 4 talks about the class and description of the work. In which class you are going to apply? As I have told you that copyright exists in 6 types of the work: literary, artistic, musical, sound recording, CF. So you have to mention that appropriate class of the work in your form. If you don't write appropriate class, then definitely objection is raised by the registry. Column number 5 talks about the title of the work. What is the title? You have to mention the accurate title which is written on work. The same title should be written in the column number 5. If you mention different title, then registry raised the objection that your title should be according to the work. Title at both places at column number 5 and column number 4 in your work should be identical. Column number 6 talks about the languages which you are used in your work. All the language which you are using in your work, you have to mention all those languages in column number 6. Column number 7 talks about the nationality, name, address, and nationality of the author. And if the author is dead, then date of his death. So in column number 7, you have to mention the author's detail. As I have told you that, please remember, except CF and sound recording, only natural person can be the author of the work. Most of the persons commit this mistake that when we are applying for work something which is created by you in CSIR, you write the name of the CSIR in column number 7, which cannot be. Only natural person can be the author. You have to mention who is the author of the original work. Column number 8 talks about the publication detail, whether you have published, whether the work is published or unpublished. If the work is published, then you have to mention that work is published. And in column number 9 and 10, you have to give the detail of the publisher who has published the work. And if there is any subsequent publication, then you give the detail of that subsequent publication in column number 10. And section 11 talks about the names, address, and nationalities of the owners of the various rights. As I have told you that author is the first owner of the work, but in some cases, some other person may be the owner of the work. As I have told you that if some work is created during the employment, then under whose employment you are working, that person, that institution is the owner of that work. So if you have created your work in CSIR under the guidance of CSIR, CSIR has provided you resources, financial assistance, and you have created the work for CSIR, then in column number 11, CSIR will be the owner of the work. And all the rights are given to the owner of the work. In that case, the person who has created the original work, that person have to give the no objection certificate, or he has to assign all his rights of the ownership to the owner. Section column number 12 talks about the name, address, and nationalities of other persons, if any, authorized to assign or license the rights comprising in the copyright. If you are going to authorize any person other than the author or owner, that this person has also the ownership right, has the right to grant the license or assignment to make the assignment on behalf of the owner, then you have to give the details of that person in column number 12. Column number 13 talks about the work. If the work is an artistic work, the location of the original work, including names, address, and the nationality of the person in possession of the work. If you are applying for the copyright in artistic work, then you have to tell about who is the original person in whose possession this work is existing. In column number 14, if you are applying for the registration of the copyright in artistic work, and that artistic work is capable of being used in goods and services. For example, Maruti has a logo M, which we see before the Maruti car. That is his trademark. And if that mark is Maruti is going to protect as a copyright also. Since that M is his trademark, and if that M is he's going to Maruti is going to apply for the copyright, in that case, the Maruti is required to give to take the search certificate from the register of trademark. The purpose of search certificate is that when any artistic work which is being used or which is capable of being used in goods and services, meaning thereby which can be used in trademark, then you have to take no objection certificate from the register of trademark that no similar trademark is existing or pending in trademark registry. This is the prior condition for the applying artistic work for the copyright which are being used in the trademark. Column number 15 talks about if the artistic work is if the work is an artistic work, whether it is registered under the Design Act. If yes, give the details. If the artistic work is being registered, is capable of being registered, then it cannot be registered under the copyright. So he has to give the affidavit that the work is not registered under the copyright and he is not applying in the copyright. Column number 16 talks about if the artistic work is an artistic work capable of being registered as a design under the Design Act, whether it has been applied. If you have applied for the Design Act, that artistic work, then you have to give the details of that work also. And in column number 17, if you want to give any additional information, then you are required to give that information also. So this is the form 14 statement of particulars, which you need to know how you apply for the registration of the copyright. Since this application form is very compulsory and most of the persons make a mistake while applying for the copyright. The third portion of the form 14 is the statement of further particulars. This statement of further particular is given only in the case of literary, including software, dramatic, musical, and artistic work only. And this talks about whether the work is registered, is an original work, yes. Since section 13 talks about that copyright exists only original literary, dramatical, musical, and artistic work. If that is not original work, you cannot apply for the copyright. So in statement of further particulars, you give the details about the registered work which you are going to register, that it is original work. Yes, when you write yes, then definitely all the columns in the next, they are not applied. So this is the copyright form which are very important for applying the copyright registration. And as I have told you that there is very nominal fees for the copyright. For literary, dramatic and musical work, artistic work, there is only 500 rupees for the registration of the copyright. And the artistic work which is capable of being used in goods or services, then it is 2000 rupees. In sound recording, it is 2000 rupees. And in cinematography film, it is also 5000 rupees. So as compared to trademark and patent, there is very nominal fees in case of copyright cases. So when you create your work originally, being a student, most important part for you is the copyright. When you create anything, when you write an article, you can get the copyright of that article by applying in copyright office, and that enhance your status that yes, this particular student has a particular number of so number of copyright with his name. As far as the registration of the copyright is concerned, this is the procedure when you apply for the copyright. As soon as you apply for the copyright, registry give a application. You have to file the application with his registry, allot you a particular diary number for your application. And when you file complete application with your work, there is 30 days mandatory period, waiting period for calling the objection. If any third person wants to object your work, then he may object your work within 30 days from the publication of the applications. If any objection is filed by the third party, we send that objection to the applicant, that this objection is issued from the third party against your copyright application. Then applicant give the reply, and at the same time we give the notice of the hearing, that when the objection is completed, when objection is filed, then applicant gives the reply, and when reply comes, we send a notice of the hearing along with the reply of the applicant, that this is the reply of the applicant and you are required to your any additional evidence. Then hearing is fixed by the registrar of the copyright. If the objection filed by third person are accepted by the registrar of the copyright, then applications are refused. And if no objection, and if the objections are rejected by the registrar of the copyright, then definitely application accepted for the examination of the application. So initially, where the objection is not received within 30 days from the date of the receipt of the application, no objection is received by the registrar of copyright, application filed by the applicant is examined at copyright office. If any discrepancy is found, if any discrepancy is raised by the examiner, then discrepancy letter is issued to the applicant that you are required to remove your discrepancy within period of 30 days. Applicant file the reply to that discrepancy letter, and if the reply filed by the applicant is not satisfactory, then hearing is fixed by the registrar for to hear the applicant. And if no discrepancy is found in the application, then application is accepted for the registration. So when hearing is concluded by the registrar of copyright, either at the time of the objection or either at the time of the, we can say, the reply which is filed by the applicant in case of discrepancy letter. If the applicant removes the discrepancy, then registrar accepts the application, registration is approved, and registration certificate is granted. Send the certificate to the applicant. And if the discrepancy is not removed by the applicant, or objections which were filed by the third parties are held by the Registrar of Copyright, then application is rejected. This is the total flow of the copyright applications. Apart from the copyright, we have intellectual property, industrial property, which is known as trademark. So what is the trademark? Trademark is a mark, any word, name, symbol, or device, or combination thereof, which identifies and distinguishes the sources of the goods or services of one trader from the other persons. Trademark is a mark which is capable of being used in in course of business, which gives the customer the specific information that this product is arising from that particular company, that particular person is the proprietor of this trademark, and that trademark differentiate the goods of one person from the other persons. What is the importance of trademark? It allows a business entity to build up public goodwill and brand reputations. It identifies the source and origin of the goods or services. It assures the customers about the quality of the goods and services. This is the purpose of the trademark. When you purchase the brand value, when you purchase the brand name in the market, you go to the market, you ask for a Apple mobile, you ask for the Samsung mobile. That Samsung, that Apple is the trademark, which has a specific reputation with them, that this Apple has the specific quality, Apple has the special characteristics in their product, which other products does not have. So this is the trademark which differentiate the goods of one person or goods or services of one person or one traders from the other persons. Trademark may be trade name, collective mark, citation mark. There may be taglines. Ye dil mange more. You know that this is the trademark of the Pepsi. Coca-Cola, this is the shape mark, the bottle which was used by the Coca-Cola earlier. This was the shape trademark. McDonald's, this is the M signs of the McDonald's. Nike, Adidas. So all these are the trademarks of the companies. When any person is the registered proprietor of the trademark, he uses the R in circle. When a R is written on the product in circle, it means that is the registered trademark of the company, that is the registered trademark of that particular person who is selling those products. If only TM is being used in that on those products, it means he has a trademark, but it is pending. If it is pending, then he will use the TM, and when there is R in circle, it means that is the registered trademark of the company. How to protect your trademark? As I told you that trademark registration is the optional. There is no compulsory, but as I have told you, when you are the registered proprietor of a trademark, then you have some benefits. When any person infringes your trademark, then you may take the legal action against the infringer. If you don't have the registered trademark, then you have only passing of remedies. Passing of remedies means you have unregistered trademark, someone is breaking, someone is infringing your trademark. But in case of registered trademark, you can take legal action, you can file suit, you can claim damages from the infringer. As earlier in the morning, sir asked that the registration is the territorial in nature. The registration of the trademark is also in territorial nature. It is at the national level, regional level, or international level. And as far as the duration of the registration of the trademark is concerned, it is for the 10 years from the date of the applications. And it can be further renewed for 10 years plus 10 years. If any person continue to renew his trademarks, then definitely he gets the renewal of his trademark registration. In case of non-use of trademark, the person who has got the registration, who has got the right, if he does not use the trademark for continuous 5 years, then he loses his rights. And as far as the trademark registration is governed, it is governed by the Trademark Act 1999 and Trademark Rule 2017. This is the form TMA, which we uses while applying for the registration of the trademark. Earlier, there were number of forms in the Trademark Act, but after amendment in 2017, we have reduced only 8 numbers of trademark forms, which can be used for different purposes. And for registration, there is only TMA. TMA is the application form, which is filed by the applicant for the registration of the trademark. In TMA, there is nothing, there is very simple procedure. What is the nature of the applicant, whether he is the individual person, whether he is the startup, whether he is the company. And in column number 2, whether the company is startup company or individual person, he has to tell about those formalities. In column number 3, he talks about who is the applicant for the trademark applications. He gives his address, email number, mobile number, extra. If there is some agent on behalf of the applicant, then agent detail is given. Then column number 5 talks about the trademark, which type of trademark you are going to apply. Similarly, if language in Hindi or English, other than Hindi or English is used, then you have to mention the translation of that mark. If you want to make any condition, then you have to mention that this is the condition which I want to apply. Column number 8 talks about the goods and services for which you want to apply. Actually, all the goods and services are divided into 45 classes. 1 to 34 talks about the 34 classes talks about the goods, and 35 to 45 talks about the services which is provided by the you can say applicant. So you have to apply in particular class. If you want to apply for, suppose you want to apply some trademark for your clothes or shoes, then you have to apply into class 25. If you want to apply trademark for medicines, you have to apply in class 5. If you want to apply your trademark in for education services, you have to apply in class 45. So all these goods and services are classified into classes. You have to apply in that particular class. Apart from this, if any priority claim is made by the applicant, priority claim is regarding if any national of the other persons of the other countries apply for the registration of the trademark, and he is the member, the other country is a member of the WIPO, then if he wants to take the priority claim, he has applied his application in his own country also, and now he is going to apply in this India, then he can claim that yes, I have applied it earlier this application within 6 months, I am applying there in the India, then he can claim the priority. Column number 11 talks about if any information is, if you want to give any further information, you can give information. Column number 12 talks about the verification. There is no such formalities. So this is the form TMA for applying for the registration of the trademark. As far as the application fees is concerned, if you are the individual person who are going to apply for the trademark, then you have to apply only 4,500 rupees. And if the applicant is company other than the startup or small enterprises, in that case you have to apply, you have to pay fees 10,000 rupees. And similarly, there is 10% rebate in case of the online filing. Next is the GI, geographical indications. As I have told you that trademark GI are the industrial property which we protect. So geographical indication is an indication that identifies a product that has a specific geographical origin and possesses qualities or a reputation that are due to that origin. किसी भी particular region के लिए, if there is some particular reason and that some product is being produced there and that product is some specific characteristics, either it may be due to physical conditions or either it may be due to the involvement of the person who has created that product, then the group of person, that particular locality can apply for the GI. For example, in Jharkhand, there is Swari paintings which has the GI tag, Darjeeling tea, Makrana marbles, Nagpuri Santra, Nilgiri Orthodox. All these are the GI products. What can be registered as GI? Any name, geographical or figurative representation, or any combination thereof conveying or suggesting the geographical origin of the goods to which it applies. So any name, geographical or figurative representation can be applied for the registered GI. And as far as the applicant is concerned, an association of producers or an organization or authority established by or under any law representing interest of the producer of the concerned goods and desires to register a GI in relation to such goods can apply for the registration of the GI. So why geographical indication is necessary? As I have told you, like in trademark, that it identifies the product or identifies the goods. Similarly, in geographical indication also, it identifies its sources. It indicates the quality of the product. It promotes the product with a distinguished name. And also it prevents the infringement and unfair competitions. These are the examples which I have told. These are the other examples that Katputlis of Rajasthan, Bhag prints of Madhya Pradesh. These are the examples of the GI. Thank you.
Thank you very much, sir. Now I would request Dr. Sudarshan Singh Rathore to introduce our next speaker.
Good evening, everyone. I'm pleased to be with you all and have a chance to introduce our guest speaker, Dr. Sanjeev Kumar Majumdar. Dr. Majumdar has more than 17 years of valuable experience in IPR. He has started his career as a research associate in ICMR, New Delhi. Afterwards, he was working with Dr. Anil Kumar Gupta is a associate fellow in National Innovation Foundation of India, Ahmedabad. Presently, he's working as a senior manager in startup activities and intellectual property division of National Research Development Corporation, NRDC, New Delhi. His experience is conducting patent search, dealing with new patent application, receiving by the NRDC or patent assistance. He is member and coordinator of various startup innovations of Government of India, like member of interministerial board secretariat of Startup India initiation of the DIPP, which is Ministry of Commerce and Industry, which is Government of India. Then coordinator of IOCL Startup Project Monitoring Committee. He is also coordinating for the upcoming NRDC Incubation Center at NRDC New Delhi. Also, he is involved in the setup of intellectual property facility center, which is there in Bangalore, and which is funded by the Ministry of MSME and DSIR. He organized more than 30 workshops, and he delivered various lectures in various universities and research institute. Hereby, I request Dr. S.K. Majumdar to deliver his lecture.
Thank you.
Thank you.
Thank you. So I'm the last speaker. So जय जोहार, जय जोहार, जय जोहार। सभी जगे हुए हैं। अच्छा है, सभी जगे हुए हैं। शाम काफी हो चुकी है, देर हो चुकी है। माफी चाहूंगा, मैं हिंदी में बात करूंगा सभी के साथ, और आप भी बिल्कुल फ्री रहिए। मैं आपको ये स्लाइड मूव नहीं करने वाला। आज हम बात करेंगे काफी यंग फेसेस, आप लोग कॉलेज से आए हैं या फिर यूनिवर्सिटी में जहां भी पढ़ रहे हैं। विधायक जी ने भी अच्छा सवाल पूछा। आप थोड़ा सा पूछना चाहूंगा, आप लोग अपने कॉलेज का नाम थोड़ा सा अगर बताएं तो। तीन यूनिफॉर्म है यहाँ पे, चौथा यूनिफॉर्म गायब है अभी। ओके, एंड स्टूडेंट्स ऑफ विच कोर्स? जियोलॉजी, बैचलर्स कोर्स यू आर डूइंग बीटेक जियोलॉजी, बीएससी जियोलॉजी। चलिए, मास्टर्स भी हैं। एंड एनी रिसर्च स्कॉलर्स हियर, पीएचडी परसुइंग? ग्रेट। एंड माय सिम्फर फैमिली, those who are here till this 5:30 time. So most welcome. शाम को आपको गुड इवनिंग, जय जोहार। हम बात करेंगे थोड़ा बहुत, ज्यादा कुछ नहीं। सुबह से प्रेजेंटेशन चल रहे हैं। अब आपके पास नोटपैड है, पेन है, आप अपनी दिनचर्या की 2-3 चीजें बस थोड़ा सा लिखते जाइएगा। सुबह आप उठे, आपने ब्रश किया, नहाया, साइकिल उठाई, बाइक उठाई, बस लिया, कॉलेज आए, मैसेज हुए, लंच ब्रेक में कैंटीन गए। अब आपने जो टूथपेस्ट यूज किया, टूथब्रश यूज किया, उसका नाम लिख लीजिए। आपने जो शैम्पू यूज किया उसका नाम लिखिए। आप जिस बाइक से आए उस गाड़ी का नाम लिखिए। आपने जेब में जो फोन रखा उसका नाम लिखिए। अब आप अपने कैंटीन में जब दोपहर में लंच में जाते हैं, शाम को स्नैक्स लेते हैं, तो आप जो मांगते हैं उसका नाम लिखिए। सबने लिखा, सबको याद आ गया कि वो सुबह कौन सा ब्रश टूथपेस्ट यूज करते हैं, टूथब्रश यूज करते हैं, कौन सा शैम्पू यूज करते हैं, और शाम को कौन सी चाय के साथ आप नमकीन लेते हैं कैंटीन में। याद आ गया सबको? चलिए, चाय नहीं पीते, कोल्ड ड्रिंक तो पीते होंगे। अब सुबह आपका वो लाल ट्यूब या वो छोटा सा ऐसे, आपको ऑप्शन था वो 1 रुपए में भी मिल रहा था, लेकिन आपने 2 रुपए वाली खरीदी शैम्पू, 1 रुपए एक्स्ट्रा दिया आपने। टूथपेस्ट 20 रुपए का भी मिल रहा था, आपने 30 रुपए का लिया। ब्रश 30 रुपए का मिल रहा था, आपने 40 रुपए का लिया। मोबाइल 10,000 का मिल रहा था, आपने 20,000 का लिया। गाड़ी 60,000 की मिल रही थी, आपने 1 लाख की खरीदी। कॉलेज जहां पे आप आए, कोई एक सपना था आपका, अभी जिसमें है वो भी चल रहा है। अब कैंटीन में बैठे हैं, आप बातें कर रहे हैं, अच्छी अच्छी बातें कर रहे हैं। आपने बोला वो नीला वाला पैकेट, वो काला वाला ड्रिंक, उसके लिए कितने दिए आपने? 10 रुपए उसके, 20 रुपए उसके, वहां पे भी आपने पैसे दिए। अब इन सभी चीजों में क्या था जिसकी वजह से आपने 1 रुपए की जगह 2 रुपए दिया, 20 की जगह 30 दिया? क्या था? तो हमारी लाइफ में है आईपी, हम सुबह से पढ़ रहे हैं, लेकिन हम सुबह से ही यूज कर रहे हैं, हर दिन यूज करते हैं। वो महंगा मोबाइल भी लिया, महंगे कपड़े भी लिए, महंगी गाड़ी भी ली, महंगा टूथपेस्ट भी लिया, महंगा टूथब्रश भी लिया, और वो ड्रिंक भी जो पी रहे हैं। और उसके बाद जब आप दोस्त से कहते हैं जरा वो नीला वाला ले आना, और वो लेके आता है तो कहता है अरे ये क्या लेके आ गए, मैंने वो नीला वाला नहीं मांगा था जो तुम दूसरा नीला वाला लेके आए हो। अब वो डिफ्रेंशिएट कैसे करते हैं? जो उस पे मार्क लिखा होता है। तो हम आज जो बात कर रहे हैं आईपीआर के लेक्चर्स पे बात कर रहे हैं। आपने जो पे किया वो डिफरेंस था उसकी ब्रांड्स के लिए। आप पैकेट खोलने से पहले, टूथपेस्ट स्क्वीज करने से पहले, ब्रश मुंह में डालने से पहले, गाड़ी पे चढ़ने से पहले आप क्या भरोसा करते हैं? चलेगी गाड़ी, पहुंच जाएगी, फ्लाइट पहुंच जाएगी, ट्रेन पहुंच जाएगी। कोल्ड ड्रिंक की बॉटल खोलने से पहले आप उसका टेस्ट जानते हैं। तो यहाँ पे दो चीजें हैं जो मैनेजमेंट के स्टूडेंट्स पढ़ते होंगे वो जानते होंगे। दो चीजें हैं, एक आपका जो भरोसा ढक्कन खोलने से पहले, पैकेट फाड़ने से पहले। दूसरी चीज जिससे आपने उसको अलग किया, ये वो नीला वाला नहीं है जो मैं नीला वाला मंगाया था, वो नीले रंग का पैकेट बट पर्टिकुलर फॉन्ट, पर्टिकुलर स्टाइल, पर्टिकुलर कलर कॉम्बिनेशन, वो जो लिखा हुआ है वो है हमारा ट्रेडमार्क आईपी। एंड विद टाइम जो उसने अटेन किया वो ब्रांड वैल्यू। जो कपड़े आप लेते हैं, कहते हैं अगले 10 साल नहीं फटेगी, क्योंकि उसने 10 साल में आया ना, जीन्स उसने यूज किया, अपना भरोसा स्टैब्लिश किया। तो ये ब्रांड्स आपने पढ़े। अब इस इन्हीं चीजों में कहीं कहीं पे और भी आईपीज हैं जो ब्रांड्स के अलावा। उस टूथपेस्ट में आपकी टीथ वाइटनिंग प्रॉपर्टीज, उस ब्रश के ब्रिसल्स में इक्वल, आपको हर्ट ना करे आपके मसूड़ों को, वो टाइनेक्स के ब्रिसल्स जो उसमें यूज हुए, वहां पे पेटेंट भी है। टीथ वाइटनिंग प्रॉपर्टीज के लिए पेटेंट भी है। हर्बल टूथपेस्ट लिया, वहां पर हमारा ट्रेडिशनल नॉलेज है। नीम, बबूल और कोयला, नमक, जो भी टूथपेस्ट में आता है वो हमारी पारंपरिक ज्ञान है, ट्रेडिशनल नॉलेज। पहले भी हम नमक यूज करते थे, कोयला यूज करते थे, नीम यूज करते थे, बबूल यूज करते थे। तो वो आयुर्वेदिक जो फॉर्मुलेशन कही जाती है वो हमारी पारंपरिक ज्ञान है, ट्रेडिशनल नॉलेज है। तो हमारे दिनचर्या में ही हमारे सभी फॉर्म्स ऑफ आईपी वी आर यूजिंग। बट हम रिकॉग्नाइज कैसे करते हैं? सिर्फ वो जो 1 रुपए ज्यादा देना पड़ता है उससे रिकॉग्नाइज करते हैं। अब आपकी क्रिएटिविटी यहाँ शुरू होती है। आप यहाँ पे स्टूडेंट्स हैं, बाकी जो हमारी फैकल्टी है, फैकल्टी और रिसर्च स्कॉलर्स भी हैं यहाँ पे जिनको पेटेंट्स करना भी है। तो मेरा एक क्वेश्चन उनसे, रिसर्च हम क्यों करते हैं? आप भी आगे जाकर के मास्टर्स करेंगे, उसके बाद रिसर्च करेंगे। फ्रॉम साइंटिस्ट जो हमारे सिंपर्स हैं, हम रिसर्च क्यों करते हैं? एक सिंपल लाइन में अगर हम आंसर देना चाहें तो आप बताएंगे क्या? वाई डू वी रिसर्च? हाँ बताएं। आपके रिसर्च का आउटपुट आपने लिखा, आप पीएचडी स्कॉलर हैं? ठीक है, अच्छी बात बताइए आपने। सोसाइटी के बेनिफिट के लिए रिसर्च पेपर्स जो पब्लिश कर चुके हैं उन्होंने भी कुछ बताया, वो भी कुछ बता सकते हैं मुझे चाहे तो। हाँ बताएं आप। क्यों? और आपका क्या फायदा हुआ उससे? आपने भी अच्छा आंसर दिया सोसाइटी के लिए, आपने भी अच्छा आंसर दिया सोसाइटी के लिए। आपके रिसर्च पेपर पब्लिश हुआ आपकी सोसाइटी के पब्लिकेशन में, स्ट्रांग होता है। इंडिविजुअली आपकी बेनिफिट, आपके पेपर लिखे आपने, पेपर की साइटेशन आई, आपका एच इंडेक्स बढ़ा, इंडिविजुअली आपको फायदा हुआ। पेपर्स का आपने वो जब रिसर्च पेपर आपने साइन किया, पब्लिशर को सबमिट किया, पब्लिशर ने आपको फॉर्म भेजा, आपने साइन किया, क्या लिखा था उसमें? ठीक है, चलिए अब उस पे हम बात करते हैं। अभी जो आपने फॉर्म साइन किया था उस पे भी बात करेंगे। रिसर्च हमारे करने का पर्पज है फॉर द बेटरमेंट ऑफ सोसाइटी, जो मेरे मित्र ने पीछे सबसे बोला था, बेटरमेंट ऑफ द सोसाइटी। आपकी रिसर्च, आपकी फाइंडिंग्स, बैचलर्स पे आप 4-5 सब्जेक्ट पढ़ते हैं, मास्टर्स में आप एक सब्जेक्ट पढ़ते हैं। रिसर्च जब करने जाते हैं तो आप कहते हैं इट वाज नॉट एग्जिस्टिंग अर्लियर इन नॉलेज, नाउ आई एम फ्रॉम माय इंटेलेक्ट आई एम कंट्रीब्यूटिंग टू द नॉलेज। आप नॉलेज में कंट्रीब्यूट करते हैं, वो आपका रिसर्च पेपर होता है। आपकी एनालिसिस, आपकी फाइंडिंग्स टिल डेट जो भी होती है, दो तरह के रिसर्च होते हैं, अप्लाइड रिसर्च और एम्पिरिकल रिसर्च। एम्पिरिकल रिसर्च जहां पे आप रिव्यू करते हैं आर्टिकल्स, यहाँ झारखंड में हो गया काम, लेकिन आप दूसरे पार्ट में कहा झारखंड में काम नहीं हुआ तो कहते हैं झारखंड में ही करना जरूरी है। क्यों फाइंडिंग निकाली आपने, बाकी सब जगह पे हुआ। एक प्रॉब्लम आइडेंटिफाई किया कि यहाँ पे आर्सेनिक की समस्या है, बंगाल में भी आर्सेनिक की समस्या है, बंगाल के लोगों ने आर्सेनिक का एब्जॉर्बेंट निकाला, उसके हार्म्स हैजार्ड्स स्टडी करी, वहां पे हमने नहीं करी। अब आपका ये एम्पिरिकल रिसर्च है, बट उस आर्सेनिक के लिए एब्जॉर्बेंट बनाना, फिल्टर बनाना, वो आपका अप्लाइड रिसर्च है। हियर आपने रिसर्च किया, कंट्रीब्यूट किया, सोसाइटी में पेपर छापा, एच इंडेक्स बढ़ा, बट क्या वही सोसाइटी को बेनिफिट होगा या कुछ और चाहिए? फाइनली कुछ और चाहिए आपके सोसाइटी के बेनिफिट के लिए? कुछ कोई बताए मुझे, जी बताएं। प्रोडक्ट के फॉर्म में लाना जरूरी है, अदरवाइज कॉमन यूजर, पॉपुलर पॉपुलेशन को, मासेस तक वो रिसर्च जिसको हमने वर्ड कहा सोसाइटी, वो सोसाइटी के लास्ट माइल तक नहीं पहुंचेगी जब तक आपको उसने प्रोडक्ट में चेंज नहीं किया। अब आपके रिसर्च को कन्वर्ट करना होगा प्रोडक्ट में। रिसर्च की आपने प्लानिंग कर ली, प्रोडक्ट के बारे में भी सोचा और सोसाइटी के बेनिफिट के लिए भी सोचा। अब काम बैक गैप कहाँ रहा? प्रोडक्ट बनाने में। प्रोडक्ट बनाने के लिए जब आप एक नई टेक्नोलॉजी लेकर के आएंगे, एक प्रोसेस या एक प्रोडक्ट जिसके लिए आप कहते हैं कि ये पहले नहीं एग्जिस्ट कर रहा था, मैंने अपने दिमाग से खुद सोच के मैंने बनाया है और मैं इसको मासेस तक ले जाना चाहता हूं। आपने काम किया, 3 साल आपने लगाए, 4 साल लगाए, 5 साल लगाए, आपने रिसोर्सेज यूज किए जहां पे आप रिसर्च इंस्टीट्यूट्स में हैं, आपको सबसे बेस्ट सोफिस्टिकेटेड इंस्ट्रूमेंट्स दिए गए टेस्ट करने के लिए, बहुत सारा आपको फील्ड स्टडी करने के लिए इन्वेस्टमेंट किया गया। अब आपको भी कुछ चाहिए, आपके इन्वेस्टर को भी कुछ चाहिए। तो हम पेटेंट का एक और नाम हम कहते हैं, पेटेंट इज ए अवार्ड फॉर द इन्वेंटर एंड ए रिवार्ड फॉर द इन्वेस्टर। आपकी प्रोसेस या आपके प्रोडक्ट को पेटेंट के फॉर्म में लाना, प्रोटेक्ट करना और उसके बाद उसको प्रोडक्ट फॉर्म तक ले जाना, ये आपकी एक जर्नी है। मैं चाहिए अब तो मैं रिसर्चर्स के लिए यही रिक्वेस्ट कर रहा था कि आपके रिसर्च जो प्लान करी सोसाइटी तक आने के लिए प्रोडक्ट फॉर्म में लाना होगा। प्रोडक्ट फॉर्म में लाने के लिए आपके रिसर्च प्लानिंग में सुबह मॉर्निंग में लेक्चर हुआ, पेटेंट्स की डेफिनेशन, पेटेंट की पोर्टफोलियो, जो कि ऑर्गेनाइजेशन के लिए मुझे चीफ गेस्ट सर ने बताया आपको। फिर उसके बाद आपकी इस पूरी स्टडी के लिए क्या क्या आपके होमवर्क होने चाहिए उसके लिए शिवकामी मैम ने आपको बताया। तो काफी अच्छा सा आपका एक स्ट्रेटजिक ट्रेनिंग चल रही थी। मैं बीच में डिस्टरबेंस आ गया, आपका बातें याद दिला रहा हूँ आपकी पूरे बैकग्राउंड की, आपने जो काम किया उसमें आपको अभी और कुछ करना है। तो प्रोडक्ट बनाना, उसको प्रोटेक्ट करना, प्रोटेक्ट करने के लिए सफिशिएंट लॉ मैकेनिज्म है, और उसके लिए आपको एक सर्टिफिकेट्स भी लेना होता है, बिल्कुल उसी तरह जैसे आप गाड़ी निकालने से पहले अपना ड्राइविंग लाइसेंस और गाड़ी की आरसी का अपनी गाड़ी में आप रख लेते हैं। गाड़ी की आरसी क्यों? कि पुलिस वाला ना पूछे कि चोरी की गाड़ी तो नहीं है। ड्राइविंग लाइसेंस क्यों? आप एक वैलिड ड्राइवर हो। दो चीजें आपने ली ना, एक आपकी सर्टिफिकेट है, दूसरा एक गाड़ी का सर्टिफिकेट है। दो चीजें हैं, और एक तीसरा और है आपके साथ में, इंश्योरेंस लायबिलिटी के लिए। चौथा और है कि हाँ आपकी गाड़ी पॉल्यूशन स्टैंडर्ड्स के बिलो जो है कि एमिट कर रही है। वो दो और रेगुलेटरी रिक्वायरमेंट्स हैं, एक लायबिलिटी की और एक जो है कि आपके गाड़ी के हेल्थ की। जैसे ये चार डॉक्यूमेंटेशन आप लेके चलते हैं, उसी तरह से आपके अपनी क्रिएटिविटी के प्रोटेक्शन के लिए भी मैकेनिज्म है, अलग अलग फॉर्म्स। एज ए रिसर्चर आप प्रोडक्ट या प्रोसेस देंगे, जो यहाँ पे स्टूडेंट्स हैं अभी नहीं है, आगे जॉब में जाएंगे, जॉब करेंगे तो वो भी प्रोडक्ट या प्रोसेस डिलीवर करेंगे। नहीं करेंगे, अपना बिजनेस शुरू किया, अपना स्टार्टअप शुरू किया, तो अपनी सर्विसेज एंड प्रोडक्ट लेके आए, प्रोडक्ट के लिए वो भी एक ब्रांड नेम सोचेंगे, अपने सर्विसेज के लिए अब भी एक ब्रांड नेम सोचेंगे, तो वो भी एक रिक्वायरमेंट है। इसके लिए हमारा पहले पेटेंट हो गया, प्रोडक्ट प्रोसेस के लिए, आपके प्रोडक्ट लाइंस के लिए आपने एक ब्रांड नेम सोचा, आपका ट्रेडमार्क हो गया। इस तरह से ही आपका जो न्यू डिजाइन प्रोडक्ट पैकेजिंग के लिए लेके आते हैं, उसके लिए न्यू डिजाइन रजिस्ट्रेशन होते हैं। टाइमलाइन सभी के लिए है, पेटेंट की 20 साल है, ट्रेडमार्क की 10 साल है, डिजाइन के लिए 10 + 5 15 साल है। 10 साल के बाद कंटिन्यू भी कर सकते हैं, पेटेंट को 20 साल के बाद कंटिन्यू नहीं कर सकते, बट रिक्वायरमेंट होती है कि 20 साल के अंदर ही आपको उसकी मेंटेनेंस फीस हर साल की पे करनी होती है। भी आपको मीट करना होता है, अपने ही प्रोजेक्ट कॉस्ट से करिए या अपने इंस्टीट्यूशनल कॉस्ट से करिए, या फिर जो इंडिविजुअल कैपेसिटी में जा रहे हैं उनको अपने पॉकेट से या अपने कॉस्ट से करना होगा। अब फीस में भी डिफरेंस आती है कि ये एक काफी बड़ी फीस है, ये एक थोड़ी छोटी फीस है। तो काफी कई बार मैंने इंस्टीट्यूशन से सुना है, यूनिवर्सिटी कहती है कि हमें 8,000 रुपए क्यों पे करना पड़ता है, इंस्टीट्यूशन कहते हैं, तो कहते हैं कि नहीं, ये एक फीस ही 8,000 रुपए है। जिन लोगों ने कहा कि हमें डिस्काउंट चाहिए, उनको 80% तक का डिस्काउंट मिला हुआ है। 80% डिस्काउंट एज ए इंडिविजुअल इन्वेंटर 1,600 रुपए, स्टार्टअप 1,600 रुपए, एमएसएमई 1,600 रुपए, एजुकेशनल इंस्टीट्यूट 1,600 रुपए। टोटल फीस खर्च होती है 5,600 रुपए की पेटेंट फाइल करते वक्त। बाकी जो ट्रेडमार्क है वो पूरी पूरी तरह से बिजनेस टूल है, यहाँ पे कोई डिस्काउंट किसी को नहीं होता। 4,500 रुपए स्मॉल एंटिटी एंड 9,000 रुपए लार्ज एंटिटी के लिए, दो ही कैटेगरी है। इंडिविजुअल कैपेसिटी के लिए कोई नहीं है, 4,500 ही है। इस तरह से कॉपीराइट में जैसे उन्होंने सर ने बताया कि 500 रुपए फीस है, उसके ज्यादा जा करके जो सिनेमेटोग्राफ वगैरह होती है जो करोड़ों में बिजनेस करती है, उनके लिए सिर्फ 5,000 ही है। तो रजिस्ट्रेशन की रिक्वायरमेंट हो गई। इस तरह से आपके इंडिविजुअल ग्रुप के काम को लेकर के 3 तरह की क्रिएटिविटी आपकी आईपी प्रोटेक्ट होती है। अब इसके बाद एक और 2 आईपी के फॉर्म है जो कि आपके इंडिविजुअल की नहीं होती है, एक ग्रुप या फिर एक सोसाइटी या एक कम्युनिटी की होती है, जिसको कि जीआई ने अभी आपको बताया। जीआई एक तरह से हमारा पारंपरिक, जो अभी सुबह मोमेंटो दिया गया, आपने ढोकरा देखा, वो ढोकरा आर्ट था, मेटल वर्क, क्राफ्ट वर्क, झारखंड का ही है। ट्राइबल लोग वैक्स से कास्टिंग करते हैं, फिर वो वैक्स रिप्लेस हो जाता है एंड मेटल वहां पे प्लेसमेंट ले लेता है। तो बंगाल झारखंड से यहाँ से बना, उसके बाद आंध्रा में भी बनता है ढोकरा मेटल आर्ट वर्क। तो ये पारंपरिक एक कम्युनिटी है जो उसको बनाती है, और वही जहाँ पे वो डिसेमिनेट हो गई है देश के दूसरे हिस्से में, वो लोग भी बनाते हैं। तो उसको हम कहते हैं ज्योग्राफिक इंडिकेशंस। उसके साथ 3 चीजें एट्रीब्यूट्स होती हैं मेनली। लोकल एट्रीब्यूट्स बेसिकली आइदर कम्युनिटी और ज्योग्राफी, जो नेचुरल एरिया है। तो एग्रीकल्चर प्रोड्यूस है तो नेचुरल एरिया के लिए होता है, और अगर फार्म प्रोडक्ट हैंडीक्राफ्ट प्रोडक्ट है तो उसके लिए वो कम्युनिटी इन्वॉल्व होती है। एंड ये कम्युनिटी नॉलेज होती है, इसके लिए कोई न्यू क्रिएटिविटी नहीं होती है। जैसे कि हम ब्रांड पेटेंट या डिजाइन में हम न्यू क्रिएटिविटी की बात कर रहे थे फ्रॉम आवर ओन, ट्रेडमार्क में भी आवर ओन एक ब्रांड के लिए बात करते हैं। यहाँ पे होती है बात की पहले से चली आ रही थी, अब कॉमन यूज में है, हम उसकी एक वैल्यू प्रोपोजिशन चाहते हैं, इसलिए जीआई को भी रजिस्ट्रेशन किया जाता है। इसी तरह से जो लोग अभी फार्मिंग बैकग्राउंड से, फार्मर्स की फैमिली से, वो भी समझ ले थोड़ा सा कि फार्मर्स भी क्रिएटिविटी करते हैं, किसानों की भी क्रिएटिविटी होती है, जहाँ पे नई सीड वैरायटीज आती है अलग अलग, तो उनके लिए भी लॉ है, प्रोटेक्शन ऑफ प्लांट वैरायटीज एंड फार्मर राइट्स एक्ट, जहाँ पे फार्मर्स जो है कि ब्रीडिंग करें, ब्रीडर्स ब्रीडिंग करें, अच्छे से अच्छे मैक्सिमम यील्ड की वैरायटीज डेवलप करके ले आए, तो वो एक अलग लॉ में प्रोटेक्शन होता है। उसको यहाँ पे पीपीवीएफआर करके लोगो दिया हुआ है। इस तरह से अलग अलग करके जो आप लोग माइनिंग में हैं, आप लोग सॉफ्टवेयर यूज करते हैं, आप लोग जो डिवाइस यूज करते हैं, आपके मोबाइल में एक छोटा सा SICLD जिसको कहते हैं IC जो होती है, उसके इंटीग्रेटेड सर्किट डिजाइन, उसके लिए भी एक अलग रजिस्ट्री है। तो रजिस्ट्री का काम होता है उसको रजिस्टर करना और उसको प्रोटेक्शन को देना। अभी तो 2 ही SICLD रजिस्ट्री है, एक BEL बैंगलोर से, दूसरी जो है कि इसरो से रजिस्ट्री हुई है इंटीग्रेटेड सर्किट है। और अभी नई पॉलिसी आ रही है कि इंटीग्रेटेड सर्किट हमारे इंडिया में बनाई जाए, तो और भी नई चीजें आने वाली हैं R&D होने में। तो मैं ये बता रहा था कि IP के फॉर्म्स आप यूज करते हैं, समझते हैं, और एप्लीकेशन में भी है। अब मैं NRDC से आया हूं यहाँ पे आप सबको बताने कि आपने IP क्रिएट कर ली, आपने सोचा, वैल्यू भी समझ ली, क्रिएट भी कर ली। अब क्रिएट करने के बाद जैसे कि उन्होंने, मेरे मित्र ने बताया कि प्रोडक्ट फॉर्म में लाना मार्केट में, तो इसके लिए अगर कोई है तो NRDC, नेशनल रिसर्च डेवलपमेंट को नाम शायद किसी ने पहले ना सुना हो, जो सिम्फर के हमारी फैमिली के लोग हैं वो जानते होंगे थोड़ा सा नाम पहले से। किसी और ने सुना होगा नाम सिम्फर का, मतलब कि NRDC का पहले, सिम्फर के अलावा? नहीं? तो फिर मैं हमेशा ही अच्छा लगता है मुझे बताना, जितने लोगों ने इसमें से, कितने लोग हैं जरा हाथ उठाएं जिन्होंने वोट डाला है? वोट डाला है, वोट डाला है आपने? आपकी उंगली में नीला निशान लगता है? जब नीला निशान लगता है हम कहते हैं कि फ्रॉम NRDC वी टच्ड एवरी सिटीजन ऑफ इंडिया। आपने अपने आसपास सोनालिका ट्रैक्टर देखा है? देखा है? अमूल स्प्रे डब्बे का दूध देखा है? कितने लोगों ने ब्लड डोनेट किया हुआ इसमें से? ब्लड बैग्स देखे हैं आपने? पॉली ब्लड बैग्स? तो NRDC 1953 में बनाई गई थी, पंडित जवाहरलाल नेहरू एंड और फर्स्ट DG ऑफ CSIR डॉक्टर संती स्वरूप भटनागर। इट वाज मीन एंड पर्पस्ड फॉर डेवलप की हुई टेक्नोलॉजी जो है सभी CSIR लैब से, उन टेक्नोलॉजीज को मार्केट में लाना प्रोडक्ट फॉर्म में। तो लैब की टेक्नोलॉजीज को प्रोडक्ट के फॉर्म में वहां लाने के लिए तो हमारे पहले चेयरमैन डॉक्टर कस्तूर भाई लाल भाई, जो कि इंडस्ट्री मिनिस्टर भी थे, उन्होंने एक टेक्नोलॉजी ट्रांसफर करी, उनकी इनिशिएटिव से हुआ था ये। डॉक्टर वर्गीज कुरियन जब इंडिया में आए, उनको श्वेत क्रांति का जनक कहा जाता है। उनकी जरूरत थी कि उन्होंने मिल्क रिवॉल्यूशन में कोऑपरेटिव बना करके काफी अच्छे से मिल्क इकट्ठी कर ली है और मिल्क को वो पास्चराइज्ड फॉर्म में ले जाकर के बॉटल में सप्लाई कर रहे हैं। अब उनके सामने एक चैलेंज था कि उनको जो है कि अब उसको पाउडर फॉर्म में करना है। तो पाउडर फॉर्म में टेक्नोलॉजी लाने के लिए उस समय तक US की सिर्फ जो है कि काउ मिल्क पाउडर आया करती थी। तो CSIR की CFTRI मैसूर में एक लैब है, उन्होंने बोला बफेलो मिल्क को भी स्प्रे ड्राइड करके मैं टेक्नोलॉजी पाउडर बना सकता हूँ। तो हमारे चेयरमैन सर ने सिर्फ 10,000 रुपए में टेक्नोलॉजी को ट्रांसफर किया डॉक्टर वर्गीज कुरियन को। वो उस समय खेड़ा मिल्क यूनियन हुआ करता था, वहां से उन्होंने टेक्नोलॉजी एक्सेप्ट करी और आनंद में नया प्लांट लगाया जहां पर कि पाउडर्ड मिल्क बनाया जाने लगा और उस कंपनी का नाम हुआ अमूल। सभी ने आज सुबह बटर खाया होगा अमूल का। तो लाइक वाइज हम जब से काम कर रहे हैं, टेक्नोलॉजी ट्रांसफर इंडियन लेवलिंग की इलेक्शन कमीशन को ट्रांसफर की गई। अगेन इट इज CSIR टेक्नोलॉजी फ्रॉम CSIR NPL। आज भी उसकी रॉयल्टी इलेक्शन कमीशन हमें पे करती है, जब भी आपके स्टेट में इलेक्शन होता है आती है CSIR को उसकी रॉयल्टी ट्रांसफर हम वापस भी करते हैं। तो NRDC बनी थी टेक्नोलॉजी को कॉमर्शलाइज करने के लिए और आज भी हम यही काम करते हैं। हमारा ये रिस्पॉन्सिबिलिटी है आपके साथ, आपके लिए काम करना। तो हम सभी के लिए काम करते हैं, सिर्फ CSIR लैब्स ही नहीं, आप एज ए इंडिविजुअल भी अगर आप हमें अप्रोच करते हैं कि समथिंग न्यू क्रिएटिव विथ यू एंड यू आर लुकिंग फॉर सपोर्ट, एक अच्छा आइडिया है जो कि सोसाइटी को इस फॉर्म में बेनिफिट कर सकता है आगे जा करके, एंड कंप्लीट हैंड टू हैंड सपोर्ट अवेलेबल फ्रॉम NRDC आपके लिए। आपने न्यू इन्वेंशन बताई, पेटेंट फाइल करना है, वी विल सपोर्ट यू फॉर फाइलिंग अ पेटेंट। उसके आगे लैब में डेवलपमेंट करना है, उसके लिए वी विल सपोर्ट यू अगेन फॉर द फाइनेंशियल सपोर्ट। सो अभी तक हमारे पास जो है कि 5,000 टेक्नोलॉजी लाइसेंस हमने एग्रीमेंट साइन किए हुए हैं, 2,000 पेटेंट असिस्टेंस हमने प्रोवाइड किया हुआ है और 2,500 से ज्यादा हमने जो है कि टेक्नोलॉजी हमारे पास अवेलेबल है अभी कॉमर्शलाइज करने के लिए। ऐसे ही जैसे इंट्रोडक्शन बता रहे थे, स्टार्टअप इंडिया में मैं कुछ काम कर रहा हूँ, तो अब तक जो है कि हमने लगभग 10,000 स्टार्टअप्स के साथ इंटरेक्शन भी रहा है, जिनके साथ कुछ कुछ अलग अलग एक्टिविटीज में काम भी हुआ है। तो ये सब एक्टिविटीज हैं हमारे एक ऑफिस दिल्ली में है, मेन हेड ऑफिस दिल्ली में। उसके अलावा हमारे 3 आउटरीच ऑफिसेज हैं बेसिकली, एक विशाखापट्टनम में जो कि सदर्न पार्ट को उधर कैटर करता है, दूसरा वेस्टर्न रीजन में पुणे में हमारा एक आउटरीच ऑफिस है, एंड एक नॉर्थ ईस्ट में हमारा आउटरीच ऑफिस है गुवाहाटी में। 3 आउटरीच ऑफिस के अलावा हमारे पास 3 इंक्यूबेशन सेंटर्स हैं, एक दिल्ली में, एक बेंगलुरु में नेशनल एरोस्पेस लेबोरेटरी CSIR, जैसे ये सिम्फर लैब है वैसे ही वहाँ पे एक एरोस्पेस लेबोरेटरी है, वहाँ पे हमारा इंक्यूबेशन सेंटर है। ओनली पर्टिकुलर टू द एरोस्पेस सेक्टर वी आर वर्किंग विद टाटा सोशल अल्फा, एंड कुछ न्यू इनोवेशंस नए स्टार्टअप्स के साथ अगर वहाँ पे आएंगी तो आपको वो भी देखने को मिलेंगी। अभी तो यही है कि हम कुछ एविएशन इंडस्ट्री में कुछ काम करें, बेसिकली अभी वी आर स्टार्टिंग विद द सर्विस सेक्टर, देन प्रोडक्ट्स हम बाद में जाएंगे, स्मॉल एयरक्राफ्ट्स लाइक जो NEL की एक डेवलपमेंट है। एक दूसरा इंक्यूबेशन सेंटर है हमारा भुवनेश्वर में, दे आर ऑल्सो डूइंग इन मटेरियल साइंस बेसिकली एंड टेस्टिंग सर्विसेज एंड अदर्स। एक लेदर रिसोर्स में भी हमारा एक न्यू इंक्यूबेशन सेंटर चेन्नई में आने वाला है बहुत जल्दी। तो ये हमारी मेनली जो हमारी एक्टिविटीज हैं जो मैं बताना चाहता हूँ कि हमने टेक्नोलॉजी ट्रांसफर करना हमारी रिस्पॉन्सिबिलिटी है और हम करते हैं आपके लिए, इंस्टीट्यूशन के लिए, सभी के लिए। अब जो टेक्नोलॉजी ट्रांसफर हमारा कोर मैंडेट है तो IP प्रोटेक्शन सबसे पहले जरूरी हो जाता है। जिस तरह से आपको मैंने बोला आप गाड़ी लेके निकलते हैं तो आपके साथ RC होनी जरूरी है, तो जब आप टेक्नोलॉजी को कमर्शलाइज करने के लिए निकलते हैं तो आपकी टेक्नोलॉजी की प्रोटेक्शन भी जरूरी है कि हाँ ये पेटेंट प्रोटेक्टेड है। 1 2 3 4 5 सर ने प्रेजेंटेशन में दिखाया था कि टाटा की नैनो के साथ भी कितने सारे पेटेंट्स एक साथ हैं, और भी प्रोडक्ट्स में दिखाया था। मैडम ने बताया कि एक बार जब उन्होंने स्टडी करी DME सिंथेसिस के लिए तो उन्होंने भी कितने सारे पेटेंट्स की स्टडी करने की बात करी। तो इस तरह से ही जब भी आपकी टेक्नोलॉजी आपने डेवलप करी है उसको बेटर फॉर्म में हर एक तरह से प्रोटेक्ट करके आगे लेकर के कॉमर्शलाइज करना जरूरी है। और जब वो प्रोटेक्शन होती है तभी इंडस्ट्री को भरोसा होता है कि यस मुझे इस टेक्नोलॉजी के लिए 10 लाख रुपए देने चाहिए, और वो प्रोटेक्शन नहीं होती है तो कहती है कि मैं तो सिर्फ 5,000 ही दे सकता हूँ, उससे ज्यादा मेरा तो फंड है ही नहीं। बट प्रोटेक्शन है तो हाँ 10 लाख तो ठीक है, दे सकते हैं। तो एक डिसीजन मेकिंग में भी इस प्रोटेक्शन का आपको सेफ्टी होती है, तो इसलिए टेक्नोलॉजी डेवलप जब भी करें प्रोटेक्शन लेकर के चले, एंड वो सपोर्ट हम प्रोवाइड करते हैं। हम टेक्नोलॉजी जब भी हम मार्केट करते हैं इवन फ्रॉम द CSIR सिम्फर या CSIR की अदर लैब्स, वी गेट इट असाइंड इन द नेम ऑफ द NRDC, देन वी फर्दर लाइसेंस इट टू द इंडस्ट्रीज, license it to industries on non-exclusive basis, and we collect the premium and then we collect the royalty post production, and that एक सर्विस मतलब कि एक एग्रीमेंट है विद ऑल पब्लिक फंडेड रिसर्च इंस्टीट्यूट, 70-30 रेशियो। 70% it goes back as a R&D cost to the lab, 30% is being retained by us as a management fees, but for the private individuals and other industries it is variable. We don't give it 70% there, 50% kind of thing, 50-50 share we hold. So yeah, support end to end, and it is success fees after the complete transaction when we collect, then only. तो वो अब जैसे कि अब इस फील्ड में काम करना है टेक्नोलॉजी कॉमर्स में, तो वी आर नॉट लिमिटेड टू एनी पार्टिकुलर सेक्टर। अब जो माइनिंग रिसर्च यहाँ बैठे हैं सोचे कि माइनिंग रिसर्च में आप क्या काम करते हैं, हम हर एक फील्ड में काम करते हैं, एंड कवरिंग द माइनिंग रिसर्च एज ए सिविल एंड बिल्डिंग, जनरल एंड मैकेनिकल। सो वी आर हियर from starting from agriculture, horticulture to aerospace, in every field we have a technology. मैंने बताया 2500 टेक्नोलॉजी हमारे पास है, मोस्टली केमिकल में अभी हम आजकल लाइसेंस कर रहे हैं, एग्रीकल्चर। कुछ हमारे पार्टनर्स जहां से हमने टेक्नोलॉजी शुरू करी, CSIR से हमारी यात्रा शुरू हुई, और अभी CSIR के अलावा अदर मिनिस्ट्रीज के भी इंस्टीट्यूशन हमारे साथ में पार्टनर हैं जिनके साथ हमारा MOU more than 500 MOU are in force, and जिनकी बेसिस पे हमारे पास टेक्नोलॉजी मिलती है। कुछ एक इंस्टीट्यूशंस के लिए तो एक्सक्लूसिवली हम ही टेक्नोलॉजी कमर्शलाइज करते हैं, जैसे कि सेंट्रल सिल्क बोर्ड का यहाँ पे नाम लिया है मैंने, NIOT जो मिनिस्ट्री ऑफ अर्थ साइंसेज के अंडर आती है, उनकी सारी टेक्नोलॉजी हमारे पास होती है, हम ही कमर्शलाइज करते हैं एक्सक्लूसिवली। CSIR की टेक्नोलॉजीज पैरेलली कमर्शलाइज होती हैं फ्रॉम द CSIR लैब्स एंड फ्रॉम NRDC ऑल्सो, बोथ कहीं से भी आप अप्रोच कर सकते हैं। कुछ हमारे क्लाइंट्स जिनके लिए हम अदर सर्विसेज दे रहे हैं या फिर हमने न्यू टेक्नोलॉजी कमर्शलाइज करी है, जैसे बेमल है, जिन्होंने मैंने पूछा था ब्लड ब्लैक्स जिन्होंने ब्लड डोनेट किया हुआ है, हिंदुस्तान लेटेक्स इज ऑल्सो और लाइसेंसी जिनके वो ब्लड बैग्स आते हैं हीमोपैक नाम से, एंड वो भी एक हमारी सक्सेस स्टोरी में से है, जिसमें कि मैंने एग्जांपल दिया था इन्फेंट फूड, आर्टिफिशियल हार्ट बल्ब, ट्रैक्टर, स्मॉल एसपी ट्रैक्टर्स, डिस्पोजेबल ब्लड बैग्स एंड इंडिविजुअल इंक जो कि हमारी हिस्ट्री में है। रिसेंट्स में अभी हम एक यूनिवर्सिटी की टेक्नोलॉजी पीछे से उन्होंने पूछा था स्टेट यूनिवर्सिटीज में फैसिलिटीज नहीं है। बिल्कुल ही एक स्टेट यूनिवर्सिटी कुमाऊं में, नैनीताल के प्रोफेसर ने, उन्होंने एक फंडिंग मिनिस्ट्री ऑफ एनवायरनमेंट से ली थी। उस फंडिंग के बेसिस पे उन्होंने प्लास्टिक वेस्ट को ग्राफीन में कन्वर्ट करने के लिए बहुत ही अच्छी टेक्नोलॉजी डेवलप करी, एंड वी हैव लाइसेंस इट टू 3। तो ग्राफीन फ्रॉम प्लास्टिक वेस्ट टेक्नोलॉजी स्टैब्लिश्ड, लोगों ने ली है और अभी हम उसको कॉमर्शलाइज भी कर रहे हैं। एंड नाउ वी आर इन प्लानिंग टू ट्रांसफर द टेक्नोलॉजी टू द सिंगापुर बेस्ड ऑन एंटरप्रेन्योर, क्योंकि वहां पे भी प्लास्टिक वेस्ट है एंड दे नीड दैट। ग्राफीन के यूज आपको पता है, बीइंग माइनिंग के सभी लोग आप लोग हैं, आप जानते हैं कि बैटरीज जो आ रही हैं, ईवीज जो आ रही हैं, उसमें ग्राफीन को यूज होना ही होना है। तो ग्राफीन चाहिए ही। इन द कोविड टाइम्स ऑल्सो हमने एक टेक्नोलॉजी कॉमर्शलाइज करी, काफी क्विकली, हमने 3 to 4 मंथ्स में करी। इंडियन नेवी ने एक टेक्नोलॉजी डेवलप करी थी, सिंपल सी टेक्नोलॉजी थी, ब्रेदेबल पीपीई किट, बिकॉज पीपीई का उस समय जो रेगुलेशंस थे उसके हिसाब से जो है कि प्लास्टिक सीट्स की तरह से होते थे, एंड डॉक्टर वाज स्वीटिंग इनसाइड द डैट। काफी लोगों ने न्यूज भी पढ़ा होगा कि स्वीटिंग की प्रॉब्लम की वजह से डॉक्टर्स की ज्यादा प्रॉब्लम हो रही है। तो वन डॉक्टर फ्रॉम नेवी ही डेवलप दिस पीपीई किट, इट इज ब्रेदेबल एंड अगेन इट इज सेफ इनफ टू प्रोटेक्ट द कोविड वायरस। सो हमने उसे 6 लोगों को लाइसेंस किया एंड काफी अच्छी रॉयल्टी भी आई। एक कंपनी ने तो 1.5 करोड़ पीसेस उसके सेल किए, तो नेवी को उसकी रॉयल्टी जा चुकी है। इसके अलावा कुछ हमारा काम कंसल्टेंसी प्रोजेक्ट्स में भी है। हैवी इंडस्ट्रीज के साथ हम काम कर रहे हैं, डेवलपमेंट्स, उनके पेटेंट फाइलिंग करना। स्टार्टअप इंडिया के साथ हमने काम किया। इंडियन ऑयल के साथ हमारा काम है, जहाँ पे हम स्टार्टअप्स को सपोर्ट करते हैं अप टू फंडिंग ऑफ ₹1 to 3 करोड़। आपका जो जो गुड आइडियाज को लेकर के आप प्रोडक्ट टेक्नोलॉजी डेवलप करना चाहते हैं, उसके लिए जो है कि डेवलपमेंट होती है, को डेवलपमेंट होती है, आईएसएल की फंडिंग एंड फॉर योर स्टार्टअप। कुछ और भी प्रोजेक्ट्स हमने कंप्लीट किए हैं अभी, बाहर भी कुछ टेक्नोलॉजी के प्रोजेक्ट्स हमने कंप्लीट किए हैं। इसके अलावा 2-3 चीजें जो आपके लिए जो स्टूडेंट्स हैं, आप अगर अपनी न्यू टेक्नोलॉजीज लेकर के सोच रहे हैं कुछ काम करने के लिए, तो 2 चीजें। पहली चीज आईपी असिस्टेंस आपके लिए मोस्ट ओपन एवरी टाइम, जब भी आप कुछ क्रिएटिव काम कर लेते हैं। आईपी असिस्टेंस के लिए मुझे लिख सकते हैं, मेरा ईमेल आईडी sanjeev@nrd.in। इंडिया में पेटेंट फाइलिंग करने के लिए कोई खर्च आपको नहीं उठाना पड़ेगा, अप टू द ग्रांट, 0, 1 रुपए भी खर्च नहीं करना है। सब्जेक्ट टू इट इज पेटेंटेबल सब्जेक्ट मैटर, पेटेंट हो सकता है, जरूर से हम फाइल करेंगे। और ग्रांट होने के बाद सर्टिफिकेट आपको हैंड ओवर करते हुए कहेंगे कि अब आपकी मर्जी, आप इसे जैसे चाहो कॉमर्शलाइज करो, यूज करो, मैन्युफैक्चर करो, जो भी आपका प्लान है, आपकी टेक्नोलॉजी आपको करना है। एंड फर्दर लाइबिलिटीज 3 साल के बाद ग्रांट होती है, 2 साल के बाद ग्रांट होती है, अगले 17-18 साल की एनुअल फीस आपको पे करनी है। हमारी रिस्पॉन्सिबिलिटी आपके इन्वेंशन डिस्क्लोजर को इस फॉर्म में लाना कि वो पेटेंट ग्रांट हो जाए, ये हमारा काम है। एंड उसकी सारी कॉस्ट हम अपने गवर्नमेंट फंड से बियर करते हैं। दूसरी, जो स्टार्टअप्स चाहते हैं कि स्टार्टअप बनाना चाहते हैं, एंटरप्रेन्योर्स, यहाँ पे इनके पास आइडिया है, इंक्यूबेशन सर्विसेज आर ओपन टू अस। हमारे 3-4 जो इंक्यूबेशन सेंटर है, वहाँ पे कभी भी आप आ सकते हैं, आइदर फिजिकल और वर्चुअल, जो भी आप मोड सेलेक्ट करें, हमारे इंक्यूबेशन सर्विसेज आर ओपन टू यू। एंड इसके अलावा जो रिसर्चर्स कुछ एमएसएमई से अगर यहाँ बैठे हैं, या फिर आप में से कुछ लोग एंटरप्रेन्योरशिप सोच रहे हैं कि किसी स्टार्टअप के साथ करने के लिए, तो हमारी एक फंडिंग स्कीम है 1 करोड़ रुपीज की। इट इज ग्रांट टेक्नोलॉजी डेवलपमेंट एंड वैलिडेशन। उसके नेक्स्ट फेज में है कॉमर्शलाइजेशन, जो हमारी टीडीवीसी स्कीम है। डिटेल्स में मैं यहाँ पे बताना चाहूंगा। यहाँ पे स्टार्टअप्स, एमएसएमईज, इनक्यूबेटर्स टू ब्रिंग देयर टेक्नोलॉजीज टू कमर्शियल लेवल। जो आपने बोला कि आपका प्रोडक्ट कन्वर्ट करना है, तो प्रोडक्ट कन्वर्ट करने के लिए जो जर्नी है, पेटेंट फाइलिंग के बाद से आपका जो 0 लेवल पे आप टीआरएल लेवल 2 to 4 पे थे, अब उसको 6 to 8 तक लाने का काम करने के लिए आपको फंडिंग भी चाहिए। तो आपकी उस जर्नी में ये सपोर्ट हमारी तरफ से है। हमने अब तक 7 लोगों को सपोर्ट किया हुआ है। एलिजिबिलिटी ये है। नेक्स्ट फेज में जब आप उसको प्रोडक्ट लॉन्च करेंगे मार्केट में कॉमर्शलाइज करने के लिए, तो अगेन 1 करोड़ रुपीज इज अवेलेबल फॉर यू, subject to your business plan and how we'll be going to return it. So it will be equity investment into your company, and few thrust areas we have selected, but एक photograph मैंने example में ले लिया है, our first startup which has come up with a new technology and signed the agreement in presence of our secretary DSIR and कलाईसली मैडम and DG CSIR। ये उनका प्रोडक्ट था। आपके भी फील्ड में काम आता है शायद ये, जो फायर प्रूफ वेस्ट material is so capable that it can bear प्रोटेक्टिव इन्वायरमेंट कैन गिव 360 सेकेंड्स। आग में जाके आ सकते हैं वापस। So it's good. Patent has been filed. Brand name also protected. And now this year they are completing its validation activities. Testing, everything is done. So like that, IP assistance मैंने आपको डिटेल्स बताई, आप इसकी स्कीम का फायदा ले सकते हैं। They have मतलब all kind of supports, मतलब कि kind of mixed users, clients हमारे पास हैं। बस यही वास्प्रोस, ये V&A जो लिखा हुआ है वास्प्रोस, ये कंपनी यहीं से रांची झारखंड से। They are good in manufacturing arsenic absorbents. They got a technology good and उनकी arsenic absorbent इतनी अच्छी है कि वो अगले 6 साल तक अच्छा काम करती है। इसी तरह से कुछ एग्रीकल्चर स्टार्टअप्स हैं, सिल्क बोर्ड्स हैं, एंड इवन जो नेशनल शुगर इंस्टीट्यूट, इसके अलावा जो है कि सर गंगाराम हॉस्पिटल के लिए भी हमने कैंसर रिसर्च के लिए उनका भी पेटेंट हमने फाइल किया एट आवर ओन फंडिंग स्कीम में। सो दीज आर द स्कीम्स जो मैंने आपने बताई, ये हमारा काम है। आपके पास अपॉर्चुनिटीज पूरी हैं, ओपन है, यू कैन राइट टू अस। एंड बाकी ज़्यादा डिटेल्स की बजाय यही खत्म करता हूँ। बस क्वेश्चन आंसर्स मुझे चाहिए आपकी तरफ से, जिनकी क्वेरीज रह गई है पूरे दिन में। मैंने अपना नंबर भी शेयर किया हुआ है, शायद मैं फोन पे बात ना कर सकूं, लेकिन व्हाट्सएप मैसेज कर दीजिएगा, मैं रिप्लाई कर दूंगा। जब भी आपकी एक क्वेरी हो कि आपको समथिंग यू गॉट यूरेका मोमेंट, जब भी आए आपको, जब भी यूरेका मोमेंट आए कि पेटेंट फाइल करना है, आप मुझे लिखिए, हम पेटेंट फाइल करेंगे। नहीं, अभी तो नहीं आएगा, मतलब कि वो एक मैसेज था ना कि अपने नंबर कम आए तो अफसोस कम होता है, दोस्त के नंबर ज्यादा आए तो ज्यादा अफसोस होता है। तो आपका दोस्त जब फाइल करेगा तब आपको ज्यादा अफसोस होएगा। तो बी मोटिवेटेड, टाइम जरूर आएगा, आप अपना पेटेंट फाइल करेंगे। क्लोजिंग नाउ, कोई क्वेश्चन नहीं है? सिक्योर फायर वो 360 सेकेंड्स तक प्रोटेक्शन देता है। फायर सूट इसकी कैपेसिटी है कि इस टेम्परेचर तक जो है कि फायर के अंदर जाकर के आप वापस आ सकते हैं 360 सेकेंड्स में।
360 सेकेंड्स में 6 मिनट्स।
हाँ,
6 मिनट में कौन सा काम हो जाएगा?
हो जाता है। तो फायर सेफ्टी वर्क्स जो फायरमैन है उनको रिक्वायरमेंट होता है इस तरह का। अभी तक ऐसा नहीं है जो 360 सेकेंड्स का भी टॉलरेंस दे सके, तो ये एक थ्रेशोल्ड तक पहुंचा है।
वो जो ड्रेस है वो ड्रेस ही बनाया।
ड्रेस वो जो यूनिफॉर्म है वो।
थैंक यू।
सर मैं मनीष कुमार, सीएसआर सिम्फर में वैज्ञानिक हूँ।
जी बिल्कुल।
एक इंफॉर्मेशन चाहिए था। एनआरडीसी सीएसआईआर के वैज्ञानिकों को स्टार्टअप या स्पिन ऑफ कंपनी करने के लिए क्या हेल्प करती है?
सर आपका वेल स्टैब्लिश्ड रूल है, लॉ है। आप अपना स्टार्टअप स्टैब्लिश करना चाहते हैं, उसी सर्विस रूल्स को आप यूटिलाइज कीजिए, जहाँ पे आप 3 साल के लिए लीन जाते हैं या 2 साल के लिए छुट्टी लेते हैं एंड अपना स्टैब्लिश करते हैं। अभी तो वही एग्जिस्टिंग रूल है। नए रूल में मॉडिफिकेशंस आने वाले हैं, जब भी आ जाएंगे तो उसके बाद आप कर सकते हैं। आप इसको बेटर अंडरस्टैंडिंग के लिए एनसीएल पुणे के जो पॉलिसी है उसको थोड़ा सा समझिए, और साथ में शिवकामी मैम हैं यहाँ पे, वो भी बताएंगी, एग्जांपल्स दे सकती हैं। तो एनसीएल में स्टैब्लिश मॉडल ऑलरेडी इन प्रैक्टिस है, अदर लैब्स में अभी प्रैक्टिस में नहीं है, तो वो आप यहाँ पे भी आप विद परमिशन ऑफ डायरेक्टर आप यूज कर सकते हैं। एंड
Is it through NRDC only or
It is not through NRDC, it is directly within आपके खुद के ही पर्सपेक्टिव में है। अभी थ्रू NRDC आप जब कंपनी स्टैब्लिश कर लेते हैं, देन आवर सपोर्ट इज ओपन टू एवरीवन।
थैंक यू
ऑल स्टार्टअप्स। इवन आपको स्टार्टअप रजिस्ट्रेशन करने में भी कोई प्रॉब्लम होती है तो आप मुझे बता सकते हैं, बिकॉज आई एम वर्किंग विद स्टार्टअप इंडिया। तो मैं इसलिए रजिस्ट्रेशन देखता हूँ, वहाँ पे मेरी टीम है जो रजिस्ट्रेशन देखती है। एंड आफ्टर द रजिस्ट्रेशन व्हेन एप्लीकेशन कम्स फॉर टैक्स एग्जम्पशन अंडर सेक्शन 80 IAC, 3 साल तक इनकम टैक्स नहीं देना होता, ऐसा हमारे प्रधानमंत्री मोदी जी ने बोला है। तो वो जो उनकी प्रॉमिस है, उसके लिए एलिजिबल स्टार्टअप्स को पहचानना और उसको वो सर्टिफिकेट देना, वो हमारे पास वो काम है, हम उस काम को कर रहे हैं मुस्तैदी से।
सर वन क्वेश्चन।
जी बताएं।
Whenever a patent is copied by someone, they file a case. But sir, the case in India, you know that only dates are given by the honorable courts. But if the court case will come after 6 or 7 years, if the person dies, it will be very bad for that. So the government establish a different code for particular type of patent codes.
नहीं,
फास्ट ट्रैक कोर्ट सर
बिल्कुल भी स्लो नहीं है। आप उसके डेथ होने तक कोर्ट इंतजार नहीं करेगी। देखिए, पहले पेटेंट ऑफिस में आईपीएबी था, इंटेलेक्चुअल प्रॉपर्टी अपीलेट बोर्ड। उसको जब डिफंक्ट किया गया है तब यही कहा गया है कि हाई कोर्ट आईपी के केसेस को फास्ट ट्रैक मोड में सुनेगी। इवन द जज सैटरडे संडे को भी केसेस की हियरिंग करते हैं रिक्वायरमेंट के हिसाब से। तो मरने नहीं देंगे इन्वेंटर को, उसके पहले ही फैसला हो जाएगा।
ओके सर, थैंक्स।
हाँ, इतना लंबा नहीं है फैसला जो कि ये जमीन को लेकर के होता है। इतना लंबा फैसला नहीं, क्योंकि टाइमलाइन नहीं होता।
Sir,
टेक्नोलॉजी
one thing is not I also said, but in the government job, see with the giving the exams, when the papers are leaked, government is taking 7 to 8 years. In state government also, the student careers is also vanished, sir.
देखिए, वो अब इस मतलब कि इस फोरम के बाहर का सब्जेक्ट है।
Yes, sir. But it should be also a major example of.
हमारे पेटेंट के लॉ में सभी रूल्स के लिए टाइमलाइन दी हुई है। अगर आपका पेटेंट पब्लिश होता है तो कोई 6 महीने में ही आपको चैलेंज कर सकता है। टाइमलाइन सभी की यहाँ पे फिक्स की हुई हैं। तो हमारे कानून में टाइमलाइंस के बियॉन्ड कुछ भी नहीं आता। हमारे फैसले मतलब कि पेटेंट ऑफिस को फैसला देने का भी टाइमलाइन फिक्स है। पेटेंट ऑफिस में आपको रिक्वेस्ट करने का भी टाइमलाइन फिक्स है। आप 6 महीने के अंदर जवाब नहीं देते तो आपकी पेटेंट अबेंडन भी हो जाती है। तो सभी के लिए टाइमलाइंस फिक्स हैं। तो ऐसा मतलब कि बियॉन्ड टाइम्स का एक्सपेक्टेशन यहाँ पे तो नहीं है किसी में भी। इतने लंबी पेंडिंग्स ही नहीं है।
Yes, sir. Thank you, sir.
और असंतोष तो सब जगह बना ही रहता है, उसके लिए मैं कुछ नहीं कह सकता। तो संतुष्ट रहिए, कुछ नया काम कीजिए, कुछ नया आप भी पेटेंट करिए। कुछ और सवाल? हमारी वुमेन पावर से कोई क्वेश्चन नहीं आया। किसी को भी नहीं पूछना? नंबर है मेरा दिया हुआ। आएगा, बाद में मोमेंट आएगा कि मैंने कुछ बनाया था, मैं चाहता था पेटेंट करने के लिए, हो सकता है क्या? तो जब भी आए, आई एम अवेलेबल।
I have
मोस्ट
this
वेलकम।
question.
बहुत अच्छा लगा। नाम आपका?
Shruti.
जी श्रुति, बताइए।
So starting में ना the first speaker which we had, उन्होंने हमें बताया था कि within 31 months of filing a patent, हमें अगर हमें इंटरनेशनली उसको फाइल करना चाहते हैं तो हमें उसके
आगे
या उस ड्यूरेशन के बीच में ही हमें उसको भी फाइल करना पड़ता है। तो इफ आई स्टार्टेड अ बिजनेस, मैंने अपना पेटेंट फाइल कर लिया, इट्स बीन 2 to 3 years and now I'm planning to expand my business. अब मेरे को इंटरनेशनली भी पेटेंट चाहिए होगा, तो उस टाइम पे हमें सर ने बताया था ना कि हम नहीं कर सकते वापस से आफ्टर 31 months, तो फिर आई बी स्टक इन मिड।
आपका जो प्रोडक्ट है वो इम्प्रूव हो सकता है। आपका जो प्रोडक्ट है, आपने जो बनाया है, अभी जो इंडिया में पेटेंट लिया है वो इंडियन मार्केट के लिए है। आप बाहर जब ले जाना चाहते हैं तो आपको उससे अच्छा प्रोडक्ट देना होगा।
राइट।
तो आपके पास अपॉर्चुनिटी है अपने प्रोडक्ट को इम्प्रूव करने के लिए। प्रोडक्ट को इम्प्रूव कीजिए, डेल्टा एक्स डिफरेंस लाइए उसमें, और एक नया पेटेंट एप्लीकेशन फाइल कीजिए, और उसके बेसिस पे आप फॉरेन के मार्केट में एंट्री कीजिए। आपको 2 चीजें चाहिए, इम्प्रूवमेंट्स, उनकी स्टैंडर्ड्स, उनकी क्वालिटी के हिसाब से आपको टारगेट मीट करना है। दूसरी चीज आपको मीट करनी है, आपके पास कॉस्ट जो आपको लगेगी वो भी आपको कलेक्ट होना चाहिए। आपके पास एक बिजनेस पार्टनर उस कंट्री में जरूर होना चाहिए जिसको कि आप वो टेक्नोलॉजी दे करके एक्सपोर्ट करेंगे या फिर वहां पे प्रोडक्शन होगा। एंड अगर आप वो जो 2.5 साल का जो टाइमलाइन है वो इसीलिए है कि आप वो इन्वेस्टमेंट ढूंढ लें। जो 60 लाख रुपए तक का खर्चा सर ने बताया था मुझे, आप सभी को, हम सबको बताया था कि हमने इंडिया में फाइल किया, अगले 7 साल में 2023 तक 60 लाख रुपए खर्च हुए। तो ये 60 लाख रुपए हम अपने कॉस्ट पे लेकर के नहीं चल सकते। एज ए एंटरप्रेन्योर, एज ए बिजनेसमैन हम लेकर नहीं चल सकते। हमें उसको मार्केट से लेना होगा, प्रोडक्ट सेल करके या फिर पार्टनर्स लेकर के या फिर इन्वेस्टर्स लेकर के।
तो इफ आई इन्वेंट मैंने थोड़ा सा अपग्रेड कर लिया अपने प्रोडक्ट को,
आज फाइल कीजिए इंडिया में, विद इन 12 मंथ्स आप उसका जो है कि पीसीटी फाइल कीजिए, एंड देन आप अपना 1.5 साल का अगला स्वीट टाइम लीजिए उस कंट्री में एंट्री करने के लिए पार्टनर ढूंढ के। लेकिन उसके पहले पीसीटी फाइल कर लीजिए जब पार्टनर आप ढूंढ रहे होते हैं तो।
क्वेश्चन, हम लोग प्रोडक्ट को ना अपग्रेड करा जाता है, मतलब हमेशा करते रह जाते
जैसे आपके एप्पल के फोन आते हैं।
हैं। राइट। तो माय क्वेश्चन इज कि क्या हम लोग उस टाइम पेटेंट भी अपग्रेड होता रहता है उसके साथ, और कंपनीज हैव टू फाइल?
नहीं, पेटेंट अपग्रेड नहीं होता। पेटेंट के साथ एक चीज होती है, कुछ इंजीनियरिंग इन्वेंशंस में हम पेटेंट ऑफ एडिशन फाइल करते हैं, उसकी भी लाइफ उसके साथ ही खत्म हो जाती है जो हमारी पेरेंट एप्लीकेशन फाइल होती है, पहली एप्लीकेशन। लेकिन दूसरे कंट्रीज में ऐसा रूल नहीं है, वहां पे वो इंडिविजुअली चलती ही होती है। तो एडिशनल पेटेंट ऑफ एडिशन फाइल करने के लिए आप ना ही सोचे तो ज्यादा अच्छा है। हर बार आप न्यू पेटेंट एप्लीकेशन फाइल करने के लिए सोचिए, अपने बिजनेस कंपनी का पोर्टफोलियो बढ़ाइए। जितने पेटेंट्स आपके पास होंगे उतने ही आपको इन्वेस्टर का भरोसा ज्यादा होगा।
ओके,
तो जब भी इंक्रीमेंट करते जाए, फाइल करते जाए।
थैंक यू।
सर ने पोर्टफोलियो मैनेजमेंट मॉर्निंग में बताया था, आपने उस पर ध्यान नहीं दिया शायद। कुछ और क्वेश्चंस? नहीं? चलिए घर जाने का समय हुआ, काफी लोग जा भी चुके हैं। थैंक यू, धन्यवाद।
Thank you, sir, to all of you. In post-lunch session, we have two papers by Dr. Virendra Singh and Dr. S.K. Majumdar. So Dr. Virendra Singh has detailed about patent, copyright, trademarks. I think you must have heard, or you must have understood all these things. What is patent, what is trademark, and what is copyrights. So among these students, can you tell what is the difference between patent and copyrights? Anyone? Tell, what is this? Yeah.
That patent is developed by the human intelligence.
नहीं, सारी दोनों क्रिएटिविटी, आपकी कॉपीराइट की क्रिएटिविटी को, चलिए मैं दूसरी तरह से एग्जांपल देता हूं। आप कॉलेज जा रहे होते हैं, आपके साथ ही एक इंसिडेंस हुआ, मान लीजिए साइकिल से कोई गिरा, लेकिन आपके सारे दोस्त उसको जब उस नैरेशन को सुना रहे होते हैं तो आपको किसी एक खास दोस्त की पसंद आती है।
यस सर, यस सर, यस सर, यस सर।
हाँ, किसी खास दोस्त की पसंद आती है, यार वो सुबह साइकिल से गिर गया था, जरा सुनाना। एक वर्जन आता है, वो साइकिल लेके आ रहा था, गिर गया। दूसरा वर्जन आता है, बड़ी तेजी से आ रहा था, उसने वो देखा और फिसल गया।
यस सर।
काई थी। तीसरा आता है कि उसकी चेन उतर गई, फिसल गया। चौथा आता है कि उसकी पैडल टूट गई, फिसल गया। पांचवें वर्जन में आता है उसके दोनों पहिए अलग हो गए और गिर गया।
यस सर।
छठे वर्जन में आता है कि वो गिरा और उसकी मलहम पट्टी हुई और अस्पताल में पड़ा हुआ है। तो ये जो नैरेशन से हर बार जो इम्प्रूवमेंट्स हुआ, ये आपके दोस्तों के बीच की बातचीत की थी। लेकिन इसके लिए कभी पेमेंट भी मिलती है अच्छी नैरेशन सुनाने के लिए?
नो सर।
कपिल शर्मा का मिलता है।
हाँ, यस सर। they are working on a platform, that's why they getting.
अब यही चीज है, एक्सप्रेशन ऑफ द सेम इंसिडेंस। आप जब कमेंट्री क्रिकेट की सुन रहे होते हैं तो आप कहते हैं हर्षा भोगले आ गया, अच्छा लगेगा सुनने में, थोड़ा सा मंदिरा बेदी बोलने जा रही है, अच्छा लगेगा। नहीं तो पहले का तो ऐसे ही था कि ये बॉल आई और ये आउट। अभी वो कहते हैं थर्ड अंपायर का डिसीजन लेने तक हम देखते हैं छोटा सा ब्रेक, तो कमर्शियल भी चल रहा है।
यस सर।
तो कॉपीराइट में इंपॉर्टेंट है एक्सप्रेशन। सर कॉपीराइट में 3-4 चीजें एक साथ है। देखिए, आपके पेपर्स जो पब्लिश हुए, जो कि आपने पेपर्स के लिए आपने राइट साइन किया, उसमें 2 चीजें होती है। एक होता है आपका पहला मॉरल राइट, दूसरा होता है आपका वो इकोनॉमिक राइट्स। तो इकोनॉमिक राइट्स आप ट्रांसफर कर चुके होते हैं। एंड ये जो आपका जो नरेशन हुआ, जो मैंने फ्रेंड्स के बीच में बात बताई, इसमें क्या होता है कि आपको उसको बार बार कहते हैं रिपीट करने के लिए, तो ये रिपीट होता है। फिर कॉलेज के फंक्शंस होते हैं तो कोई अच्छा परफॉर्म होता है, उसी को दोबारा से ऑर्डर मिलते हैं। लेकिन यही कॉमर्शियल लेवल पे क्या होता है, परफॉर्मर्स को बार बार ऑर्डर्स आते हैं, वो अच्छे फीस चार्ज करते हैं। तो कॉपीराइट में डिफरेंट है ब्रॉडकास्टिंग राइट्स। अब कॉपीराइट एंड ट्रेडमार्क का एक छोटे 2 एग्जांपल और आपको बताता हूँ। विजय माल्या का नाम सुना है?
यस सर।
क्या केस था?
Sir, he was in Kingfisher company. He has taken much loans for our country and use our resources and fly back to the England.
तो उसने उसने क्रेडिट किसके लिए लिया था? ब्रांड के लिए, किंगफिशर ब्रांड के लिए उसने एज ए क्रेडिट गारंटी दी थी बैंक को और उसने लिया था। ये भी ट्रेडमार्क का ही केस है।
Yes, sir.
अब ललित मोदी का नाम बता दीजिए।
Yes, sir. He has also done some mischief for our country.
नहीं, बिल्कुल मिसचीफ नहीं था। यही कॉपीराइट का केस था। ब्रॉडकास्टिंग राइट्स उसने सोनी टीवी को दिया था।
Yes, sir.
ब्रॉडकास्टिंग राइट सोनी टीवी को दिया था आर्बिट्रेरी, अपने खुद के डिसीजन से। ESPN या फिर दूसरे चैनल को
Sir, but the government is not why filing a case against the Lalit Modi sir if
वही आर्बिट्रेरी था ना। प्रॉपर सबको चांस नहीं दिया। बिडिंग के लिए तीनों को चांस देना चाहिए था और भी चैनल्स को।
Yes, sir. Only the giving the special who
broadcasting rights.
Yes, sir.
Of IPL.
Yes, sir.
Again, it is an IP case.
Yes, sir.
अभी भी बाहर ही है।
Yes, sir.
तो कॉपीराइट दो तरह से मिक्स्ड बिजनेस टूल भी है, ट्रेडमार्क भी बिजनेस टूल है, पेटेंट कॉपीराइट दोनों ह्यूमन इंटेलेक्चुअल से ही आते हैं।
Now tell me what is the difference between discovery, invention and innovation. There are three keywords.
Yes, sir.
Discovery, invention and innovation. There is little bit difference between these three, among these three.
Sir, someone has discovered earlier.
Newton's law. What is this? Invention or discovery?
Sir, it is discovery. He discovered a theory, and after that, this theory, all the scientists had done research on it and may improve their generation to generation.
And what is innovation?
Sir, innovation means whenever an invention is done, new innovative ideas which is done from pre-existing invention, not used by the intellectual mind.
Certainly, I think invention is commercialized. Then after commercialization, it is called innovation of that particular invention.
Yes, sir.
Is it okay? So there is a bit difference between discovery and invention and innovations. In CSR logo, what is written?
CSR logo.
Innovation Engine of India.
Yes, sir. Invention.
What do you mean by Innovation Engine of India?
Sir, India is a country where so much of young talents are there. So the government is trying to produce much more new scientists to be a part of the engine. We are in 2047. Our Prime Minister Narendra Modi has given a very good thought that we will become a powerful nation. So
no. In our country, CSR has a maximum number of patents.
Yes, sir.
Among all the scientific organizations.
Yes, sir.
And in CSIR, there are 37 laboratories.
Yes, sir.
Under CSR umbrella. And CFTRS, Central Food Technological Research Institute at Mysore. 37 laboratories, CFTRS has maximum number of patents that they have filed. So it is related with the patents. Those which has a more number of patents, and that is why it is called Innovation Engine of India. That means you are going for invention and inventions, or always going for patenting. So can you tell who is the highest number of patents in the world? Who is having the names of highest number of patents?
Sir, I don't know.
Thomas Alva Edison, you must have heard.
Yes, sir. He developed the bulb.
He has more than 1,000 patents
in
his name. And out of these 1,000 patents, only bulb has
been successful, sir.
Rename his names like Thomas Edison.
Yes, sir.
So I mean to say, you always go on patenting, inventing. That is called Innovation Engine of India. Once upon a time, एक बार 3 बच्चे गए ताजमहल देखने. तीनों से पूछा गया कि आप बताइए क्या देखा. उन्होंने कहा सर ताजमहल आगरा में है. ठीक है. दूसरे ने पूछा आपने क्या देखा. सर आगरा में ताजमहल तो है, उसको शाहजहां ने बनवाया. तीसरे से पूछा आपने क्या देखा. सर वो आगरा में ताजमहल है, शाहजहां ने बनवाया, इसमें इतने मजदूर काम किए, ये संगमरमर का बना हुआ है, इतना इसी में ये हुआ. तो ये माइंड जो लास्ट वाला ने कहा वो इन्वेंटिव माइंड्स होना चाहिए, तभी जो है वो साइंटिफिक टेम्पर और साइंटिफिक इनोवेशन माइंड में हो सकता है. ठीक है, तो ऑलवेज you are knowing the three words see, look and observe. What is their meanings?
First you
सबका
see.
मतलब होता है देखना.
Yes sir.
See मतलब भी देखना, look मतलब भी देखना, observe मतलब भी
सर
देखना.
ऑब्जर्व मतलब होता है कि उस चीज को अपना माइंड में उस चीज के बारे में सोचना कि वो कैसे हुआ, क्यों बना.
ये सी मतलब हुआ कैजुअली देख लिया, चलो ठीक है कुछ हुआ, जो पहला बच्चा किया. लुक मतलब थोड़ा सा ध्यान दिया उसमें.
यस सर, यस सर.
यहाँ क्या था भाई, किसने क्या बनाया. और ऑब्जर्व मैंने ऑब्जर्वेंट, उसने देखा कि अरे कहाँ कहाँ वो सील पट लगा हुआ है, सबको पढ़ा, ताजमहल देखने गया तो वन शुड हैव ऑब्जर्वेंट माइंड, और तभी वो इन्वेंशन और ये कुछ नया चीज हो सकता है उसमें.
यस सर.
ठीक है, तो सी ऑलवेज डूइंग द वर्क एवरीवेयर यू गो, इन ट्रेन, प्लेन, इवन इन होम आल्सो. To you observe the things, what is going on, what process is going on, then only you can have this mind of inventing new things. Okay.
Yes.
Now thanks to all my speakers. Dr. Bindra Singh, he has nicely presented this what is called industrial property, IPR, its generation, protections. He has very nicely explained what is property. Property means land property, house property, and what is intellectual property. That tangible property and intangible property. Tangible property means house, home, bicycles, furnitures. These are tangible property. And other IPR is intangible property. So he has nicely presented property, industrial property, trademark, and copyrights. So thanks to our Virendra Singh Sahab. And the second, our best speaker is Dr. Sanjeev K. Majumdar. इन्होंने इतना बढ़िया से प्रैक्टिकल वे में बताया बच्चों को कि आखिर ये होता क्या है, इन्वेंशन क्या है, पेटेंट कैसे करते हैं, क्या उसमें क्या क्या कमी है, कैसे उसका करने के लिए क्या प्रोसेस है, और सबका इन्होंने एग्जाम्पल दिया अच्छे ढंग से. तो ये इनका जो बनाने का बताने का ढंग था वो बड़ा बढ़िया लगा सभी लोगों को. एंड बड़ा इंटरेक्टिव सेक्शन रहा इनके सेशन में, बच्चों ने काफी इसमें पार्टिसिपेट किया. तो थैंक्स टू हमारे संजीव कुमार मजुमदार साहब आल्सो. Now over to.
Thank you, sir. Now it's time for to felicitate the speaker. I would request the chair, Dr. S.K. Kashyap, sir, to felicitate the speaker. First, felicitate to Dr. Virendra Singh. Thank you, sir. Now, Dr. Sanjeev K. Majumdar. Thank you very much, sir.
So thank you, all of you. Now we have come to our concluding session. Actually, we have planned in this way that we should take some questions what the various speakers, our speakers delivered throughout the day. So first I would like to ask if there is any doubt, you can ask, you can clarify regarding the patent filing, patent strategies, filing strategies, then the patent informatics homeworks, then again copyright, trademarks, and value addition, that is commercializations. So actually these are the steps in IPRs from generation, creation to protection and commercializations. So is there any questions to our speakers? Yes, please, please.
Sir, if I filed a patent and my patent was successful and I commercialize the patent into the product and sell it to the company, if the company is not giving me the economic benefits which are written in the declaration or the agreement, what will I do?
Sir, please. Actually, one mic will be there to our speakers, please.
सिंपल सी बात है, आपका हक आपको नहीं मिला। सिंपल सी बात है, आप अपने भाई से कैसे झगड़ा करते हैं? आधी जमीन मेरी यहां से है। कोई बात नहीं, एंसेस्ट्रल प्रॉपर्टी कहीं पर होगी। तो सिंपली क्या होता है कि आपके राइट्स आपको नहीं मिले, आपने पेटेंट फाइल किया, कॉमर्शलाइज किया, आपको नहीं मिला। ये आपका असंतोष इस बात का नहीं। आप जो चाहते थे बात वो नहीं है जो सर्विस रूल्स में है। अगर सर्विस रूल्स में लिखा है कि आपकी टेक्नोलॉजी कॉमर्शलाइज होगी और आपको सिर्फ 3% मिलेगा तो 3% ही मिलेगा। अगर सर्विस रूल कहता है आपको 85% मिलेगा तो आपको 85% मिलेगा। हर इंस्टीट्यूशन में, हर जगह पे रूल्स में इसको डिफाइन किया हुआ है। आप जहां पे, मैंने आपसे एक क्वेश्चन पूछा था ना, सबसे टूथपेस्ट के बाद पूछा था कि आप अपना नौकरी कहाँ ढूंढना चाहते हैं। तो जो आप ऑर्गेनाइजेशन पहला ढूंढते हैं ना, सोचते हैं पहला जो ड्रीम जॉब होता है, उसमें ये भी कंडीशंस होती है 9 to 5 वर्किंग, गुड सैलरी एंड गुड एम्प्लॉय एम्प्लॉयर एग्रीमेंट। वो भी सोच करके आपका ड्रीम जॉब आप सोचते हैं। तो उस हिसाब से कोई भी ऐसा नहीं कर सकता, आपको आपके राइट्स बराबर मिलेंगे। और उसके बाद अगर नहीं होता है तो कोर्ट में देख लेंगे। भरोसा रखिए कोर्ट पे।
Next. Any questions?
I saw the enthusiasm in the students. I didn't expect so much of knowledge you are bringing, so much of interest in IPs. In fact, my question on behalf of you to the panel, the question which you raised in the morning, that so much of creative ideas thinking there. It's not just only CSR lab can do research and file patents, or maybe one of you, a few very recognized universities can do it. It's across. It's across in communities. Go to villages, rural areas. People are coming with bubbling with ideas. What is not there is that how to take those ideas to next level. Give a shape to those ideas, develop some new process or product, and then commercialize. The whole ecosystem is not, I'll say, there, so that those ideas are nurtured. So my question now, maybe Kishore sir, you can throw some lights. How we can encourage, because the whole purpose of today's program is awareness. How we can take this IP know-how knowledge across. So how we can do that on? What is your suggestion? What is your ideas that we can play a role? SIMPAR can play a role to help nearby institutes, communities and all. But what should be the good mechanism to develop that ecosystem? I mean, any of you can throw some lights on this.
I don't know if others can correct me if I'm wrong. Maybe first we will have to find out if I understand your question properly, you're saying that somebody who doesn't know कि किसके पास आना है, and they, yeah.
Get these ideas and incubate those ideas.
Yeah.
Then take it to the next step.
Yeah, but I think if they know it, then there are facilitators available also. But they will have to come to that right person, and wahan pe aaye to I think then that channel can be established of doing the full process for them, or else it is going to be difficult for us to go and take the initiative. But I think because CSR is there, at least if they come to some organization like that, from wahan se I think we can start the guiding. I don't know.
Okay, मैं कंटिन्यू करता हूँ. If such kind of queries, if you are receiving, आपके पास आते हैं लोग कि मैं एक as a individual inventor,
Please, students, please.
एज ए इंडिविजुअल इन्वेंटर, एज ए इंडिविजुअल कैपेसिटी में भी कोई सपोर्ट आपसे चाहता है, देयर आर इंस्टीट्यूशंस, डिफरेंट इंस्टीट्यूशंस, दोज हु आर वर्किंग टू फैसिलिटेट, इवन फ्रॉम द CSIR, it was earlier a scheme was there into that. In the IPU, others patents are being filed right now. I'm also from the CSIR family. So in NRDC, there is a scheme for the individual inventors, for the grassroots also, and for the startups. It is completely the patent support can be done, incubation support also can be done from our side, and funding also can be done. And here those यहाँ पे जो धनबाद में हैं, आपके पास मैंने एक बार सौभाग्य प्राप्त हुआ था, झारखंड सरकार की भी बहुत अच्छी IP पॉलिसी है. MSME डिपार्टमेंट एंड DST दोनों ही देखती है, झारखंड DST एंड झारखंड MSME, दे रीइंबर्स द कॉस्ट. आपके पेटेंट फाइलिंग की कॉस्ट रिम्बर्स करती है. आपने अटॉर्नी हायर किया, पेटेंट फाइल किया, आपको कॉस्ट रिम्बर्स होती है. एंड शायद इंक्यूबेशन सेंटर पॉलिसी भी आने वाली है. एंड MSME डिपार्टमेंट दैट टेक्स केयर ऑफ ऑल सच काइंड ऑफ सपोर्ट. Even IPFCs are there. We are also running on IPFC at Vizag. That is for that purpose. And even if you are coming for a query that कि मेरे पास क्या चाहिए, तो we have a TISC, WIPO TISC is there. So if CSIR Simper is planning like that, कि some technological information support center is required, so WIPO supports for that. That brand can be given here, and like कस्टमर रिलेशंस आपने बनाया हुआ है, उस तरह से आप जो है कि टेक्नोलॉजिकल इंफॉर्मेशन सर्विस सेंटर आप एस्टैब्लिश कर सकते हैं यहाँ पर भी. एंड फॉर द IP सपोर्ट, IPFC also you can establish here. So TIFAC support for the institutionals only. हाँ, for the universities and the research institutes, that is their restriction is there. And beyond that, ours is additional to that. For the institutes and R&D we support. Apart from that, individuals and the grassroots also we support. And जब हमारे प्रधानमंत्री जी ने बोला था कि जो स्टार्टअप्स हैं, स्टार्टअप्स को पेटेंट फाइल करने के लिए सपोर्ट देने के लिए गवर्नमेंट एजेंसीज को अप्रोच कर सकती है. 600 अटॉर्नीज का एक पैनल भी उन्होंने पब्लिश किया हुआ है वेबसाइट पे, जहां पे कि कॉस्ट नहीं देनी होती है. उसमें से किसी की भी सर्विसेज आप ले सकते हैं. यहाँ धनबाद में अगर कोई है तो आप उनको आइडेंटिफाई करके लिस्ट कर लीजिए अपनी तरफ से फैसिलिटेटर इनटू दैट, कि जिनको भी पेटेंट फाइल करना है एज ए स्टार्टअप, दे हैव टू अप्रोच देम. दे विल फाइल योर पेटेंट एप्लीकेशन टू द पेटेंट ऑफिस एंड दे विल चार्ज ओनली फॉर द गवर्नमेंट फीस 1,600 and additionally that 4,000 rupees. इन दोनों के अलावा कोई उनको चार्ज नहीं करना है आपको फीस. दे आर barred to charge any fees. उनको 10,000 रुपए फाइलिंग करने पे रिम्बर्स हो जाती है, और जब वो ग्रांट हो जाता है तो फिर 15,000 रुपए उनको रिम्बर्स होता है पेटेंट ऑफिस की तरफ से. पेटेंट ऑफिस बॉम्बे कंट्रोल करता है. लाइकवाइज दैट पेटेंट नॉट ओनली फॉर पेटेंट, ट्रेडमार्क एंड डिजाइन के लिए भी सपोर्ट स्कीम है. आपके स्टार्टअप के लिए जब वो रजिस्ट्रेशन करेंगे तो उसके लिए सपोर्ट स्कीम है. वैलिड रिक्वायरमेंट इज दैट कि योर कंपनी इज हैविंग ए कंपनी रजिस्ट्रेशन एंड द DIPP रजिस्ट्रेशन नंबर ऑल्सो विथ यू. वो रिक्वायरमेंट है, उसके साथ ही वो फाइल कर सकते हैं. अगर वो अदर चार्जेस आपसे डिमांड करते हैं तो आप पेटेंट ऑफिस को कंप्लेन कर सकते हैं. एंड काफी स्ट्रिंजेंट है. पेटेंट एजेंट की पेटेंट एजेंसी नंबर भी कैंसिल हो सकती है अगर उन्हें मिसगाइड किया या चार्ज ज्यादा लिया तो स्कीम्स हैं डिफरेंट स्कीम्स की कमी नहीं.
एक चीज मैं यहाँ पे ऐड करना चाहूंगा कि हर एक इंस्टीट्यूट को एक थोड़ा सा सेल्फ सस्टेन, यानी कि क्या कहते हैं कि डोर स्टेप पे होना चाहिए स्टूडेंट्स के. उसके लिए एक IP सेल जरूर होना चाहिए, जहाँ पे कि स्टूडेंट्स वॉक इन करे और उनके क्वेश्चंस का आंसर तुरंत मिल जाए. तो एक IP सेल जरूर होना चाहिए. वहाँ पे कोई टीचर या प्रोफेसर जो एक IP अच्छा जानता हो वो जरूर होना चाहिए. तो एक
Yeah, so you can go back to your institute and ask for a support cell, IP cell kind of thing, which could be the single point of contact. So you can give your ideas to your IP cell, and through that they can connect whether NRDC or CSL laboratories or any other. There are multiple opportunities there to get help. I think that could be one opportunity. Yeah. So thank you very much for this. Yeah.
So thank you, sir. Just I would like to ask as a final concluding question, I think, to our honorable speakers, is that value addition is the ultimate word in case of IPR. So basically, for a public funded organizations like CSR, SIMFAR, what should be the strategy in IP? Not to only to increase the number, but also to increase the quality.
Specifically to answer, sir, to your question, although sir has broadly mentioned the strategy in the morning. So what I would say is, whatever you all have filed so far, we can try to analyze what are your patents filed in the last 10 or 20 years. 20 years maybe we can take, because wo wale patents abhi it would be live till now. So we can first start with analyzing those patents to see that what are your core technologies and what are its applications. And then going forward, then we will have to interact with the scientists, like whether they are standalone patents or whether they are related patents in a specific area. So pehla wo mapping kiya, to we'll get an idea what is your existing portfolio, and then depending on what are the areas where the scientists are active right now, we can try to suggest how those patents can be developed further as a follow-on developments or taken ahead for products. If they are standalone, we'll have to say, Jaise sir ne subah, he had shown these are the core technologies, then whether they have been taken ahead for making the compositions and products or not. So doing that mapping for what is existing, I think you should start from that rather, and then only we can say what, based on the new areas, what should be the strategy. So I think it's a little bit correct.
And there are ample opportunities, sir. Very specific to सिम्फर. हम सभी सिम्फर के साइंटिस्ट अगर हम ये सोचे, अगर ये काम को हम नहीं करेंगे तो कौन करेगा? आपके पास आंसर नहीं है. आपके अलावा दूसरा कोई नहीं करता. Am I right? आपके अलावा दूसरा कोई नहीं करता. तो स्ट्रांगली हमारे पास अपर हैंड है. ये इस काम को करने की जिम्मेवारी हमारे पास ही है. तो हमारे पास जितने पेटेंट्स हैं, हमारी जो एक्टिविटीज है, हमारी एक्टिविटीज जो हमारे रिसर्च है, हमारे जो सर्विसेज हैं, हम उनको एक प्रॉपर पैकेजिंग करें, रीब्रांड करें अपने आप को, तो वो सर्विस सेक्टर में अभी जो की रादर देन प्रोडक्ट जो चाहिए होता है, हम सर्विसेज को एज ए प्रोडक्ट दे सकें अगर, तो अभी हम बहुत ही एम्पल अपॉर्चुनिटीज हैं हमारे पास. सर्विसेज एट पार ऑफ द इंडस्ट्री, जो इंडस्ट्री को चाहिए, जो दूसरे कंसल्टेंट से ढूंढते हैं, वो कहीं से कुछ जोड़ करके दे देते हैं, लेकिन उनके पास वो रिसोर्स नहीं है. आइदर इन इंडिविजुअल कैपेसिटी द कंसल्टेंट इज प्रोवाइडिंग टू द इंडस्ट्री, लेकिन हमारे पास क्या है, एक संगठन है पूरा. नॉट ओनली सिम्फर, इट्स 37 लैब्स फैमिली. आप सिम्फर से सपोर्ट सर्विस देते हैं, लेकिन आपके साथ ओडिप भी है, आपके साथ आईपीयू भी है. तो वो स्ट्रॉन्ग होल्ड रख करके डिलीवरी क्या क्या देनी है, इंडस्ट्री की क्या रिक्वायरमेंट है, कंप्लीट मार्केट रिसर्च के साथ रीलॉन्च कीजिए. आप नंबर 1 है. आप नंबर 1 है, एंड देयर इज नो ऑप्शन.
थैंक यू सर. थैंक यू.
ये जो लगता है वो ये कि हमें पेटेंट फाइल करने तक नहीं रुकना चाहिए. पेटेंट के आगे बढ़ो. पेटेंट जैसे ही फाइल हो जाता है उसको प्रोडक्ट डेवलपमेंट फेज में घुसना पड़ेगा. ये नहीं कि आपने पेटेंट फाइल किया और फिर कोई और प्रोडक्ट डेवलपमेंट में चला जाएगा। ऐसे नहीं होगा, आपको बिजनेस डेवलपमेंट ग्रुप के साथ मिलजुल के काम करना पड़ेगा। और एक इंस्टीट्यूट को भी उसमें इनिशिएटिव लेके उसको इन्वेंटर को ड्यू क्रेडिट्स देते हुए आगे लेके जाना पड़ेगा। ये नहीं कि इंस्टीट्यूट भी ये सोचे कि ये आदमी सिर्फ एक ही पेटेंट में लगा हुआ है तो उसको क्या कहते हैं प्रमोशंस में प्रॉब्लम हो, क्योंकि वो एक ही प्रोडक्ट पे काम कर रहा है, पर वो उसको फिनिशिंग कर रहा है, उसमें बहुत मेहनत करनी पड़ती है। एक पेटेंट को यानी कि एक इन्वेंशन को एक इनोवेशन में लेके जाने में बहुत मेहनत लगती है। तो इट इज अ टायरसम जॉब एंड इट शुड बी रिस्पेक्टेड।
Thank you, sir. You have a question. Just last question.
सर मेरे पास एक छोटा सा क्वेश्चन है सर, वीरेंद्र सिंह सर से। सर मान लीजिए सर मैंने एक कविता लिखा और मैंने लिखा भी है सर। सर तो इसके रिगार्डिंग सर मैंने कॉपीराइट उस पर करवाया, लेकिन सर इन फ्यूचर उस कविता को मैं और एक्सटेंड करा, उस कविता में मैंने कुछ और लाइंस जोड़ी, तो सर उसके रिगार्डिंग मुझे क्या करना होगा?
जो भी आपने न्यू एडिशन किया है, that is your new work and you have to again copyright. जी, again copyright. जी, when you have changed your contents, and definitely you have to again copyright. नहीं, you are changing your content. You are adding, you are editing, and when you are editing your contents, then you have to file the copyrights. वो तो कॉपीराइट है ही आपका ऑलरेडी, लेकिन जब आपने एडिट कर दिया है उसमें तो वो भी कॉपीराइट करना पड़ेगा आपको। तो कंपोजर रूप में तो आप लिख ही रहे हैं ना, यानी क्या उसको आप एडिटिंग कर रहे हैं ना। पहले आपका कंटेंट एक था, अब उसके साथ अपने आपने एडिट किया, आपने नया कंटेंट बन गया, तो वो भी तो आपका कॉपीराइटेबल है। नहीं, उसका कॉपीराइट तो आपको ऑलरेडी हो चुका है, इसका कॉपीराइट अब होगा। राइटर सेम है, बट ही इज एडिटिंग ना। जी चलेगा, लेकिन ही इज एडिटिंग, ही विल मेंशन दैट आई हैव ऑलरेडी पब्लिश्ड, आई एम सब्सिक्वेंट पब्लिशिंग दिस। सो जी सब्सिक्वेंट, जी 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 सब्सिक्वेंट पब्लिकेशंस। कॉलम 10 में लिखते हैं सब्सिक्वेंट पब्लिश्ड एंड अनपब्लिश्ड, यू मेंशन दैट आई हैव पब्लिश्ड ऑलरेडी दिस कंटेंट। जी एनी मार्क्स में भी लिखते हैं। जी जी सेम चीज है, होता आप सिर्फ चीज चेंज कर रहे हैं, आप पोइम कर रहे हैं, आप कहानी लिख रहे हैं, आप यू आर ऑथर ना, यू आर क्रिएटिंग सम वर्क। जी आप कंफ्यूज मत होइए जी 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 जी
कहाँ जाऊँ? मैंने कहानियां लिखी।
ऐड कर दूं मैं? जी देखिए, कहानियां लिखी या फिर आपने कविता लिखी, कॉपीराइट डिफरेंट तरह से लॉ है। कॉपीराइट में आप जो किताबें खरीदते हैं, नॉवेल खरीदते हैं, तो वहां पे पब्लिशर के साथ आपका एक एग्रीमेंट होता है। आपकी जितनी किताबें बिकती हैं आपको रॉयल्टी उसकी आती है, पर कॉपी रॉयल्टी आती रहती है। बुक्स लिखने में पोएम की बुक आती है, एब्रिज कंपाइलेशन जो भी कंपाइलेशंस होती हैं, एंड जितनी बार भी आप नई कविता लिखते हैं उतना आपका नया बनता है। आप किसी की दूसरी की कविताओं का ट्रांसलेशन भी करते हैं, वो भी आपका एक नया काम होता है। आपके काम को दूसरा कोई और ट्रांसलेशन करता है, वो भी एक नया काम होता है। अब सिंपली एक्सप्रेशन, इसमें हम कहते हैं कि किसका हो रहा है कॉपीराइट, एक्सप्रेशन का, एक्सप्रेशन का। रिक्वायरमेंट पेटेंट ट्रेडमार्क एंड डिजाइन में थोड़ा सा डिफरेंस है। पेटेंट एंड डिजाइन में हम कहते हैं नॉवेल्टी चाहिए, ट्रेडमार्क में हम कहते हैं फर्स्ट यूज चाहिए, पहले से पब्लिश हो चुका होता है। कॉपीराइट में भी आपका जो है कि पहले से आप यूज कर रहे हैं, लेकिन यहाँ पे एक्सप्रेशन नया होना चाहिए। जैसे कि सिंपली मैंने बोला, वही एक चुटकुला जो हम सुनते होते हैं, वही चुटकुला कपिल शर्मा से आप सुन रहे होते हैं, आप उसके देखने के बीच में ऐड भी देख रहे होते हैं। तो इस तरह से कमेंटेटर्स, परफॉर्मर्स, इनके उनको जो वैल्यू मिलती है, न्यूज चैनल आप भी चैनल चेंज कर रहे होते हैं ना, जब आपको फेवरेट एंकर का न्यूज चैनल मिल जाता है आप रुक जाते हैं, देखते हैं क्यों? क्योंकि उसका एक्सप्रेस करने का तरीका अलग है। न्यूज तो वही उठी, दिल्ली में बाढ़ आई, लेकिन आप देख रहे, अब ये आ गया अंजना ओम कश्यप का, मैं देखता हूँ कैसे बताती है, उसको जो वैल्यू मिल रही है उसके एक्सप्रेशंस के बेसिस पे ही मिल रही है, उसका ही कॉपीराइट है उसके पास। तो एक्सप्रेशंस के लिए कॉपीराइट होता है, ना कि जो है कि एक काम का बाद में नया वर्जन आया। अब इस कॉपीराइट के कंटिन्यूएशन में जैसे कि देखें ग्रोथ, जो भी एप्स आपके होते हैं ना उसके वर्जन आते हैं 2.0, 2.3, 2.4, हर बार उसका जो है कि वो सॉफ्टवेयर का कॉपीराइट लेते हैं। अपडेट आता है, अपडेट के लिए अपडेट भी होता है और उसका कॉपीराइट रजिस्ट्रेशन भी करते हैं। एक और मजेदार बात है, मतलब कि सभी रजिस्ट्रेशन की बातें हो रही थी, बर्न कन्वेंशन में रिक्वायर्ड नहीं है कि आपको कॉपीराइट रजिस्ट्रेशन करने जाना पड़ेगा, ऑटोमेटिक राइट। धन्यवाद था। जिस दिन आपने उसको फ्रीज कर दिया, आपने लेटर में लिखा, ईमेल में लिखा, एसएमएस कर दिया, व्हाट्सएप कर दिया, उस दिन से आपने अगर प्रूफ कर सकते हैं, कहीं अगर केस होता है कि मैंने इस दिन इसको लिख करके छाप दिया था। बट हाँ, यस, फ्रॉम दिस डेट। एक लॉ के प्रोफेसर इसका एग्जांपल दिया करते थे कि आपने ओपन पोस्ट कार्ड में पोएम लिखी और उसको पोस्ट कर दिया अपने आप को, उस पे डेट की स्टैंप लग गई, तो फ्रॉम दिस डेट दैट डेट यू हैव ए कॉपीराइट। तो सिंपल सा बर्न कन्वेंशन में प्रोटेक्शन दी हुई, क्योंकि ऑथर्स जो है कि क्रिएटर्स का काफी लार्ज है ये, तो इसमें जो है कि प्रोटेक्शन दी गई है और बहुत मैंडेटरी भी नहीं किया गया है, क्योंकि परफॉर्मर्स, आर्टिस्ट, सभी लोग जो है कि बार बार रजिस्ट्री के लिए नहीं जा सकते। मोस्टली जिनके इकोनॉमिक राइट्स हैं, बुक्स राइटर्स एंड सॉफ्टवेयर राइटर्स एंड सिनेमेटोग्राफ फिल्म से, ये लोग ज्यादातर अपने फिल्मों के लिए जाते हैं। एंड कॉपीराइट कभी कभी एक ही फिल्म के जो है कि अलग अलग वर्जन आते हैं।
लास्ट मंथ कोई लेडीज थी कलकत्ता में, तो व्हेन आई वाज इन दिल्ली शी मेट मी, शी टोल्ड मी, सर आई रोट ए बुक and I got a copyright. Then I edited my book. Someone in foreign country made a film on my contents which were mentioned in my book. So how I will prove? Then my answer was that if you have registered certificate, if you have your work with you, then you will prove that I have got the registration earlier and they have copied the contents from my book, and definitely. तो ऐसा कई बार होता है कि even you have literary content, you have got the copyright, but someone makes a film on that contents. And if you have proof, if you can prove that yeah, I have the copyrighted material, I created this work in first of all, then you have right in that work. But as I have said, copyright is not compulsory. Copyright is automatic right. Registration give only some help that yes, you have copyright in this work.
Thank you, sir. So I think we will conclude here. Actually, we are very happy that our speakers have ignited the young minds. We know that you have endless questions. Okay, sir.
सर एक आपकी तरफ से एक क्वेश्चन पूछना चाहता हूँ। सर मैंने एक पेटेंट किया, मान लीजिए, उसके बाद फाइल हुआ, उसके बाद उसको मैं प्रोडक्ट में लेके गया, प्रोडक्ट डेवलप हुआ मान लीजिए, और उस प्रोडक्ट को हम इंडिया में यूज कर रहे हैं। सो इज इट पॉसिबल कि वो अच्छा प्रोडक्ट हो और मैं उसको विदेश में भी उसको ये कर सकते हैं, यूज के लिए भेज सकते हैं?
सर प्रोडक्ट्स देखिए बिना इंटरनेशनल पेटेंट के जाना जो है कि सेफ नहीं है। आप हो सकता है आपको जब उसकी स्टडी के लिए जो मैडम ने अभी आपको पूरा आपको पेटेंट सर्च की जो स्टडीज बताई थी, हम कहते हैं कि आपके पास एज ए साइंटिस्ट और एज ए बिजनेसमैन जब आपके पास प्रोडक्ट तैयार कर रहे होते हैं तो आपके ऑब्जेक्टिव दो होने चाहिए। क्या मैं इसको पेटेंट कराऊं, और अगर पेटेंट नहीं करा सकता हूं तो क्या मैं इसे बेच सकता हूं। दो काम के लिए हम पेटेंट एक्सपर्ट के पास जाते हैं। पहला काम पेटेंटेबिलिटी असेसमेंट, दूसरा काम हम चाहते हैं कि क्या मैं इसको बेच सकता हूं। आपके पास पेटेंट है, आप इंडिया में बेच रहे हैं, आपने फॉरेन में पेटेंट नहीं फाइल किया है। अब आप जिस कंट्री में बेचना चाहते हैं वहां पर आप अपने लिए अपॉर्चुनिटी ढूंढेंगे। क्या इस प्रोडक्ट से रिलेटेड पेटेंट वहां अवेलेबल है, क्या किसी ने फाइल किया हुआ है, अगर फाइल किया हुआ है तो उसकी टाइम क्या थी, अगर वो फाइल है भी तो क्या वो कहीं मेंटेन करना भूल गया या मेंटेन कर रहा है। तो ये सारी सेफ्टी लेकर के आप उस मार्केट में एंट्री कर सकते हैं। बट लेकिन हम सजेस्ट यही करते हैं कि सेफ्टी एंड प्रिकॉशंस के साथ ही करें, जिस तरह से घर से निकलने से पहले आप ड्राइविंग लाइसेंस जेब में रख लेते हैं।
कंट्री में है या नहीं. If it is not there, you can still manufacture and sell in that country if there is a market in that country, of course. And but if there is any other patent protecting your product or the features of your product, then you cannot manufacture and sell it in that country, although if there is a market in that.
इन्फ्रिंजमेंट सूट्स के चांसेस होंगे उसमें कि नहीं, आपके पास तैयारी का टाइम, आपके पास तैयारी नहीं है ना। पहली चीज है आपके पेटेंट जो आपने फाइल किया मार्केट में लॉन्च कर रहे हैं, आपको कितने साल हो गए इसमें, सबसे पहला ये क्वेश्चन है। जैसे कि हमारा प्रोडक्ट आपने पेटेंट फाइल किया और हमने प्रोडक्ट जो है कि दूसरे दिन लॉन्च कर दिया। अभी रिसेंटली ऐसा हुआ था, मैंने हैदराबाद में एक जो है कि योगेश जी को बता रहा था कि हमने वाटर फ्रॉम एटमॉस्फेयर, एटमॉस्फेरिक वाटर को कंप्रेस करके हम वाटर बना रहे थे। काफी अच्छा पेटेंट है, आईआईसीटी की पेटेंट एप्लीकेशंस हमने फाइल किया। नेक्स्ट डे हमें उसे पब्लिश करना था, डेमोस्ट्रेशन देना था, तो हमने रात में उसको फाइल किया। उस पेटेंट को फाइल करने के बाद उनके पास अपॉर्चुनिटी थी कि वो दूसरी कंट्रीज में भी उस मशीन को एक्सपोर्ट करना चाहते थे। तो उसी साल विद इन 3 months वी डिसाइडेड दैट वी हैव टू फाइल ए पीसीटी एप्लीकेशंस स्ट्रेटेजिकली। वी फाइल्ड ए पीसीटी एंड देन बाय एंड ऑफ, जो योगेश जी ने आपको टाइमलाइंस बताए थे, 2.5 साल के अंदर हमने कुछ कंट्रीज में यूएस, ईपी एंड अफ्रीकन रीजन में हमने उसका रीजनल पेटेंट एप्लीकेशन फाइल किया है। बिकॉज द मैन्युफैक्चरर इज फ्रॉम हैदराबाद एंड उनके अफ्रीका में बिजनेस है, उस मशीन को बनाते हैं, गूगल को भी दिया है, फेसबुक को भी दिया है, एंड नाउ दे आर एक्सपोर्टिंग दैट मशीन टू कीनिया ऑल्सो। तो कीनिया में एक्सपोर्ट करने से पहले उन्होंने पेटेंट वहां पे प्रोटेक्शन लिया हुआ है। तो ये स्ट्रेटेजिक टाइमलाइन है, 12 मंथ्स के अंदर आपको डिसाइड करना होता है। अगर 12 मंथ्स निकल चुके हैं तो जो मैंने श्रुति को बताया था, पेटेंट पे इंप्रूवमेंट कीजिए, नया पेटेंट फाइल कीजिए, उसकी पीसीटी फाइल कीजिए और फिर मार्केट में एंट्री कीजिए। जो स्टैंडर्ड्स नॉर्म्स हैं उसके विद इन हम करते हैं काम को। उस कंट्री की जो रिक्वायरमेंट है इस कंट्री से अलग होगी, हमारी कंट्री से अलग होगी, उसको भी अपने रेगुलेटरी अप्रूवल्स लेने होंगे, सब कुछ जानना होगा। उस हिसाब से अपने प्रोडक्ट को मॉडिफाई कीजिए, उस कंट्री के लिए डिलीवर कीजिए। आपका टारगेट होना चाहिए कि यस अपॉर्चुनिटी इज देयर फॉर दैट मशीन, तो आई हैव डेवलप्ड दैट मशीन काइंड लाइक दैट, तो न्यू पेटेंट हैज बीन फाइल्ड, न्यू एप्लीकेशन इनटू दैट कंट्री आल्सो। तो कंप्लीट स्ट्रेटजी डिजाइन करनी होगी, सुजन जी हैं, बनाएंगे आपके लिए पूरी पॉलिसी कैसे करना है। आपको वो प्रोडक्ट लेके जाएंगे, आप हमें बता दीजिए, हम करेंगे, उस कंट्री में ले जाएंगे। और उसकी एफटीओ स्टडीज करनी है तो मैडम है, तो वी आर टीम, नो प्रॉब्लम, फैमिली।
Thank you, ma'am. So what we started at 10 o'clock today, I think after 8 hours also we are having same queries, same excitement to ask the questions. So really we are very happy that throughout the day we are very interactive. You have a lot of questions, you have a lot of you got the clarifications, and please keep in our touch. For your any clarifications, you can always contact us, contact me, and I can pass your questions to our speakers, to our resource persons. So always your queries will be taken care of. So with this, once again, I would like to thank all of you for your kind support to make it a grand success. And Last but not the least, we will take a group photo. So please, all are welcome for a group photo. Sir, please come on the dais, sir.